Give me coffee in the morning, gotta have the coffee. Wake me up, shake me up, dip me like a pussy. One sip, two sips, and I'm feeling so alive. Coffee in the morning, it's the best way to survive. Woke up in the morning, sleepy eyes yawning. Jumped out of bed, started the day, opened the curtains. Felt the cool breeze, the sun shining on my face. But something was missing, I needed my job to chase. Give me coffee in the morning, give me coffee in the morning, gotta have the coffee. Wake me up, shake me up, dip me like a pussy. One sip, two sips, and I'm feeling so alive.
Good morning. Is it morning? Is it another day? I'm not even sure. Good morning, guys. Welcome in. For everybody just waking up and getting in here, I'm doing the same. Hang on. I'm checking a message, guys. Hold on 1 second. Okay. Welcome in, Walter Waller. It's been a minute. Thank you for coming in. Good morning, Dolphin. I was just checking my messages over here at the Discord, what you girls was up to this morning. Good morning. So yeah, I looked down at the clock and was like, oh, it's time to go live. It's too early today for some reason. I fell asleep yesterday after my live and after dinner. I was so tired and didn't know if I was coming or going and all that good stuff. So I go to sleep. About 11:30, my phone starts to ring and I'm waking up going, oh my God, what time is it? Nobody ever calls me late at night unless something's wrong, right? And my kid driving his daddy's truck and it's running hot. I'm like, boy, it's 11:30 at night. So I was up to about 1 o'clock till he got home safely. Walter's been up long enough for a whole pot of coffee. I'm on my second cup. I almost didn't make it. I was like, man, I got up a little later than usual this morning, so it's all good. Dolphin, you've been up all night as usual. You're going to get your rest on today. Some of these boring witnesses don't put you to sleep. So I'm interested to see if Julie Nagel, when they're going to bring her in to testify, because I did go review her old testimony, just a little bit of it. And I was like, oh, it's going to be interesting to see what she's got to say. Almost 1 mountain time. Are you on mountain time over there, Walter? Is that what MST is, y'all? I'm from the South. I get my letters all confused. It rained there all night, Dolphin. We had some rain here last night, but not a lot. But I was sitting here when my kid was, trying to get home safely, and I put on my new headset because I'm having a mic issue, which I got to get with you today about that later. But anyway, I'm sitting here with the headphones on, and I hear this horrendous noise that didn't come from my headphones. And I'm like, someone just crashed on the highway out there. Or it was a big shotgun blast. I'm not sure. Take my headphones off, and I'm sitting here going, what in the world? It was thunder. Yeah, it only lasted for like a little bit and it was gone. You're in Arizona, Walter. Oh, that's okay. You're over there with Joe. Y'all over there in funky land with the weird time zones. Still raining there, Dolphin. It's all gray and icky here this morning. A little humid out there. I was like, oh boy, Florida. I can't complain though. I won't complain in the summer. I'll just complain during the winter. I know how to get in the air conditioner. My son said it was supposed to start raining and rain. He said for like a week. I'm like, dude, you're always exaggerating, but okay. I didn't check. I didn't care if it's going to rain or not. It's not going to really affect me. I don't have no plans to go anywhere. Good morning, Joy. Welcome in. Y'all, today is my oldest son's birthday, though. And I had to ask him this morning how old he was. And he laughed at me. I'm like, look, little boy, you caused me enough problems 34 years ago. Settle down now. Settle down. Act right. Okay, guys, I just pulled up the. Let me turn that sound down. They are showing the outside of the courtroom this morning. So we've had some interesting testimony up until now. We'll see what happens today when they get in here. I got some lunchtime stuff to talk about that doesn't pertain to this case because my true crime brain gets bored and I got to go look at other stuff. But a couple of developments have happened and a couple of little things I want to talk about. And I also went down a well, I did start the live a minute late because I was accidentally stumbled into a rabbit hole with my morning coffee. You know how those things go. You fall in and you're like, oh, it's time to come out. But I was reading into some of the Sandra Birchmore files. Yeah. Some interesting stuff going on over there. Officer Lank. Yeah. Interesting. Do I have company? Do I have company? Oh my gosh. Good morning, Firefly. Welcome
Hey,
in.
morning.
How are you this morning?
I'm good. How are you? Happy birthday to your son.
Well, thank you. Thank you. Yeah, today's his birthday. Gosh, 34 years ago, they're like, ma'am, you're about to have a baby. I'm like, oh, no, I'm not. It's 3 months early. And here we are, 34 years later. So I always think about that on his birthday, what I was told the night he was born compared to where we actually are today. Very different situations than what they told me was going to happen. So I'm very, very thankful and grateful that none of the things they told me was going to be my son is my son. You know what I mean? We fought a long battle, 3 years to get him off all his equipment and all his little tubes and stuff, but it was well worth it. He's a good boy.
Well, that's good.
Yeah. My little preemie, my little 3 month early baby. I'll never forget that day. They're like, ma'am, you're in labor. I'm like, no, I'm not. Can't be. I've already had 2 of these. I know what it feels like. Now, my back sure is hurting. My cousin warned me about that, and I didn't believe her.
Well, how many weeks early were you?
I was at the first week of my 7th month.
Okay.
Yeah, he was pretty early. His little lungs had not even began to open and develop because that's the last stage in that last trimester.
Mm-hmm.
And I had him at the beginning of the 3rd trimester. So his lungs hadn't even tried to open yet. So surfactant, here we come. Thank you, little lab rats. But surfactant forced the lungs open. Little lab rats can breathe underwater with surfactant. That's how they discovered it. And it forces the lungs open and helps these babies breathe. And it saved my son's life. So, and he's been a little case study for a lot of doctors in Florida because he's done the opposite of what those books told them he should do. I had doctors walk in and just stand there beside me in amazement. That kid, I was told when he was 6 months old, he would require a double lung transplant to live. And that had never been done in the U.S. before. Knock on wood, my baby's 34 years old and has never come close to needing a lung transplant. So hopefully we're good to go. You typing away? What are you searching? What are you researching?
I'm always researching something.
I was there. So last night, I don't even know when this was filed. I took a screen, well, I put it on my phone because I was laying in my bed on my phone when I saw this. I don't have it on the PC, but I need to read this again because it was pretty interesting and it's to do with Karen Reed, Sandra Birchmore stuff. And then that led me, a good buddy of mine on Twitter is a document god, and he always helps me out. But I was turned on to a little website this morning and I was like, okay, it's all about Sandra Birchmore. Let me read you guys what this document says that came down. It's Commonwealth versus Karen Reed. It was handwritten. The date was handwritten in. It says 5/6, and I think it says allowed 5/6/25. So I'm confused about what this means, but it says the Commonwealth moves to prohibit disclosure. So the Commonwealth versus Karen Reed. They want to move for this to be not allowed. So the Commonwealth moves to prohibit disclosure of references to any investigation conducted by Canton Police Department, Canton Fire, Massachusetts State Police, Norfolk District Attorney's Office, U.S. Attorney's Office. Um,
What?
yeah, Federal Bureau investigations related to the death of Miss Sandra Birchmore. The
Oh,
circumstances surrounding the 2021 February death of Miss Birchmore is not related to the material death of John O'Keefe. Evidence is relevant if it has rational tendency to prove an issue in this case. See Commonwealth versus Fayweather. Evidence that this is not relevant is not
the
admissible.
relevance is that they're shitty investigators.
Right.
That's what it
Well,
is.
they cover up for one another.
Mhm.
There's a difference between shitty investigation and cover-ups,
Yeah.
and we'll call it a shitty investigations. They won't know we're covering shit up. We'll just take that little slap on the wrist. Therefore, the concept of relevancy has two components. Looks like Reed and team are entering the courthouse. By the way, guys, evidence must have a tendency to prove or disprove fact. Um, the fact must be material to the issue in the case, and it cites a case to go look at. Questioning an officer's involvement in an unrelated death investigation, particularly one remote in time and circumstance, is irrelevant. Is it? Can we be the judge of the irrelevancy, please?
I wish.
Right, girl. When I read that, I was like, so they don't want Karen Reed's attorneys, or they're not going to be allowed. They don't want, the Commonwealth doesn't want them to bring up Birchmore and the officers involved in that investigation. Lank. I'm going to have to see that name a whole bunch of times, y'all. Like, I'm like, why is this dude so important? And I'm figuring it out. And thank
Yeah,
you,
like,
Mr.
sorry, Bev,
Attorneys, for
like,
telling me the story finally. Like, damn it,
it's
man.
proof that they're corrupt. Like, that's the relevance, lady. Like, come on.
Well, yeah, and I've read some more stuff about the involvement of Lank. Well, see what she's saying is whatever happened over there doesn't even tie to this case. Excuse
Well,
me,
that's
lady.
true,
The
but
one thing
yeah.
that, but the no, it, they don't tie as far as the two crimes. But what does tie them together are the officers involved in two separate possible cover-ups.
Mhm.
That's a huge problem. So if you got cops who think they own the town to begin with, and then you got the Canton PD's top cop is the brother to the man who owns the home where the other man was found dead, who also both happen to be cops.
Mhm.
Y'all recused yourself, Canton PD, from questioning witnesses in John O'Keefe's demise because of your connection to your top cop, Kevin Albert. These top cops are also involved in the Sandra Birchmore cover-up case. So there is relevant, ma'am. We're not idiots. You just don't want us to know your dirty little secrets in Canton. Y'all, what's going on in this world? Um, so Dr. Vanna responded on my live
Oh,
yesterday
she did?
after
Oh, okay.
some butterflies on shit. She is not with me. Oh, there she is. Butterfly is here. She my main mod for a reason. She got my back. So I had sent her a little thing. We had some trollish, not true crime trolls, but we had like a cryptocurrency scam making its rounds, right? And I had to delete a few comments out of
Mhm.
Joe's live the other night. This guy was just about crypto shit. So someone left a comment on one of my video or one of our lives. So I sent it to Butterfly. I'm like, hey, let's keep an eye out for this type of activity, blah, blah, blah. So then she sends me a message last night. She's like, hey, Dr. Vanna responded. I'm just checking for trolls on the comments. And I was like, oh, good catch. So yeah, she responded. Let me take a look at what she said. Um, so we might get her on the show. We're going to work on that. She's busy right now. Let me pull it up, that comment, and I'll read it to you guys. I guess she got word that I said something on the live because she came in and commented on it. So I can only assume. Which live was that, Butterfly? Was it
Yesterday,
yesterday?
we were
Was
talking
that
about
it?
it.
So that would have been today's day 11. So it would have been this one.
Because Truth was saying that she would come to, join your
Oh,
chat or, join your
here it is.
panel if you
The
wanted,
my
maybe.
Okay, so Ms. Vanna's handle on Twitter, I didn't realize, was at the minds behind true crime. She said her comment to me 13 hours ago was, "You said I'm so young looking, a girl after my own heart." Yes, ma'am. My semester ends next week. Okay, I get a week off before summer. So we should be able to get her on before summer and before the Koberger trial. I'd love to come on for a little to answer psych questions. Also about Dr. Ramsland's response, they were different. See, I wasn't being ugly, I
Um,
was just being truthful. It's probably because he asked her different questions than I did. I can see that. I never asked anything I felt would put her in a bad position to answer. Bryony is also a reporter and can do that well. Me, not so much. I'll stay in my lane. Yes, ma'am. I didn't get to listen to this whole thing. Hopefully, it wasn't brutal. And I commented back, it was not brutal. She says, I can handle it either way. You always been kind to me, but let's talk. So, yes, ma'am. So I sent her a message back and asked her to give me an email so we can work that out. We can get her on here. Oh, I was reading a comment. Walter, scream it for the people in the back. May not be listening. Right? So that would be interesting, right? If we get Dr. Vanna over here and have a little discussion about Koberger stuff. So I checked his docket this morning and hey, did you guys see that link I dropped in Discord to you about another interview that was done with Chris McDonough? McDonough was his name.
I saw that there was another one. Yeah.
Yeah, it was an interview with Stephen Christie
Mm-hmm.
Gonzalez. And it looks like Autumn, their youngest, has got a going to college at Baylor.
That's good.
Yeah, good for her. She got a pretty good scholarship. So I noticed somebody made a headline on their live, something about their daughter goes to college and same labs that were used in the Idaho 4. I'm like, what are you talking about? So I had to go review that live myself and listen to what Stephen Christie said. And I'm like, I didn't hear that part, but okay. Pays to do your own research. Don't take somebody else's word for it.
Oh, definitely. Definitely
Headlines,
learned that.
right? Headlines can be deceiving. Clickbait.
Oh, shoot.
You clickbaited my ass. Good Lord, I should have known better. I should, especially seen the account that it came from. I was like, oh, I should have known. Um, so guys, at lunchtime, hold on one second. Okay. So you guys know if you've been following me for a while, and if you don't know, I have been covering I've been getting weird notifications this morning. There's a couple of things I forgot about that business wise I need to take care of. Yeah, they hit me this morning. I'm like, y'all get away from me, phone. All right. So we've been following the Mickey Steins case over there in Kentucky. You know, he shot the judge in the judge's chambers. And I presented the videos that have come down since that all happened. And we had the video of the sheriff actually shooting the judge in chambers. A while back we had video released of shows when they all leave the restaurant and head back down to the courthouse after their luncheon. Shows Mickey Steins, going into the courthouse. Shows him casually walk out after he did what he did. All those things. We've reviewed that whole video. Um, I need to clean up the playlist and get them all in order. Well, there was some more that was released recently, but there was like a 5-minute piece, like wasn't there. Now the whole thing is out. There's no audio, of course, because it was from within the judge's chambers, but it's the whole thing from beginning to end from the interaction. And it's odd. So we're going to review that at lunchtime for any of you who are interested and want to follow along. I'm sorry, I was reading comments. Butterfly, you watched that interview with the Gonzalez over there? It was a good interview. Christy seemed to be in a better place. I always gauge her when I watch her because as a mother and the worry, knowing what her whole journey is going to be the rest of her entire life, I kind of have a feel for Christy Gonzalez. And I ain't scared to say it out loud. You're living an abnormal normalcy. Don't know what to do with it. You haven't watched it yet. The Interview Dolphin? Yeah, it's pretty good. I mean, it's nothing we really, I didn't take any new takeaways from it or anything like that, except the youngest one getting ready to go to college, you know? And they really talk about Kaylee and Maddie, the girls, right? Outside of these college girls that were murdered. They talk about them, their life together, and it gave me a little more insight into the girls. And this time of year, they're always on my mind. I try to keep my
Yeah, it's
emotions
close to
in
their
check.
birthdays, isn't it?
Yes, ma'am. Yeah, we try to
Yeah.
do our best to keep ourselves in check, but right now it is birthday time. We got Maddie Mays coming up at the end of the month, I think the 25th.
And then
Kaylee
early
J-
June, yeah, it's
Kaylee
Kaylee.
Jade is June 8th because I'm June 9th. Me and Kaylee are Gemini twins, almost. And then we have Xana in July. Ethan doesn't come up till later in the year, my little Scorpio. So, yeah, it's birthday time for the girls, so it's on their minds, you know what I mean? And you can't help that. So I always like hearing families talk about the victims in any case because they get so lost, you know, and just to know a little bit more about them. Um,
Yeah. That's a
just
it's
kind
a
of
good change, yeah.
Yeah, it is, right? It's a change of pace and it kind of puts things back into perspective because they do even here that gets lost when we're talking about Koberger and reading all those documents. That's not to say it's Koberger, you know, I'm innocent to proven guilty, all that stuff. But we wouldn't be sitting here discussing crimes if there weren't victims. So I never want to forget the victims. Yeah, Butterfly, it wasn't about everything else, right? It was about them. And yeah, the girls had a big fight right before Olivia's wedding. And Kaylee's like, to hell with Maddie. I don't want to be at the wedding if she's going to be there. And so Christy had to get the girls back together after their little fight. And I'm laying there listening to the interview going, typical teenage girls. If you got girls, you'll understand what she's talking about. So we are up to, let me see if I think I messed my list up. I told y'all that. Where's my other piece of paper? Oh, oh, Lordy. I had myself all organized up and I just lost my main. Where did I do
Yeah, I
it?
don't remember who was testifying at the end there.
Oh, I can tell you that one because I know, right? Everything.
And did he finish cross? I don't think they
They
crossed him.
weren't finished. Yeah,
Mhm.
cause they were going. Let me pull up my last one here. We were at O'Hara.
O'Hara. Okay, yeah. Okay.
Massachusetts State Trooper. He was on, but I thought I had another page that was laying here that I moved out of my way this morning.
Oh, the one that did the grid search with the
Yeah. The SART team guy.
yeah, yeah.
So you know what I found
Not
odd
the
about that? I'm glad you brought that up
mhm.
because you got, the top cop on the scene over there, Mister. I'm gonna use a leaf blower and some red Solo cups. Then you got SART team coming in. Well, we use shovels and rakes. But
Yeah, right?
your top cop who just invented new crime scene techniques in 2022, leaf blower and red Solo cup style, didn't want to use a shovel because he might break glass. But here comes the SART team, grid search people. We're gonna use shovels. I'm like, y'all, can y'all find anybody in your town? Can you conduct? What's happening here? I guess both methods worked in the end. They got what they needed, right? Excuse me. Okay.
Well, apparently on an audit, that other guy was called innovative for using the snowblower, that which
Well,
blows your mind, you know
actually,
what I mean?
what was so funny is I watched something on Court TV may not have been Court TV. I won't promise you that's where I saw it. Anyway, there were two different experts there talking. One of them said that innovative. The other one laughed at him. He's like, "I'm sorry, I can't get behind with that innovative theory. That's not
No.
innovative." So you had two opposing, you know, uh takes on that. It was so interesting. All right, we got movement in the courtroom, guys. Let's bring it up. It looks like the judge is giving her instructions. She's gonna start smiling because her morning gummy kicking in a minute.
Mhm. Yep.
Yeah. Her morning gummy's about to come into play. I'm going to go get me some more coffee. We got
Gonna
to have
talk
our
about
little morning
how, oh,
chai
we're sorry
bottle.
we wasted your time with the
Yeah.
sidebar, and
We're just
thank you for being
pretending
patient.
we're getting we're getting warmed up for the day. What y'all do with Tiny Desk Guy? He's on a different assignment because now they got a girl. Uh-oh. ST done changed and that's a different lady. Is that her? That's a different lady. She
Which
not there
one?
today. The
Tiny
one
desk lady?
no, the chick sitting beside Karen's parents. That's not
Oh,
that's not the
that's,
mysterious
yeah.
lady we're debating about.
Oh,
Is
yeah, she's gone. Yeah, yeah.
she's not
Yeah?
no, there she is. She in the
Oh,
back.
she's a second. Oh, okay.
See? Look at
Yep.
her face and look at his face. Them bitches are related. Firefly. That's gonna be mine and Firefly's big debate throughout this whole trial. Are they or aren't they? Guys, y'all help us dig and find that out. Who is this lady though, Firefly? She might be her sister, huh?
But the new girl, she looks, yeah, no, she, yeah, I see a resemblance there between the two ladies, yeah.
Yeah.
Or maybe not. No, the nose looks the same, the mouth kinda looks the same, yeah.
Yeah. Their profiles are matching, aren't they? Firefly or Butterfly, I thought so. Ed Wallace didn't like the
Oh, he sure did, I loved that,
Did
that
you
was so
watch
great, I
it?
knew he would.
Okay, I did not watch that yet, but I have heard, yeah, he was
It
like,
was really
not
long, they did like a 2-hour show.
mm-mm. Was
He
he
put
going
and
off on their techniques?
he cut out holes out of a Shop and Stop bag and put it over his head. Oh.
Oh my goodness. So I bet you, I wonder how many actual CSI type guys and, forensic guy,
Oh, they're probably all freaking out.
they're all like, dude, was that innovative or was that just plain stupid? I don't know how to tell them to go about removing that snow. What was the best option? Who am I to tell them? I'm some lady sitting at my chair at a
Well, why
desk.
didn't you just let the state do it? Like they came and did the grid search. They could have done a better job. They probably would have done it properly. Then again, I don't
Well,
know.
they were pressed for time, snow melting and all the things.
Why?
Blizzard coming. We got a blizzard coming, Firefly. We got
I
about a
know that means it's not going anywhere, right?
or is it all going to be covered? I don't know what that guy was thinking. He's needed a
It's gonna
snowblower
be
real fast.
frozen in place. There ain't
He
nothing gonna
just needs
happen to it.
somebody get me a snowblower fast or leaf blower. Let's correct the record. It was a leaf blower. I've used leaf
Leaf
blowers. Them
blower.
bitches are powerful.
Oh, I keep calling it a snow blower too.
Yeah, it's a leaf blower. I don't guess they
Are
have an
there snow
actual.
blowers? I guess they're snow blowers like what shovels the snow, I guess.
I don't know. I don't live in Snowland. I just
Oh.
know they were called is a leaf blower turned snow blower, and
Mm.
I know I've used plenty of leaf blowers in my life and they're powerful even on low. He's like, you can control it. And I was thinking to myself, the ones I use will blast the shit out of them leaves. What's he talking about?
Yeah.
I used
Well,
to use
you could even
dog
see in the
kennel.
film, it showed a couple leaves blowing away.
Well, it shows us the powder. You
It's
can
like,
see
well, what about the stuff you can't see is gonna blow away too, buddy? Duh.
what if there had been hairs or
Whoop.
fragments of glass, shards of, there could have been all kind of stuff in that snow that he was unaware of. I don't think it takes a rocket scientist to know that was a shitty move on his part, right?
I loved it when Jackson's like, "Have you been questioned on your performance on that day?" And he's like, legit look confused. He's like, "My
He's like,
performance?
don't
What do
ask
you
me that
mean?
question.
What do you mean?"
It was
Okay.
funny too, the way the defense is like, you don't have to shake your head before I finish the question. I'm like, yeah, that dude's a head shaker. Every time he's questioned by the defense, midway through, he starts shaking his head. And I'm like, Then body language experts would tear you up, dude. Good thing I don't pay them no mind. Because it would, right now, your body language shaking you. And then he got called out on it by the defense attorney. I was laughing. I was like, ho, ho, ho.
Yep.
He probably Googled it, right? Best way to remove snow from crime scene. Get out your leaf blower, buddy. That's what Google says. Oh my God.
They
Fire,
didn't want to, he didn't want to break anything with the shovel. And yet
like,
the actual professionals come with shovels. I mean, go figure.
right. And it was interesting too that he said that, we didn't want to break glass. Oh, really? How did y'all know there was even a glass in the ground?
Right. Right. And that's the thing too when he talked about doing a probable cause affidavit, he's like, "Oh, well, we already knew there was the glass from the bar." Like you said, he kinda
And
gave
but
himself away there too.
but how did he know that? Because
I don't know.
he had just stated before that he didn't know where that glass come from. Then he turned around and lied a little bit later and said, "Well, we knew the glass came from the bar." No, at that moment you did not. You know now,
Mhm. Yep,
just like the rest of us, but you didn't know that night where that glass came from.
right.
So, unless Karen was still there on scene, because by the time he got there, the body was gone. John O'Keefe was no longer there, right? When he took out the snowblower to get all of his, because it was an unsecured scene when he got over there. So, no one told him the rock glass came from the bar. Only one that could have verified that would have been Karen, and she wasn't there. So he can come again with his perjury shit. You didn't know where the glass was from. You had no idea what happened to the man. And I got a problem with them finding the sneaker and pieces of taillight all over that 6-inch berm. But yet, Carrie
You
was
didn't.
parked right there.
Mm,
You had cops behind her. You had activity at the scene. Everybody running around. Whatever happened here. Get blankets. All of y'all running right past that shoe and those broken taillight pieces. And
yeah,
nobody
it's a little
sees that
tough.
shoe yet. And the visibility in the snow wasn't that bad yet. When did that shoe get out there is the problem, along with those broken pieces. Because right now, I'm telling you, neither side's proven shit to me. The prosecution has not proved to me this woman did anything that she even knew she did. And the defense hasn't proved to me a conspiracy happens yet either. They're getting there, though. They're getting there. They've shown me there's some questionable things to ask about that said conspiracy. That's why I'm writing down the actual players of the conspiracy, because that matters if you want my brain to link them all together and how they conspired together. You can't just tell me a cute story and I'm going to believe it.
Right.
You can't. And the defense came in hot, with their opening statements. So right now, if I had to gauge it, who's got me more? Defense by a long shot. By a long shot.
Yep.
Oh, they're coming back to their tables, so maybe they'll
Okay,
get it.
can you bring
As
the
soon as they
jurors in,
start, I'm going to
Tony,
go get my
please?
coffee.
Thank you.
Thank you, Butterfly. Yes, everybody,
You are
welcome
unmuted.
in and please hit the like button. I'd appreciate it. Here we go, guys. Day 11. True, Butterfly. You probably would have got better advice off the Google, huh? Think about that for a second, y'all. Google that, somebody.
Okay, thank you.
Y'all make me laugh. My favorite thing in the world to do. If you can't make me laugh, I don't even know what I'm doing. Oh, I was about to say, Firefly, I didn't see the brother over there, but he's back there on the very back. I see him.
Yeah, apparently he's been naughty. He can't
Still,
sit up front anymore.
he's still intimidating. Get your butt to the back, mister. Get to the back. Don't be giving nobody the side eye. I mean, you're going to sit there and intimidate people with your look? I'd give it right back. I'd stare back at him. Like, get up, Karen Reed, and pretend to box his ass. What you gonna do about it, buddy? Y'all, I gotta know why Mickey Stein shot that damn judge. What's going on over there in Letcher County? More corruption. Lord, we got to become a corruption channel. They keep it up. We can just say we're a bunch of conspiracy theorists over here. All cops are bad. Not true, but it kind of y'all the ones that make yourselves look that way, not us. We try to support. I've got law enforcement in my family, a couple of really good ones, and I'm very proud of them, and they do a really good job. Alabama and Florida. So I don't throw no shade at the law enforcement, but man, y'all need to act right. I need to pick their brains about a couple of things, actually. What are they doing, y'all? Y'all should come to court early and get your paperwork and stuff done. Oh, O'Hara Firefly was the cert guy's name. I'm sorry, I told you wrong. Oh, thank you, Butterfly.
Oh, I think you said O'Hara. I'm pretty sure. I think
Okay.
so. What are they doing? It's like an exam or something.
I know. It's like pencils
Everybody's
down.
got their heads
I
down.
know.
They're studying.
Fill in the little
Feel like a
bubbles.
proctor.
Filling in the little bubbles of their FCATs or whatever they used to
Yeah.
call them back in the day. You hear that pencils down, and you're like, shit, I wasn't done. You mean time's up? Y'all gonna keep me back in the grade? Because I didn't have time. Like I don't have
Karen's done first.
Karen's like, let's get it on. Tired of this shit. She probably needs a damn vacation. She's a Caribbean cruise. I'd go to an island where there wasn't nobody around, Karen. Just plop me down there for a hot month and leave me alone. All of y'all. That's what I'd do if I was her.
For the jurors, just for the record, I think Ms. Little had an opportunity to review the redacted exhibits from yesterday, and I don't think there was any objection to them.
Oh yeah, they had to get those
All right.
redactions in.
Would all rise for your attention?
Butterfly Googled it. I got the goods. Turn the fan off. It makes us dizzy. Or it does me.
Making a buzzing sound.
Hear ye, hear ye, hear
Hear
ye.
ye,
All
hear
persons
ye.
having anything to do before the
Forefathers
Honorable
might be
Beverly
turning over in their
Benoni, the
grave
Justice of the
at the moment.
Superior Court, holding in Dedham, within and for the County of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
All right, good morning again, council. Good morning, good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. No or should they? All right, Mr. Brennan, your next witness, please.
Thank you, Your Honor. The Commonwealth calls Connor Keefe.
Good morning, sir. Follow me. Now step up, raise your right hand. Face the clerk. Thank you.
You raise your right hand. You solemnly swear the evidence given to the court and jury in the case now hearing should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Good morning.
Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
Sure, my name is Connor Keefe. The last name is Keefe.
Mr. Keefe, where do you work?
I work for the Massachusetts State Police.
What's your position with the Massachusetts State Police?
I'm assigned to the Norfolk District Attorney's Office.
Are you a trooper?
Yes,
When did you first start beginning working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the Academy.
How long was the academy?
Approximately 6 months.
Did you have any further training after the academy?
On the job training?
Yes.
Yes, in various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the District Attorney's Office.
Did you have a role in investigating this case?
Yes.
Were you assigned investigator in this case?
I wasn't the main investigator, but I was involved, yes.
Did you deal with any of the digital forensic evidence?
Yes.
Specifically, regarding the digital forensic evidence, did you meet anybody to obtain a phone?
Yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
After you received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that a copying an image of the phone?
Yes.
Is that different than analyzing the phone?
Yes.
Were you involved in analyzing Kerry Roberts' phone?
No.
Were you involved in analyzing Jennifer McCabe's phone?
No.
Was your role limited to attaching it to grade key and doing the extraction?
That is correct.
And did you do that?
Yes.
In addition to the phone extractions, if you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes.
Do you know about what time you went there?
Approximately 5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes.
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag.
And why would you do that?
To secure it.
How would you become aware if there was a piece of evidence found?
The CERT team would alert the supervisor, Lieutenant Tully, or myself that there was an item or a piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a bag, evidence bag.
Do you know if those photographs were time-stamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
If I could begin, I'd like to show you on the screen a series of exhibits. If we could start with Exhibit 74, please. Trooper, do you recognize that item?
Yes.
What is it?
That is a black Nike shoe.
Did you see that item that night?
Yes.
74A, please. 74B. Thank you. Is that the same sneaker?
Yes, sir.
After you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Do you have gloves?
Yes, sir.
Do you want the lights on, Mr. Brennan?
Please, thank you, Your Honor. And Ms. Gilman, you can take the photo down, please. With the court's permission, I'm going to move this piece of evidence, item into evidence.
Okay.
Let me ask you a few questions before you open it. Could you stand and show that
Yes, sir.
bag? There's red tape on it. What's that for?
To secure the bag closed.
If the bag is open, is it then retaped?
Yes.
Do you write on the outside of the bag?
Yes.
Why do you do that?
To memorialize the date, time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir. Sorry.
Y'all, maybe we should send them all some chapstick. That chapped out, or, you know, chapstick.
With the court's permission, can he show the item?
Yes.
Thank you.
About spit my coffee out, Dolphin. Thanks.
Trooper, is that the same item that you found that night?
Yes, sir.
If you could place it back in the bag. I'd ask this to be marked as an exhibit.
All right, any
Who
objections?
cleaned it and
needed?
washed it?
There's no objection.
Exhibit 77.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who was collecting it.
The time that you write in the bag, is that the specific time the item was found, or does that represent a different time?
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times, then when you seal the bag, that can be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes.
Would you ever write a time later than when the item was found?
Yes.
I'd like to move now to Exhibit 75, please. And preferably 75A, please. Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
And if we could turn to 76A, please. Do you recognize that item?
Yes.
Is that an item that you bagged that night?
Yes.
Do you have both of those items with you?
Yes, sir.
Could you produce those, please? Ms. Gilman, you could take that down, please. Thank you. 570.
Yes, sir.
With the court's permission, I'd ask the trooper to open the bag and show the jury. Sir, on those items that are stickers, did you put the stickers on them?
I did not.
Do you know where the stickers come from?
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just 2 pieces or is there another piece in that bag?
There was another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off, or do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the jury as well?
Small motherfucker.
Is that smaller piece consistent with the same color as the 2 bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
If you could put that back in the bag, please. I'd move this into evidence, please.
Okay.
What are we already having to do that for? That was a very tiny piece in that last one he just showed.
Yeah, that's what's weird. Like, even if this light broke, would it break into so many tiny pieces? I just don't know.
Well, I've heard men, come along and mansplain it.
Okay.
The type of plastic it's made from and all the different things, and that's not designed to crack easy, right?
No.
I mean, let's use some logic. We don't need a man to tell us that. They're designed to withstand some impact. So
if you hit it that hard enough to break it like that, it's going to leave some damage to the body, right?
well, there's damage. Well, there's damage to the body, but what
more than
caused
just
it?
scratches. More than scratches, though.
So if they want to say, yeah, well, it depends on where they claim that he was hit. He wasn't bending over and the car hit him in the head. The head injury came from falling on the hard ground firm. So I know what they're trying to tell me.
So,
It's
Mr.
still not
Brennan, I'll
gonna-
leave it to you
still
and the
not
witness
job.
how you do that part.
Yes.
But how hard was that plastic? How would it shatter, right?
Sir, in the small chip piece, you don't know how it became chipped?
I do not.
I'd ask you to remove that chip. Like you
When
to
and how
safely
the items
secure it,
got
bring
there
with
is
you
the
and bag it
question.
when you leave.
Yes, sir.
And I'd like to introduce that exhibit.
78.
So we're going to mark the little chip.
You
Ms.
would like to
Giannetti
mark it?
asked to
Okay.
mark that. Yes.
Then we're going to submit that for identification. So the small chip that I
Madam
asked you to
Clerk.
secure.
Madam Court Reporter has an envelope for that.
Thank you very much.
Exhibit 78.
Thank you.
Exhibit BB for identification.
Thank you. Trooper, we have one more bag of items to go through.
Yes.
Could I have Exhibit 73, please? Sir, if you could look at Exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes,
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
That piece looks odd the way it's sitting there, doesn't it?
I'm showing you a photo. You recognize what's in it?
Part of that white piece off her tail light.
Yes.
What's in it?
The piece of clear
Clear
plastic.
piece.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Fair and accurate depiction of how you saw it that morning?
Yes, sir.
I'd move this into evidence as an exhibit, please.
Okay.
Like I said, she still
There's
could have
no
hit
objection,
him.
Mr.
Doesn't mean it
Giannetti?
was murder.
There's no objection, Your Honor.
Exhibit 79.
With the court's permission, could we show Exhibit 79 to the jury?
Yes.
Ms. Gilman, would you be able to close? Thank you. You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please?
Yes.
Are these different in color than the last pieces you showed?
Yes.
With the court's permission, could the trooper show these pieces?
Yes.
Thank you, Trooper. I'd move these items into evidence.
No objection, Your Honor.
All right. Exhibit 80. Thank you.
Thank you, Trooper Keefe.
Thank you, sir.
All right, any questions, Ms. Giannetti?
Please, Your Honor, thank you.
Good morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Kerry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct an extraction of the device.
Okay. And on that consent form, there is a description of the item itself?
Yes.
In this case, it would have been an iPhone 11.
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number?
The International Mobile Equipment Identifier.
Okay. And that would be included on the form as well because it identifies the specific iPhone 11 that Jennifer McCabe had, correct?
Correct.
The password was provided on that consent form?
Yes.
And the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well?
That's correct.
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022?
Yes.
You also dated it February 2nd of 2022, correct?
Correct.
Jennifer McCabe did not list a time, but you did, correct?
I would have to look at the consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated a time, but looking at the consent form would refresh your memory?
Yes.
May I approach, Your Honor?
Yes.
Now, I just ask you to read that silently and then look up at me when you're done, Trooper. Having reviewed that form, does that refresh your memory as to whether you indicated a date and time?
I did, yes.
And what was the date and time that you indicated?
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
Correct. 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
Okay. So don't put it up on the...
I will not.
Exhibit 81.
Now, Trooper Keefe, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay. It's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No. Not a homicide investigation, no.
You have not yet.
No.
The lead investigator is the trooper who is responsible for the case, correct?
Yes.
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
Yes.
If somebody asked within your unit while this case was going on, whose case is it or who has that case, your answer would have been Michael Proctor, correct?
Yes.
The two of you have worked cases together in the past, correct?
A few.
You've worked on this case with Michael Proctor, correct?
Yes.
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not?
You'll have to be more specific.
Sure. So for instance, on October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
No, I don't recall that.
If I may just have a moment, Your Honor.
Okay.
Sarah's the EMT paramedic, friends with Caitlin Albert.
Okay, Trooper, you do not remember interviewing Sarah Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office. Is that your current testimony?
Yes.
Okay. If you saw a copy of that report, would that refresh your memory?
To an extent.
May I approach, Your Honor?
Yes.
No, not at all. Yeah.
I've placed a document in front of you. I would just ask you to read that silently to yourself. Look up at me when you're done.
This shouldn't be taking that long to realize you were there.
And Trooper Keefe, just so we're clear, I'm not going to ask you any questions about the specifics of what Sarah Levinson said, so you don't have to brush up on that.
I'd just like to refresh. Take
Sure,
a look, sir.
go ahead.
You were prepped as well, huh, by the prosecution? Gotcha. Heavily prepped. What are you waiting on, dude?
Having reviewed that report, does that refresh your memory as to whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but...
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
Yes.
Okay. And the two of you would have participated in that interview together, correct?
Yes.
But you did not write the report, correct?
No, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the language to use in that report, correct?
I did not have any input on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing it, correct?
Correct.
Now, other examples of, and actually, let me take that back from you if you don't mind. Let me approach Judge.
Yes.
Thank you. You're welcome. Other examples are the reports on the videos that you, well, strike that. Let me start by saying this. Asking you this. You retrieved videos from both the Waterfall Bar and Grill and C.F. McCarthy's, did you not?
That's correct.
You and Sergeant Buchanan retrieved the videos from C.F. McCarthy's, correct?
Yes.
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Sure. If I may approach?
Okay.
I'm sorry. And again, if you'd read that silently to yourself and look up at me when you're done.
It's a bunch of forgetfulness in this town. Drinkers and forgetfulness. Firefly. That along with his shot of whiskey. Good morning, Carrie.
Okay. Having reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video.
Right.
I did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes.
And that, by the way, I said waterfall. Is that C.F. McCarthy's there, or is that waterfall?
This is C.F. McCarthy's.
Okay, I meant C.F. McCarthy's. He was the one to review that video, correct?
Yes, again, I only got a copy of the surveillance video.
Sure.
I did not do any analysis.
And with regard to the waterfall bar and grill, that was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes.
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
Yes, I would have to see that report as well, sir.
Okay. Now, another member of your unit was Trooper David DeChico, correct?
Yes.
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we approach?
That was an odd face that he made. May we approach? And he's like, don't come near me. Yeah, Katie, I'm glad your power came back on. It's never cool, is it, for the power to go out? It got pretty rocking and rolling from around the country last night from what I was gathering. I know Kay Woodcock was posting some stuff about bad weather in Louisiana as well. Nickname. What do you mean, Firefly? What nickname? What did I miss? Oh no, Carrie, your neighbors
Sorry,
got... Oh, you're good.
They asked about, I hate when that they asked him about the trooper's nickname, and then they objected, so then they went to sidebar. I'm like, what?
Oh, because I was trying to say, what are they talking about? Because I'm sitting here listening to this dude's wishy-washiness.
Trooper, in terms of the troopers that were in your unit as of January 29th of 2022, which members of the unit had the least amount of time in the unit at that time?
I don't recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes.
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
He could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
You attended the autopsy of John O'Keefe on January 31st of 2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office?
The medical examiner's office in Sandwich, Massachusetts.
In Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes.
Had you met her prior to that day?
No.
Had you spoken to her prior to that day?
No.
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said?
Objection.
With regard to Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
Mrs. Staines, you can ask that differently.
What, if any, conversations did you have with Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
There was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes.
You also learned that there was a small cut above his right eye, correct?
Yes.
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. If I may have a moment. May I approach, Your Honor?
Do you want this one back?
Oh, please, thank you. So I've placed another document in front of you. Just take a look, read it silently to yourself, and look up at me when you're done.
I'm writing Firefly as fast as I can.
And I would direct your attention to the second page for the question I just asked you.
Right, Dolphin? I caught that too. I'm listening. Them damn details.
Having reviewed that report, Trooper, is your memory refreshed as to whether you observed a small abrasion on the left side of John O'Keefe's nose?
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one?
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives Unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Not.
In this case, when the autopsy ended, you left the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Objection.
You knew when you left that Dr. Scorti-Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct?
Objection.
You knew when you left that in your presence, Dr. Scorti-Bello had seen the injuries to John O'Keefe's arm.
Object to the line of questioning.
Sustained.
May we approach?
Okay?
Yeah. It's getting
Please
a little
feel free to
sketchy
stand
in
up.
there. You even said something you probably shouldn't have said. You said the word bites.
He said bites, but there were injuries, though. There were injuries.
I know, but I'm just from a legal standpoint. My brain is two different brains here, so I guess two of me in here. From a legal standpoint, who's called them bites yet, right? So there, that was
true.
a valid
Yeah.
objection.
Well, that part, yeah.
Yeah, I mean, he did that on purpose. They're defense attorneys.
Course, yeah.
I don't mind them. I don't mind their shade. You know, you got to get your words in. Everybody makes little comments after the comment.
This is probably the first the jury has heard it, that bites.
Exactly. Did the jury catch what we did? He said, bite, what?
Animal bites.
Yeah.
Or whatever. Yep.
Introducing some reasonable doubt on the sly. You know what I mean?
Mhm.
Yeah. I still need to hear. I want to hear from the person who performed this autopsy. And
Well, apparently they said the unknown cause. Well, they'll tell us. I mean,
well, I'm not really worried about the cause of death at this point. I want to know about these injuries to this man's body.
yeah.
To help me get to a determination on what happened to this man. Just
So
like a doctor would do.
they haven't mentioned the skull fracture.
No, but like Dolphin and I, we were listening to him testify a few minutes ago, like her comment right here. Exactly what he said, cut
I wrote
above
that
his
down.
eye, the abrasion on the side of the nose. Both eyes were black and the right eye was puffy. Okay, so I'm learning more about these injuries that were on the body. and I need to know more about these said injuries, right? I
Right.
need how deep, the length. There's all kinds of things I'm fixing to look at when y'all get that lady up there to tell me about this man's body, because you can't just come tell me a cute story and me buy it. Wrong
Mm-hmm.
girl. I need a bunch of details first, and then we will examine and make a determination. Oh my goodness. Yeah, we can't wait to see how they explain that stuff, right, Dolphin? It's going to be so super interesting. I can't wait to get to that parts of it. Now, this guy's interesting because they're laying the foundation, again, of a conspiracy. Proctor keeps being mentioned. He's the lead investigator, right? This guy is
Yep.
now oh, I don't remember being a part of the interview. Oh, yeah, I guess I was now that I reviewed the notes.
Yeah.
He took the phones from Jen and Carrie, did the download extractions on those. He's a jack of all
Were you
trades, state
watching
trooper.
Dr. Scorti-Bello as she was conducting the autopsy?
Yes.
Did she appear to be looking at John O'Keefe's body?
Objection.
It's the same thing, just ask a different.
What direction were her eyes facing when she was examining John O'Keefe's body?
What?
I don't recall.
Okay. Was she looking at the ceiling, Trooper?
She was doing her job conducting the autopsy.
And in order to do
at
that,
the body.
I'm sorry?
She was looking at the body, I assume.
Thank
I'm not
you.
in.
Thank you. And looking at the body, you saw her looking at the body, correct?
Yes.
And looking at the body included an arm, correct?
Yes.
And it was at the arm was not covered up during the autopsy, correct?
No.
It was open for you to see, correct?
Yes.
And you saw the injuries to John O'Keefe's arm, correct?
Yes.
You didn't see any bruising on his arm, correct?
I don't recall.
You didn't notice any obvious broken bones, did you?
I'm not a medical expert.
And it is common practice for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
Not when I was there.
You were there, correct?
Yes.
And there was nothing that prevented you from giving input to the doctor as she examined the body, correct?
We don't give input. We give the facts that we know so far in the case.
Okay. Well, giving the facts is giving input, is it not?
It's not input.
Okay. Did you talk to Dr. Scorti-Bello during the autopsy?
Yes.
And you gave her information, if you don't want to call it input, correct?
Yes.
And at the end of it, you left without her ruling it a homicide, correct?
Objection.
I have nothing further.
Anything, Mr. Carter?
No, none, thank you.
All right, you're all set, Trooper.
Thank you.
So, jurors, this break we're going to take now.
They're already having morning break.
All right, we're going to take a break. The lawyers and I have some work that we have to do, so it's a little bit longer break. than we
That's because they're
normally
getting
do.
close to
Hang on,
information.
hang on,
We did get
I know, hang on.
So, we'll
Okay,
take
a longer
recess
break
after
than
the
usual.
next hour.
So I don't know how, they usually go 10, 15 minutes on their morning break. So I'm thinking maybe 30. All right, I'm sorry, Firefly. I didn't mean to interrupt. I was trying to hear what time she said so we would kind of gauge it. Okay. We're cooking with Crisco again. What was that statement you just said?
Oh,
I'm sorry.
okay. I'm sorry. I couldn't hear her talking. She talks so low.
I know, that's why I was like, hold on, let me hear what this bitch is, or this lady's saying, because I need to know what time they might be coming back, because I got to keep up with this stuff. I got a lot of going on the side over here. Yeah, let's not ask that guy anything else. There's not much else he can offer, honestly. I get it. You were there, Proctor's lead investigator. You collected evidence from the grid cert team. I wrote down everything he did. He extracted the 2 phones. What are y'all going to talk about now behind the scenes, Judge? We got some behind the scenes talk happening.
So I want to talk a little bit more about what we talked about at sidebar. And
Let's
I read
do.
the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision, and I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what, but I remember she testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get quickly the evidentiary basis. This is straightforward judicial notice. There are 2 separate decisions which require 2 separate...
One's a Massachusetts case, so that's easy enough.
Okay, so, and that's a shall...
It's an SJC case, so yes.
Yes, okay. So now to the Maryland case. So that's governed by federal, Massachusetts Rule 39A, and that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course a court is a judicial proceedings, of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor. May I approach?
Yes.
CC for ID.
Okay, thank you.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor. And the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So the drafters of this rule knew how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what...
In one area, right? One specific area?
Well, you can call it one
the decision.
Area. Right. Oh, yeah. Just what's in the decision, but there's 2 parts to that decision, 2 areas. It's FLH, frequent location history.
Right.
But what the court also got at was Apple source codes. That she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
So what is it that, so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking me to allow.
If I could give you the answer, Your Honor, I will explain it. It's a very short answer.
Okay.
What I want to do is with regard to her 227 timestamp, and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp, she is not using Apple source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say, in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is, in fact, what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she is not asked about that, then what?
Oh, if she's not asked about the 227, and I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated and not relevant to what she's going to testify to or the basis for her opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like surrogate is a way to try to cheapen her testimony in front of the jury. Here, number one, what he said, I really can't follow him. I don't understand, other than he's trying to draw some type of relevance and materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on significant location, and although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case. Nothing.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Oh, it was. The 227 timestamp would...
No, that was raised, but this... What was problematic in Maryland, the same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been Daubertized with regard to Apple source codes. And if I could, Your Honor,
okay.
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the State Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their reliability of their methodology. And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross her on. So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code, her methodology in the Herrera case, she got Daubertized on because it wasn't reliable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them. In this case, it's just basic cross-examination.
You can see the plan to dehumanize somebody, Daubertized, to use a term to suggest some type of conclusion that has no basis in fact is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with the timestamp. It was an entirely different issue. By their analysis, if an expert goes into court on a motion on anything to do with data forensics, and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different issue in forensic data analysis at another case. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is parts of Ms. Hyde's slide that go to location. There's a good part of her slide presentation. I don't want to depart from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data steps. So there are certainly aspects directly relevant. Here's the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled, it's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor, this decision, how do you impeach an expert? That one of the fundamental ways you do it is to, and I don't mean to dehumanize her, I won't even use the term Galbertize anymore. She's been deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. That's competency. You, and any expert that's been deemed that, you get to attack that. If the Commonwealth believes the case is not relevant, if Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Mr. Brennan make that point on redirect. But I can't have my client's constitutional right to confront her on the very subject matter she's going to testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court. And one part is the location. She has in her PowerPoint she's going to testify.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion that the timestamp for 227 is not related to the search. They're conflating the issue. She has not been deemed unreliable. It is the issue of the significant locations by that court that they found insufficient. There's no opinion from a court that she's an unreliable expert, and this is how they're going to distort it. Invoking the Constitution and invoking the client's rights has nothing to do with the analysis. That is a totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion, it wasn't this methodology for the opinions that she's going to offer in this case. And so if you look at the case, it is a totally different related report, different related item. It's as if a reconstruction expert went into a court and attempted to give an opinion about a medical diagnosis, and the court wouldn't allow that medical diagnosis in another court, in another jurisdiction, they would not be able to be cross-examined that in some court there was an opinion they offered that was deemed inadmissible, unless they were talking about the very same methodology and the very same point. This has nothing to do with her opinion whatsoever. It's just an attempt to try to endorse the defense's attempt to suggest she's not credible by hiding behind the shield of a different judge and distorting the fact that it's two different methodologies, it's two different issues.
One last word. Go ahead.
Thank you, Your Honor. He just said credibility. This isn't a credibility issue. This is a reliability. This is the essence of what experts do. You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion.
And this is the equivalent of a Superior Court opinion, right? It's not an appellate decision.
It is, Your Honor. It is the equivalent. I respectfully don't think that the level of the court is at all relevant. Any court, unless you get it overturned on appeal, then this would be a different matter. But this is a valid case, and even if it wasn't, it shall be in evidence. So there's two issues here, and I think the Commonwealth is conflating that. The question first for the court is this admissible? Can it come into evidence? To me, that's a non-issue. Rule 39 says, ipso facto, yes, as long as I've got a certified copy. So it is in evidence. I don't know why we're perseverating respectfully on whether I can question her on something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly says that this wasn't about her. The final sentence, the decretal section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert, and her name is mentioned throughout this opinion. It's all about Ms. Hyde. And I'll conclude my last point, Your Honor, where I started, and that is Ms. Hyde's methodology. With regard to her PowerPoint, you heard Mr. Brennan's answer. He has included in her PowerPoint locations, steps, etc. It's exactly what was at issue here. The 227 timestamp, she has no, and this will be developed further on cross, she has no peer-reviewed article to say that how she is determining that 227 timestamp should not be in the data. She has nothing to support that, just like she had nothing in this case with regard to data forensics. Final point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't, in anticipatory, have my cross-examination struck before I even get to pursue that with the witness, and I believe once I pursue it with the witness, it will become eminently clear that it's a proper basis for cross-examination.
All right, and Mr. Lessie, have you thought about if the Commonwealth does not get into the 227 timestamp, whether you think you're still entitled to do this?
Your answer, Your Honor, my answer is I would be entitled, but I would say this. If they don't get into 227, I won't go after it. I won't pursue it. I won't pursue use of this opinion.
We necessarily would have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases, and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone calls, but if I could avoid talking about 227, I would, but it is necessary for the basis of her opinion. There's just no way around it. And again, this is something that after a defendant expert may or may not testify, could be addressed at that point. There is no burden on the defendant. I'm not being presumptuous, although there was an offer of proof earlier on similar evidence. But not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact and have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we have not made a decision on what data forensics expert we're going to call, but if I could just 10 seconds.
Okay, but then answer my question after your 10 seconds.
I will. Mr. Brennan can't have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an expert. Her competence has been determined in this decision, and it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense on cross-examination. Now to answer your question, Your Honor, we are going to have a witness that is going to address the 227 issue.
Okay.
Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's...
Yeah. And Your Honor, my point would be that's obviously going to be Your Honor's decision ultimately. But again, the Commonwealth can't have it both ways. They're the ones who are triggering this issue, and I say triggering in a legal sense. They are putting at issue the 227 timestamp with this issue, with this witness. If they weren't doing that, I wouldn't be having this discussion at all. But they're putting it at issue. I have the right, respectfully, to cross-examine on the issue that they're putting in issue, and they shouldn't get rewarded with sort of having a pre-authorization of rebuttal to deal with it. They should have to meet their burden of rebuttal depending upon when the evidence comes. But I don't believe just because we may call a witness, that should dilute my ability to cross-examine this witness on an issue they're raising. I'm not raising it.
You can see why I wish I had more notice on this, right?
Your Honor, I have no good answer for that.
So I will do what I can in the next half hour. I might need more time on this, frankly, but we'll see. She's here?
Your Honor, may I ask one quick... may I, Mr. President?
I just want to know, is she here?
She is, Your Honor.
Can she stay another day if need be?
I think she'll do what the court directs her to do. She would have to leave by Friday. She cannot be here. Well, may I approach?
Yeah, why don't you come up?
Yeah, y'all go discuss it. Get this witness on board because I need to hear. So they have had Daubert hearing. Hello, Sinead. Welcome in. Yeah, he was... The jurors are not present right now. They were sent out on break, and they're discussing a matter about this expert, cell phone data girl. I've been calling them data dudes. So anyway, there's been another case she was involved with, and a Daubert hearing was held. Daubert hearing, Frye hearing, same thing. What they do is they go in and they have a hearing on the admissibility of an expert's opinions. Peer reviewed, where all the things peer reviewed, is substantial here or not, right? Is this going to be allowed in? So she was apparently, her opinion was not allowed in. Now I get the argument that what she's testifying to in this case could be totally separate than what that case pertained to, but what's important is she's had a Daubert hearing on her. So let me decide. Now, the jury didn't see what I just saw, so I've already got a caution flag flying for this expert, right? Because she's fixing to come in and tell me how that crazy deletion happened and how that phone search was done at 2:30 in the morning versus not done till Karen demanded it after 6 a.m. versus the 2:30 search. So yeah, I kind of need to know about her, everything about her at this point, right? And put up another expert to dispute her defense. Y'all can do that. I'm down with it. But deletions. Well, I got a big red flag about all her deletions when I figured out where her husband does for a freaking living. Matt McCabe. I see you. I done read all about you what you do for a living. And I concluded on my own theory here, you may be the one who tampered with your wife's phone. You're the only one that would have known what to do.
That's a good point. I forgot about her husband and
Oh,
all
I
this.
did not. The minute I learned that information, I was like, whoa, you got
Yeah.
calls on Jen's phone? Say no more. So if I'm to buy into your conspiracy, and there's weird shit happening on this lady's phone, her husband happens to own company.
Hey there, Karen Reed trial watchers. You know what a lot of the trials we cover remind me of?
Jesse, don't freak me out again.
Not Jesse.
No, Jesse. Okay, let me get this little pop-up out of my way that was in my way of my screen here. All right. Look, her fingers can't operate the phone, but her butt sure can, right, Dolphin? Jesus, lady. Even if you lay your phone down on the table and you're sitting there drinking, what's the chance of that phone butt dialing somebody over and over and over and over and over, all on its own? We all know how these cell phones work these days. Butt dials aren't that easy to pull off anymore. I don't butt dial anybody. If I dial you, you know I did it on purpose. And you're lucky because I just usually don't call people. We need the expert to explain what. What did I miss?
How all those text messages got deleted spontaneously, not by the user, right? That's what they're trying to say.
Yeah, they're calling it a data dump thingy that happened with her phone. Nobody seems to be sure what happened to Jen's phone.
That's never happened to my phone.
Huh?
That's never happened to my phone. I have an iPhone. Nothing.
I know. None of us buy that. We all have phones. Half of us have iPhones, half of us have Samsung or Androids, whatever. But so a lot of what they're trying to sell us, we're like, what? My phone don't do that, and we all got phones. So it's a whole weird theory they're trying to sell us. But when you got Jim McCabe's phone, a highly questionable witness in this conspiracy ring, a lot of mysterious things are happening to her phone. And then when I realized what her husband did for a living, that kind of made sense to me. If someone manipulated her phone, it was him. He deleted all the stuff. He deleted Safari and all the things. Would have been him. I don't think Jen's smart enough to figure that part out yet. She's smart enough to know, hey, we can use that. I just heard that. We can do that. She's smart enough to help us pull a lot of this off. But the phone deletion activity, all the sketchiness on Jen's phone, is leading back to her husband in my mind.
Maybe.
Who else would delete it? Who else would manipulate that phone thinking they've done it where nobody else could figure it out? A cybersecurity guy who has a lot of knowledge, owns a multi-million-dollar company, works for business. I mean, contracts with all kinds of agencies. And hold on, Dolphin, you weren't here the other day when I went over all that. Let me see if I saved it. I know I saved it. I just don't know if I saved it into my file or the bookmark bar. Let me look. He owns a cybersecurity type company, and I read all about his little. Maybe it's on the bookmark bar. Let me go check.
Was it he and his brother or somebody? Yeah. He has a partner.
His brother. Hang on, let me take this screen down and pull this up. And I also got to get to my phone and pull up the stream for the trial to keep an eye on when they go back. Okay, let's see. Let me get to my bar here. Let's see where did I save it at? It must be in here. Karen Reed. Let me see. Where'd you go, Karen? I got too many cases, too many files. Karen Reed. Here we go. Matt McCabe, cybersecurity. Da-da-da. Okay, let me bring up the screen. And I'd love to get your view on this, Dolphin. All right. Which, by the way, you know where the link's at if you want to grab it. All right. So Matt McCabe is right there that's him on the left, right, Firefly? Standing up.
Upper left, yeah.
Yeah, upper left guy standing up in the back. That is Matt McCabe. His brother is seated at the table. Okay, so technology is all about benefits and threats, and the speed of sophistication of development on both sides of the spectrum has spawned industries of their own. In an age when almost all information from baby pictures to strategic war plans is transmitted through digital channels, the risk of having that information accessed by hackers, phishers, cyber criminals, and terrorists have never been greater. Former personal credit data breaches from personal credit data breaches like the most recent Target Corp and Neiman Marcus hijacks to allegations of international governmental and industrial what can I read this morning? Cyber hacking. Retailers, financial institutes, corporations, and government agencies have been vulnerable. The expanding need for specialized information technology services in the private and public sectors led four Massachusetts businessmen to go all in to meet what they saw was a universal product need. In 2009, long before Karen Reed's incident, 2009, brothers Michael McCabe of Sandwich, that's a town, and Matthew McCabe of Canton partnered with former Hingman resident Mark Miller and Mike Pinota of Duxbury to found Elevate Technology Solutions. The four left their corporate positions in other industries to build a staffing and consulting services company based in Rockland. Since then, the company has experienced massive growth in clients, increased revenue, and has expanded enough to open facilities in two other out-of-state locations. Elevate recruits IT specialists with a specific focus on enterprise applications, cloud technology, big data, and cybersecurity. Interesting. Their clients range from small private companies to U.S. government, and flexible strategy of using contract experts to supplement staff knowledge gives them a competitive edge on finding the right solution for their client needs. Did you find a solution for your needs, Mr. McCabe? Ford took a risk when they opened up the shop in the midst of a recession. But as managing partner Michael McCabe sees it, it was a time when companies were trying to learn how to be better at using the internet to their advantage and in need of the kinds of services Elevate and its contractors could supply. They took a gamble on starting the company, McCabe said. They had explosive growth. Their numbers improved the wisdom of the vision. In its first year in business, Elevate had 2 clients. Since then, it served 55 commercial clients and 9 government agencies and 722 consultants on assignment. 722, all with varying expertise and knowledge. Revenue, which was 456,000 in 2009, grew to 17 million by the end of 2013. Jen's got a wealthy husband and a nice phone. What do you think, Dolphin? Think there's a possibility he could have fudged with the phone? Or one of his people? Y'all know what I mean.
Wow, 17 million? Damn.
Yeah.
Pretty good.
Yeah. Dolphin, I'll link it in the Discord if you need me to or want me to. Because I saved it. According to Elevate, a leadership team, the growth in threats is directly related to a growth in technology. And the growth of Elevate business follows. Okay. Tech and threat curve. In the past, the way you took data about people was to walk out of a building with data or a hard drive. Said the person. Okay, the company's vice president of corporate development strategy. Today, there are so many different ways to threaten security. Elevate utilizes a robust mix of full-time staff, contract employees, field consulting services, and their own consulting services on projects requiring highly specialized technological knowledge. We got some highly specialized technological knowledge going on over there. Yeah, even if he doesn't have the direct qualifications, somebody in his company might know something. You might know more than Jen about just deleting a message or two, right? We're talking massive data dumps on that phone. Wasn't there at one point something like 4,000 something's deleted from this woman's phone?
Yeah, it was like
I gotta go.
4,000.
Yeah,
Yeah.
yeah, because during the previous testimony we've heard, and nobody can explain how or why that occurred, right? Elevate competes with other staffing agencies that provide similar services, but has found a large client base in Massachusetts and Washington. The original mission was to provide its clients with the opportunities to benefit from virtual mobility and cloud technology. Well, that cloud technology, but people's just jumping all over that stuff. It has adapted to the needs of those clients whose concerns have transitioned to cybersecurity. So yeah, that's just a little bit about Jen's husband. Did he
So
do
do we
something?
know does Matt know how to delete files on a phone without making it obvious? I don't know.
Well, if he don't, somebody does within the company.
Yeah, but the only thing with that, like you don't, if you have a conspiracy going, you don't want too many people involved because somebody's going to
Exactly.
spill the beans. You know what I mean? Like,
I
so
think, look, somebody messed with the lady's phone. If y'all want me to
somebody
be on
did
this
for sure.
conspiracy train, let me be a conspirator for a moment.
Go ahead, go for
Oh,
it.
golly, I get confused in this space. One minute I can, and one minute, like, come
Oh, you
on,
can do
y'all.
anything you want. I'm just saying.
I'm
I'm just
saying
saying.
her husband. No, I'm joking. I'm joking. Because I'm thinking, what the hell happened to this lady's funky phone, right?
Yeah, something weird. Definitely
What
happened.
happened in 2022 to her damn fancy ass iPhone? Huh. I got an iPhone. I'm, like, okay, yay. I'm an Android person. All my family has iPhones but me. If they all probably had Androids, I'd probably be the one to get the iPhone. Because when that crowd goes right, I go left. I can't help it. I do it every
Isn't
time.
it like, as far as the
Voila.
population goes, isn't it pretty much 50-50 Android, iPhone? I think it is. I don't think there's like either one is, or if anything, Android's probably more popular.
Oh, I have no clue. I don't keep up with it. I just know that I had an iPhone once, and I was like, I don't like this thing at all. I got rid of
I
it and
think
got
it
my
goes by
Android back.
which was the first smartphone you had because
Oh,
that's probably the one you're
Android.
gonna like. Yeah, then that's why. Because
Yeah,
so
but the
the first
iPhones
smartphone I
weren't
got
out
was
back.
iPhone.
iPhones weren't out back when I got my first cell phone.
Was it?
No.
No, I'm talking cell phone. I'm talking smartphone.
Oh, well,
What was the first
no, my
smartphone
first
you had?
smartphone wasn't no iPhone. I don't even think them things were out yet, honestly.
It's
I've
like
had a cell phone for
2008,
years.
2008, 2009.
Well,
iPhone came out. I don't
oh
know when
yeah,
the first
I had a
Android
cell
came out.
phone long before then. I got my
Yeah, but a cell phone is not the same thing as a smartphone.
Oh, well, smartphone, okay. Yeah, I've never owned an iPhone until probably 10 years ago, and I did not like it. And my son told me that I was just old and needed to get with the program. I'm like, no, dude, it doesn't operate like my Android, and I'm used to all the
Right, right,
functions on
right.
the
So
Android,
if
right?
you had
So,
an Android first, that's what I'm trying to say. If you had
yeah,
an Android smartphone first, then
you
you're
start
going
with
to
that.
prefer that, right?
Right.
Like
Yeah,
I
yeah,
said, we're
yeah.
a little bit older, so if younger people could probably jump back and forth, because I was the same way.
My son used to
I
jump back and
started
forth.
with iPhone, and after a
Yeah.
while, and after a few years, I did try the Android,
Mm-hmm.
and it was too different for me. So I had it for like 6 months, and then I finally switched back to iPhone. I'm like, oh, thank God. Oh, because I mean, it's just for me, it was just like you're used to
Yeah,
whatever
you're
you're
used to
used
what
to.
you're used to.
Hmm.
Yeah, I think all my kids now have the iPhones. The grandchildren have
Yeah,
the
everybody
different
in my
iPhones.
family has iPhones. I think
I'm the odd man out. That's
my
okay.
one daughter always had an Android.
Well, I love my Samsung S24 Ultra.
Yeah,
And
that's what I
Dolphins,
mean. It's a personal choice. They're both good.
yes.
They're
Oh
both good.
God.
It's like
Got a
whatever you prefer.
little mini computer in my hands. Dolphin over here naming off all the old phones.
So she would probably know which was first. Was
What came
iPhone
out first?
first or Android?
First
Android
smartphone?
smartphone. Yeah, I don't know. I think it's iPhone was the first, but
You think that iPhone was the first smartphone? I don't
I
know.
don't know to be honest. I'm
I
not
feel
that
like
into it.
I don't know. I feel like
Before I had it, I had a BlackBerry.
somebody Google it.
I had a BlackBerry and it was so cool.
What
And
came
then
first?
the iPhone came out and I'm like, oh.
I never had a BlackBerry either. I didn't have one of those. I never did. I was too busy
I
doing
had a
other
Palm
shit.
Pilot too, because when I was still working in the hospital and I had the Palm Pilot, it was so cool because you could open it up and like Google search like medications and stuff, like,
Yeah,
or
yeah.
no, maybe not Google search, whatever it was, you could
Right, you
search.
can look it up.
Um,
Exactly.
and it was
You know,
like
a lot
so
of them.
cool for back then. No, it
Yeah.
wasn't. She said, no, what wasn't?
What was it?
Android? Somebody, well, it's a debate
Very
amongst person.
my phone has so much storage, right? That the one thing I loved about this new phone, I've had it for a couple years now, but the S24, like all the massive storage it came with. And I was literally talking to Joe on the phone the other night, and I went to get a screenshot to share, and I was like, dude, my phone's telling me I got 17,000 screenshots on it. And I have a lot of I make all my videos from my phone. I'm just stuck on my phone. So I have to delete shit sometimes. I'm like, why am I got to free up space on this massive storage on this phone? Well, because you got 17,000 screenshots, you freak.
Right.
People I don't even know.
I
Comment,
know.
documents and all these things. I'm like, man, I really got to sit down one night and spend a couple of hours deleting. Oh, maybe that's how Jen's happened. Her phone space
Okay.
got so full, she had to go do a data dump of 17,000 screenshots.
We have an official answer. Butterfly says she worked for AT&T and first smartphone was Android. Okay. I believe you.
Okay.
I believe you. I couldn't tell for sure.
I don't think the Apple came out until after that, right? The
Yeah,
Apple
I just
product.
remember the first one was like either 2008 or 2009. I'm not sure.
Yeah, I think my first smartphone was before 2008 because I had one when my kiddo was born, and he was born long before 2008. 4 years.
Smartphone or cell phone? I mean,
Smartphone.
oh, okay.
Smartphone. Well, my oldest went to Jacksonville for school after high school. We had smartphones back then, and my kid wasn't even born yet. I wasn't even pregnant yet.
Oh, okay.
Yeah, because we went to Verizon and we both got smartphones because he was about to leave for school in Jacksonville, and I wanted him to have a good phone.
Yeah, okay.
Yeah, and I think that was the first time I went and got like a plan, you know what I mean? And
Mhm.
got phones, and they were both two little smartphones.
Ah, neat.
I remember that too. You could finally download apps and shit. I'm like, oh, apps. What the hell they do?
Yeah.
There's an app for everything, and so y'all say, but what do they do? Now we know. Oh, which reminds me, sticking to true crime, but apps. I saw a piece. I always keep up with Elizabeth Smart, right? Because I followed Elizabeth Smart since she went missing until she was found 9 months later. She's an amazing, amazing person. Her so the two people that were arrested for kidnapping her was a husband and wife, and Barzy was the female. She just got caught on a sexual offender charge. She was let out of prison, had to register as an offender because of what she did to Elizabeth Smart. Court ordered not to go within these two specific parks. She got caught going into the park and got arrested. And I got the article with her mugshot and all this stuff. But Jesus told her to go to the park. I thought, okay, Lori Vallow, sit down. But because they were religious freaks, and they're in Utah. But she has worked with a company, and they've developed an app called Guardian. And the links they went to try to make security a top priority there, and why? Because like you can go on there and upload a profile of your person. Say you got a child, a family member with Alzheimer's, somebody might wander off, a child with autism, whatever. You put your information in, but you can't come in as an anonymous user. You have to be verified to use the app. And then you have your trusted people. I got to look into it to really know a lot more about it. This is what the gist I got from it this morning. So then you have these trusted people that you know. And then she's like, please never say never. Don't ever say my kid won't go missing. She literally went missing from her bed in the middle of the night. So anyway, it's a safe app. They tried to employ. So you say your kid goes missing, then you can send out an alert to those trusted people. What they did not want was predators to learn about such an app and use it and say, oh, look, there's a child over here that's wandered away, vulnerable situation, I'll go that kind of thing. Because don't think that kind of stuff doesn't happen. Predators watch a lot of things to get ideas on what to do next, including stalking your Facebooks. Lock your Facebooks down. But anyway, I'm going to check into that app. Have you heard of the Guardian app? I have never heard of it until this morning.
I have not.
Elizabeth does amazing work. She's took a bad story and she came through that. And this was before social media. We had Nancy Grace on HLN. And the allegations leveled against her father were horrendous. He never gave up. He stood his ground. He came out and fought tooth and nail. Every bad thing you say about me, I'm coming out here and we're going to talk about it. He was never afraid, even though he was hiding a big giant secret the entire time. But he never harmed his daughter. That thought never crossed that man's mind. He was dragged through the mud and accused of doing all sorts of things to his daughter until the day she was found. There was another gentleman who was looked into because of his prior record. They dug up his yard, right? The news media shows up, the neighbors all see it. The poor guy, I'll say that because he didn't have anything to do with Elizabeth Smart's disappearance, had no connection to her whatsoever. But they had dug up his yard, ran a lot of stories about him. Everybody was accusing him, regardless of the fact that nothing was found on his property. The man unalived himself because he couldn't take the pressure and the accusations being leveled at him. And again, he was completely uninvolved with Elizabeth Smart's disappearance. It's crazy. That is one of the craziest stories. That's why I hold out hope for Sebastian Rogers. To this day, is only because of Elizabeth Smart. Not a damn thing his daddy comes out and runs his mouth about. Nothing Chris Proudfoot comes out and runs his mouth about. Those two men need to sit down and shh. Not helping, right? Always hold out hope for Sebastian because of Elizabeth. Let me bring up that article while we're waiting. I also want to show you guys the Mickey Steins thing, but I don't want to start that in case they go back to the court because I don't want to interrupt it. Did y'all follow the Elizabeth Smart case at all when it happened?
I didn't. I know very little about it.
Oh, really? Yeah. Oh, bookmarks bar. Duh. Elizabeth Smart was kidnapped out of her home in Salt Lake City, Utah. And kidnapped by a man who had done handyman work around the home. Her little sister was in the same bedroom and was awake. Heard the man's voice speaking. She was 6 years old. She waited and she waited and she waited until she thought maybe the coast is clear and ran to her parents' bedroom to tell them a man took Elizabeth. I think 3 months went by before Mary Kate remembered the man's voice. And when she remembered who he was, she told her daddy. He called the cops. The cops came back over, interviewed her again. And she told them, I remember whose voice that was in the room that night. And she gave him a name, and they put out his flyer. Somebody that frequents the park he would come down from the woods with, where he had Elizabeth kidnapped and shackled. He would bring Elizabeth down occasionally, but he made her wear the garb from head to toe. I forget which, the burqa stuff where you can only see their eyes. Go figure. A very astute individual was in the park that day, and he remembered seeing that guy from time to time because the guy was very distinctive. He wore the same garb, him and his wife, and trolled around the parks, panhandling for money. So the guy was familiar with the face they put out there. And then lo and behold, he goes to the park one day, and there they are. He calls the cops. When the cops approach her and they separate them and they ask her, are you Elizabeth Smart? The first thing out of that child's mouth was, no, I'm not. Because she was terrified of what that man was going to do to her when they let her go and leave with that man, because she wasn't convinced they were going to save her. It's crazy. Thank God someone noticed that in the park and was able to get help down there, and that is how Elizabeth Smart was found. I was at work My husband and I fought at the time. We followed this case very closely with Nancy Grace every freaking night. And I was at work when he called me and he said, they found her. And I said, found who? He said, Elizabeth Smart. And I thought I was going to fall out right there at work. I was like, where is she okay? Was the first thing out of my mouth. Where and is she okay? Luckily, she turned out to be okay because some horrendous things were happening to this poor girl. All right, well, there's Elizabeth for you. She has also substituted for Ashley Banfield over on her show, and she did an amazing job that night. She interviewed little Charlotte. Charlotte was kidnapped from the state park last year or the year before. Anyways, Charlotte's a little amazing little girl as well. She did a really good interview with Charlotte's mom and aunt. They're really active now in the little missing persons community as well. Okay. Elizabeth Smart's convicted kidnapper Wanda Barzee was seen in a new mugshot on Utah's sex offender registry, smiling from ear to ear. In Utah, sex offenders are required to register twice a year, on their birthday and then 6 months later to the date, according to Utah law. Nearly 20 years after her conviction for holding Smart captive for 9 months, Barzee, 79, was arrested on May 1st after she allegedly violated sex offender restrictions. She was arrested at her Salt Lake City, Utah home on Thursday after she allegedly visited at least 2 parks, which she is prohibited from doing as a registered sex offender, according to the reports. Sex offenders are forbidden from entering certain protected areas where children are likely to be present, which included public parks, schools, and playgrounds. During her arrest, Barzee said she was commanded by the Lord to go to Liberty Park, and she liked to go there to sit on benches and feed the ducks. The outlet reported that Barzee also admitted that God had commended her to go to Sugar House Park as well. Barzee is now required to do weekly check-ins after her arrest for allegedly visiting parks in Salt Lake City, which is restricted from doing so because of her status, offender status. This is what she looked like back when she got arrested in 2002. Weirdo lady. I mean, she was. What that man was doing to that girl and what you were sitting there watching. It's freaking sick. In 2002, Barzee and her husband, Brian David Mitchell, kidnapped then 14-year-old Smart at knife point and held her captive for 9 months. Mitchell forced Smart into a polygamous marriage and raped her almost daily. Smart was rescued when a couple recognized her as she was walking through Sandy, a suburb of Salt Lake City, with Barzee and Mitchell. Initially, out of fear, Smart denied her identity when questioned by police. Yeah, it's been out there for so long. But later admitted that she was the missing teen. It took her a minute to tell them, and she talks about that very openly. She's an open book. You can pretty much ask that girl anything, and she doesn't mind answering the questions. It was America's Most Wanted, which aired an episode in Smart's 2002 abduction that led to her being recognized by a couple who spotted her walking with the captors. After several hearings, Barzee was sentenced to 15 years in prison for aggravated kidnapping. She received a sentence after cooperating with the FBI in the state of Utah to convict Mitchell, who was sentenced to life in prison. So she turned state's evidence against her husband to save her own ass. Smart later testified how she was drugged, tied to a tree, and raped as often as 4 times a day. She dared to cry for help. Her family would be murdered, Mitchell warned her. Now just imagine for a moment that someone lured Sebastian Rogers out of that house. I'll kill your family. You try to escape, I'll kill your mother. Because I've done took all the parents completely off the table. Because I got to have some faith in the TBI. During her ordeal, Smart insisted she would never give up hope that one day she would be found. Here is the guy that had her. David Brian Mitchell, the man accused of kidnapping. You're not accused, you're actually convicted now, where you belong. But they would wear everything and just cover up their whole entire body, face, and all. Coming back and being with my family was everything I dreamed of while I was being held kidnapped. she previously told Fox Digital. All I wanted was to make it home, feel love again, and feel safe again. I wanted to gain the courage, as cliche as it sounds, to follow my dreams. These weren't extravagant dreams. Extravagant dreams. Sorry, I glanced over at my phone at the same time I was trying to read. I wanted to go to high school, get my driver's license, and go to prom, go on a first date, go to college, get married, and have a family. She wanted to be normal. Here comes this weird ass man. Y'all lock your doors at night. Just because you live in a gated, pretty home doesn't mean you're safe. Lock your doors. In 2018, Barzee was released from prison and placed under 5 years of federal supervision in addition to being registered as a sex offender. She was ordered not to contact Smart's family. Sex offenders cannot be within 1,000 feet of victims in their victim's residence if a victim requested restrictions in place. So yeah, she done wandered off into the park when she wasn't supposed to because God told her to go out there and sit down and feed ducks. Lady, the ducks don't want no part of your food. All right, so we still got a few minutes. I'll play this for you guys. Look, that was her arrest. And like I said, she's smiling from ear to ear. She don't got a care in the world. Jesus has got her too. Man. So do we have to be bad in this world to get Jesus on our side? What the hell's going on lately? All right. This is the beautiful Elizabeth Smart. Let's let her talk. Oh, come on. We have a swamp signal.
Don't upload your videos to YouTube. Upload to Restream, where we will live stream it to YouTube.
You go to the App Store to begin with. You download it. You have to set up a profile. Now,
Uh-oh, could you guys hear that? It like froze up all of a sudden. Maybe it's just because it's coming through this article. Oh, let me turn something off. Maybe that'll help. Okay, let me try it again. Oh, shit. Come on. Oh, shoot. I'm trying not to cuss as much, y'all. Do I need like a swear jar? Would that do any good? Do those things work? Because I got questions. Oops, that was the wrong. This is the one. No. I'm working on something for Sunday, though. A new story that I've come across that I explored a little bit and found some stuff. And I'm like, oh, this is worth talking about. I have not heard of that. Kara Robinson. Sorry, guys. I had a malfunction. Okay. Let me try this again. They are still giving us OnlyFans vibes. Oh, good Lord.
Don't upload your videos to YouTube. Upload to Restream, where we will live stream it to YouTube and all your...
What's this doing? Because I have...
you go to the App Store to begin with. You download it.
Oh, goodness. If it's not going to work, it's not going to work. But anyway, she's going to explain that Guardian app.
You have to set up a profile. Now, the really cool thing about the profile, setting it up, which sets it apart, in my opinion.
Okay. It's not going to work. I'm not going to sit here and harass with it all morning because I got to make sure. Let me pull up the court streams. I want to make sure it's not freaking out on me, too. I'm the only one home on the Wi-Fi, and we haven't had any issues, so. What? Dolphin chewed through the ropes and saved herself. Right, Sinead? Look at these horror stories we talk about. What kind of world we live in? That's why I'm saying y'all lock those darn doors at night. I live out in rural America. Guess what's happening? My doors are deadbolted. I don't trust these fools. They're deadbolted right now in the broad daylight. Not getting me today, Satan. Okay. We still have the OnlyFans fan going. Yeah, it's there's a, y'all when you get into true crime and you hear all those stories, you start to realize it's a wicked world out there. I mean, I've known it for years because I've followed true crime around for years, but mm, compared the little girl to Elizabeth Smart. Oh, okay. Right, Sinead? Well, my daddy raised three daughters. He had one son. We lock our doors. Our daddy would lock these doors, girl. You lock your doors. Your car doors. You lock your doors, girl. Yes, sir, daddy. It's like drilled into my head. When I first moved into my son's house a couple years ago, to help with the grandson, a few times I'd walk by the front door and it's like, everybody's getting ready to go to bed and the door's not locked. I'm like, lock the door. Like, son, who raised you? You're my child. You know it better. It's fine, Mom. I'm like, no, it's not fine. So I had to retrain my grown son to lock his damn doors. I still go behind him and check. The other little girl made it home in time to watch her case on the news. Wow, she escaped from her kidnapper. Some of these kids are just got tenacious as heck. You know what I mean? It's of course some are going to be terrified to make a move. Then you got those that are just like little daredevils. What is it from 3021? Thanks, ladies. I've been the pace of the show. Maybe Salty's in the know. Of what? I don't know a lot. Make sure I didn't miss a comment somewhere. What are we in the know about? Come tell us. Oh, I'm sorry. Let me look. I see a comment now. Hey, gang. Anyone know where True Crime Grit has been? I do not. Good question. Wondered the same thing myself. Lot going on down there in Delphi. Some of us have, just kind of stepped away quietly and sat down. So maybe she's doing that. I really couldn't tell you. I haven't even tried to communicate with her. Maybe I should reach out and make sure she's okay. But she doesn't do the XDMs often, so. Yeah, my chat on the restream doesn't keep up very well. It goes a little slower, and I have my phone turned off right now because Butterfly's comment just popped up for me. Yeah, they have to register in Florida the same way. I have sex offender alerts on my phone from the Florida Department of Law Enforcement for the state of Florida. You move in within a certain range of me, I'm going to get a notification and know exactly who you are, exactly what you did, and exactly where you live. Got a notification last week of a new one way out here in the country. I was like, oh, heck. Thank you, Florida. So y'all go sign up. Go search it, Google search it, your state's registry offender list. Every state has one. Most states have a option where you can opt in to be notified via email. And you can set, in Florida, we can set like a 5-mile radius, 2-mile radius of our homes. And you'll get an alert. Somebody moves into your radius, right? You get their flyer, you get all the details of their arrest. You'll get notified when they fail to comply with registering as well. Because that happens a lot, too often, where they just don't comply. Oh, well, thank you. You're enjoying the pace of the show. Well, thank you. I try to keep it going, and during these long breaks, I try to keep it interesting with conversation. My partner, she ran off to get a snack. So I like reading y'all's comments and catching up with chat. And we are still looking at the OnlyFans while Miss
I'm back from my snack break.
So what did you get? What did you get for a snack? 'Cause I'm kind
All
of
I got was like a cheese stick and what do you call it? Meat stick. I forget what you call those. A little
that's my favorite,
turkey.
girl. Give me a little meat tray. In fact, when I go
Yeah.
shopping this weekend, it's on my list, little meat and cheese tray.
Mm.
Perfect, perfect trial snacks. I got to get my trial groceries again this weekend.
And those little a little V8 energy drink. I don't
Oh
drink them
yeah.
as energy drinks, but I like them. They're only like 30 calories or
You
something.
know what? My son and I like the V8 Fusion.
Yeah, those are good too.
Those are really good. Yeah, we both enjoyed those. I haven't had those in a while, but I think my body is telling me lately I need something like that. So that's a good idea for me to get some more of those. Thank you for that. I like tomato juice as well,
Yeah, they're
like in the
pretty cheap at the
South.
Dollar General too. Don't get
Yeah,
them at Publix.
yeah. I know, right? You don't get, girl. We got a
Publix
Publix
is
out
like twice as expensive. Ugh.
expensive, right? The closest thing, the closest grocery store to my home, well, besides that little tiny one down in town that I don't care for, well, whatever. That's a whole other rant about living in the country. But the closest main grocery store to me is Publix. And the Winn
Mhm.
Dixie was just down the street, but I've heard, because I haven't been into town in a while. Um, Hold on, Jesse just snuck in there and got me. Let me mute him out. Anyway, that Aldi or Aldi, whatever it's called,
Oh yeah, that's
they bought up the Winn Dixie here.
oh.
So I'm not happy about that because all summer long, Winn Dixie be out there freshly barbecuing me up some ribs, and I just stop and grab a slab and come to home. I don't know if they're going to still do that when Aldi moves in. I don't like them. They make me pay for a buggy. I'm like, I'm not doing that.
I know. That's what bugged me about it too. I'm like,
I
there's
went there for
so
the very
little, but
first time, right? Everybody's like, "Oh, they opened a tiny one down in town." So I go to town. I'm like, you know what? I guess I'll try this new store. It's tiny looking, but okay. So I go up there, like, who carries cash or change or anything? Like, I don't have none of
no.
that. I get up there and I want a buggy, and it won't. Nothing. I can't get it. They're all locked together, and people talking about having quarters. I'm like, what the hell's happening
Don't you have
right
to
now?
bring your own bags too? Like
Oh no, I'm not down with all that. That's too much work. I got to pay for my buggy. You got weird stuff in your store. Where's my Cokes? I'm not
it's
even
like
seeing them.
Sprouts. I gotta remember to bring my bags if I go to Sprouts. It's like, okay.
I don't have,
I always
well, I
forget. I
mean,
always forget stuff.
if you're into using reusable bags, you'd keep them in your trunk or whatever, but I'm not. I use those little plastic bags around the house. I'm cool with getting them. But Publix can be expensive, but I use it sometimes for certain things. Um, but it's the closest thing to me, so sometimes I do use them. That Walmart is freaking the furthest thing from me. So if I do a Walmart, I do a pickup, right? I don't like going in there. Too
Yeah.
much. Too many peoples. They peopling up in there all the time. I don't like to people up in the Walmart.
Yeah. The other day, I think it was Monday after you quit streaming, I was like, oh, I gotta go to Publix. I went there. Parking lot was so full. I'm like, nope. I'm not
Yeah.
going in there when there's tons of people. I just can't do it.
Yeah, that new well, the Publix down here by me, it's a new Publix. That whole intersection is just new stuff is popping up all over right there. And the Publix came in about a year ago, but it's always so crowded when I go down there. I like their 2-for-1s if it's stuff that I use. You know what I mean? So they got some good deals sometimes. And Public has a couple of things that my other stores don't have. But I prefer not to go there on the regular.
Just places like Sprouts charge you for grocery bags, Sinead. Like
I don't know that kind. Is that a store down there?
Sprouts, yeah.
Okay, I haven't heard of them. Some make you bring your own bag. No, they charged you for the buggies, Sinead. You got to put money in this little lock box. Like the buggies are all chained together or something. And there's like a little box where you got to drop your money in. Then it releases the lock and you can use your buggy. Are people trying to steal buggies? Is that the whole point? You know what I mean? Or, come on, nobody wants your buggy. That
Well,
one or
that way
two.
you bring it back so you get your money back.
Oh my
So
God.
they aren't just all
They
over
don't
the
have,
parking lot.
come on, the
See,
teenagers need a
Publix,
job. Give
yeah,
them a buggy.
Publix, they always have somebody brings your groceries out if you want. Like I
Well,
usually don't have them do
well,
it.
back in the old days, that was a thing.
Hmm.
Your grocery guy that bagged your groceries walked the women out to the car and helped them load. My granny did it her whole life. I watched it all my life. So as I got older and became a teenager, that was no longer a thing. You take your own groceries to your car. Publix is the only one that will still do that.
Mm-hmm.
Remember back in the day, they all closed up at 6 o'clock on Sunday.
Yeah, they almost always ask, "Need help out?" No.
Oh yeah, Publix is great about helping assist you if you need it or want it. They're always great about doing that. But they're literally one of the only ones that left that will do that, you know? And don't pay me to return my buggy to this proper place. I do that anyway.
Yeah, I do
And
too.
the buggy boy can go get that long train of buggies and take it back up front for you. Nobody's stealing your buggy or leaving it out in the parking lot. See, if you want to force me to pay you to meet me to return my buggy, I'm not going. Don't boss me around grocery store. I'll go to the dollar store first. I do Walmart pickup too, since my car got totaled. Which, by the way, I got an important phone call to make about a little concrete barrier that got scuffed. But anyway, my son goes and picks up my stuff for me. So now but I like doing the Walmart pickup. It's easiest for him too. I don't got to rely on him to get what I want. I already got it, son. Go get it. Just go pick it up. All right, movement in the courthouse. But I do got to restock my trial groceries.
Oh, look at her. She was studying.
She was reading that. They're trying to figure out if we're going to have it.
Yeah.
I think she's going to allow it and let them have their way on cross with her.
Probably.
Because I was I'm paying attention to the law on this matter. That she can only rule that way on it. Oh, hell.
So Mass Rule of Criminal Procedure, Rule 2, purpose and construction. And so upon reflection and consideration, it says, these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly where offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology. So that's my decision. So bring the jurors in, please.
You are unmuted.
Good decision.
That was a good decision. Yeah, that was a fair decision. I don't got no bones about that. Two separate matters, separate. The Daubert hearing didn't pertain to what she's testifying to today, but he can still get her on a credibility issue because this 230 search is critical, right? To me, that's a key piece of evidence that we got to get to the bottom of. When was that search conducted matters, and it makes all the damn difference in the world. Whether we want to admit it or not, it has a huge impact on this case.
Oh, 100%.
Mm-hmm. Yeah. You know he'll tear her up on a cross-exam too, y'all. I love little legal nerd guy. I'm like, when he's talking, my legal nerd
And he does
brain,
it with kindness too.
yes,
He's
my
not
legal
like,
nerd brain is all over that shit when he gets to talking. Like, y'all just let him have the whole thing. Give this man the floor.
Put it back in session. You may be seated.
Jurors, I appreciate your patience. So your next witness, Mr. Brennan.
The Commonwealth calls Jessica Hyde.
Let's rock and roll. Y'all got your notebooks and pen? I got you. We got to do a recap show this weekend, guys. My God.
Follow me, please. Face the clerk and raise your right hand, please.
Please tell me, swear the evidence given to the court and jury in the case now and here, the truth, the whole truth, and nothing but the truth, so help me God.
Yes, I do.
Good morning.
Good morning. Good morning, Your Honor.
Oh,
All right,
boy.
Mr. Brennan, whenever you're ready.
Thank you. Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Jessica Hyde, Jessica, space Hyde.
What do you do for a living?
I'm a digital forensics examiner. I'm also an associate. I'm also an adjunct professor at George Mason University, where I teach mobile device forensics in their graduate program. I also own a digital forensics company that does training, services, and research.
In addition to teaching at Georgetown University, do you teach in other ways?
Correction, I teach at George Mason University,
I'm
not
sorry.
Georgetown. But thank you. I also teach, my company writes and develops training courses. I teach a mobile forensic analysis course and a data structures course there to law enforcement, civilians, et cetera.
Do you engage in any other type of academics or research?
I do. I do other research as part of some volunteer activities I do in the digital forensics field. So I'm the chair of DFIR Review, which is a body that reviews practitioner-created research so that it can go through peer review. I often do reviews as a member of a reviewer for Forensic Science International Digital Investigations Journal, which I was a previous associate editor of.
What does peer
Oh, I'm so sorry.
What does peer review mean?
Peer review means that when a study is done or a research paper is done on a topic, that an assessment is done of it. There are 3 types of assessments that can be done. One is a methodological assessment, where you read through the methodology of the academic or practitioner-created paper and state if it is acceptable or not. The second is you conduct your own testing using the same methodology to conduct a peer review with your own generated data sets. And the third is if the original author has shared their data sets, reviewing their data sets and checking that against their work.
Has any of your work been peer reviewed in the past?
I've had 2 peer-reviewed journals. I've had an article that was peer-reviewed and published in Forensic Science International Digital Investigations regarding the standardization of file classification of recovered items. The layman's term of that would be talking about what deleted means. And then I have another paper that's been accepted that I was a co-author on in terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those same computer-related devices.
Did you have any specific education or training to learn about forensic data?
Absolutely. I have professional training both from courses I've taken, as well as I have a master's in digital forensics from George Mason University. A master's degree in that. I've taken multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is the GIAC Certified Forensics Examiner. I also hold the NWC 3CFE, which is a certified forensics examiner.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
How do you teach private digital forensic examiners? What's the method?
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching, but I also have a team of instructors. So for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Forensic data analysis seems like a broad field. Is there certain parts that you focus in?
I personally specialize in mobile phones and Internet of Things devices.
I want you to just give us some very basic, very general and brief background. When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device, and then we utilize a variety of tools to attempt to parse results from those devices. But the forensics examiner has to take the additional step to both understand, validate, and provide meaning to those results.
Is there any shortcomings or dangers in simply relying on a forensic tool for a result or an opinion?
There is absolutely a danger in just relying on parsed results. When an algorithm is used to determine what data is stored as, it doesn't tell you what that data means, and that's where you need a forensics examiner. Tools don't necessarily understand how the data got there and what causes the data to exist, and that takes deeper and further human analysis, as well as, you know, if you think about it, if on your phone you can go to the Google Play Store or the App Store and you can actually download millions of apps. There's like 6 million apps between the two stores. Digital forensics tools maybe support generously 1,000 applications. So in order to be able to parse and understand the data from applications that the tools don't know how to support, you need a forensics examiner who knows how to dig into that data, conduct testing, and determine the meaning of the data.
Were you asked by the Norfolk County District Attorney's Office to look at and analyze a phone that was related to a person by the name of Jennifer McCabe?
Yes, with a very, very specific scope to a specific date range.
Were you asked during that scope and date range to analyze it and provide an opinion about whether there were any user-initiated deletions of any web searches or Safari-type searches?
Yes, I was asked to look for deletions of Safari searches within the scope of the time frame that was dictated by the purpose of the exam.
Were you asked to look at the phone device and determine whether or not there were any user-initiated deletions of phone calls on the device?
Yes, I was asked to look for deletions of phone calls in that same date range.
And did you do both of those tasks?
Yes, that's correct.
Did you ultimately have opinions on both of those issues?
I do have opinions on both of those issues, that's correct.
And in engaging in the efforts to answer those two questions, did you necessarily have to review and analyze a web history that included searches on January 29th, 2022 at 2:27 a.m.?
I did analyze web searches that occurred at 2:29 a.m. in local time here in Norfolk on January 29th, 2022 from the device that was provided, yes. Not the device, a forensic image, for clarity.
So before we get to the two opinions that you were asked to consider, or what your opinions were after analyzing the data, I want to begin by giving the background and having you share with us your analysis and your observations and opinions about the search on Safari relative to this 2:27 time frame. Before we begin that, let me just ask you one question. Did you do anything to ensure the integrity of the data that you were looking at?
Upon receiving the forensic image, the first thing I did was I did what's called a hash of the image. So a hash is an algorithmic representation of a file. So a forensic image, all the data from the phone, it comes in one file that can then be extracted and have the rest of the data. That singular file that's received, there's actually 3, but focusing on the one that has all of the data, that archive file, you can run what's called a hash algorithm against it. There's actually multiple hash algorithms, and I hashed it, and then I validated that hash to the document that was provided along with the image file that contained the hashes that were contained in. Those hash values matched. Now, just for clarity, if you change one bit in a file, it will not have the same hash. So the hash provides integrity, and having used both hashes, which are available in that report, and ran 2 different algorithms, they both matched. Additionally, I reviewed the PDF that was received for signs of alteration. The PDF that comes with a Gray Key report is not signed by Adobe Acrobat. However, I was able to take that PDF and then examine it just like I would a phone. So I'm using the same techniques on the phone. Using a tool called EXIF tool, I was able to learn a lot about the creation of that particular PDF. And what I was able to learn about it was that it was created by, it's labeled it as being produced by Grayshift using a particular code-based application to create the PDF called PYF PDF, standing for Python Framework PDF. It is on, it's a program that you can download, and developers who create tools, like Magnet Forensics, who owns a Gray Key, utilize that script, which is why it says it's produced by it, to create the actual PDF. That's what the evidence there in the data tells me. It also contains a time of when that is created, and that time was February 2nd, 2022, at global UTC, that's the global constant time, think what's in the UK, at 22:49, which local time would be 5:49 p.m. So that says that it was created approximately 2 hours and 45 minutes after the document said the image started, and it correlated with the document information. So that provided some level of certainty that that document was factual, and on top of that, I further opened the file of that PDF in what's called a hex editor, which lets me see like every byte, every 1 and 0. And from doing that, I looked for tag markers that are made sometimes in some modifications of PDFs called XMPs, which is Adobe's format of markup, and I did not find any evidence of those tags.
When you're trying to determine whether there's integrity in the data, are you able to tell whether or not there's been any alterations or tampering before the item is put on the Gray Key machine to make the extraction?
That would be when you're talking about if the physical device had been manipulated, is that correct?
Yes.
I cannot tell if the physical device has been manipulated prior to it being imaged. I can only validate if the image was correct. In theory, all of the data of anything that you did on that device would still show in the evidence of device logs and whatever locations that were touched or communicated with. But at that point, it's the same as any user interacting with the device itself.
After the phone's extracted, or at the time it's extracted, does it have the history of the device on that extraction?
Could you rephrase?
Yes. At the time the phone is extracted and the copy is made in the PDF and the digital copy, does the digital copy and the PDF contain the history of searches and calls and other items on that phone?
The forensic image itself contains a variety of different artifacts or traces that are left behind by activities that a user does on a phone. Yes.
When you use the term artifact, what does that mean in a basic sense?
An artifact is any type of evidence that is left behind on your phone of an action. So, for example, if you receive a call, there are multiple places in the phone that show that a call was received. That can be in the call log, that could be in a notification, that could be in a unified log that tracks the activity that the phone's doing. There's multiple locations, and each one of those residue of the fact that the call came in, that's what I would refer to as an artifact. So you could have an artifact not just about a call, about a web search, about taking a photo. Any action you take on your phone may create an artifact.
Before we get into those two questions about any alleged deletions from Safari, a Google search or an internet search, and any alleged deletions of phone calls, I want to start with your explanation or your sharing how the timestamp works relative to that search beginning at 2:27 a.m. on January 29th, 2022.
So, for clarity, there's more than one search that happens actually at 2:27. There is some activity that's looking at, and I don't want to mispronounce the name of the town, I'll try Hockomock Sports, looking at activities for the sporting events at that school system, I assume, or county location. There is a timestamp for the search Haas Long to Die in Cold. However, that timestamp isn't about active searches, it's about the time that a tab was either opened or moved to the background. So Haas Long to Die in Cold is the most current search in the tab that you opened at that was opened at 2:27. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab or you can open a new tab. A new tab was opened at 2:27 a.m., and that search was done there. Another tab, actually at 2:27, was moved to the background, and its last search at the time it was moved to the background was for, I believe it's Raining Men, the YouTube video. So those two searches both exist as what's called browser state searches, but that's browser state isn't about the time that it was searched. It's about the time that the browser tab that you opened either went to the background or, if it's never been moved to the background, the current search. So the time in the instance of the It's Raining Men video is the time that that video was moved to the background and the new tab took over as the tab that's active. And that tab, the last search done in that tab is Haas Long to Die in the Cold, because that database holds the current search, it constantly gets updated, and the time that the tab was either opened if it's the first time it's opened, or moved to the background if it's an existing tab.
Did you put together an exhibit that would help explain some of the different databases?
I did put it together an exhibit that would show that.
May I approach?
Yes.
Y'all aren't following what she's saying?
Giving you a piece of paper. Do you recognize that?
I do. This is table 1 from the first report I created on this case on the phone that I was told was for Jen McCabe.
Is that the exhibit that will help you explain?
It will.
I move this to evidence.
Can we approach you? Or a bit of Jack if you want.
Come on out.
Okay. Key, you have to pay attention to all that technical stuff, blah, blah, blah in the beginning. What she's trying to say and prove right now, that was a search done on a tab that was already opened. Explain that to me, lady, and she just tried. And that's a huge takeaway right there. That is that lady's sole purpose, is to get up there and tell you that search was absolutely done at 6 a.m.-ish on a tab opened at 2:30 in the morning. Things are moving to the background, new search coming in. What about the actual search history log? They've mentioned there's all kinds of fuckery with this woman's phone, Dolphin. All the past testimony about her phone, I've got pages on testimony about her phone from the beginning of this case. I got to sit down tonight and force myself to go through my notes.
Well, I'm with Butterfly because she's going by this PDF image that was created on February 2nd. That's like 4 days after, so.
Exactly. Enough time for people to manipulate and delete things?
Possibly, yes.
Possibly my ass. They said shit was deleted. Right?
That's what I'm saying. So, okay.
They are literally, the defense is literally accusing them of deleting stuff from Jen's phone. So I'm comfortable with just saying it like it is. The defense is accusing them of manipulating that phone. Someone manipulated that phone.
Yep.
Something is going on with this phone. There are all these 4,000 deletions, all these phone call deletions. Y'all can explain it all away with cell phone data, people. This is the first time she's testified, or at least first time I've heard her testimony. Now, don't forget, keep in the back of your mind, she's already had a Daubert hearing in another case on a separate type of situation, not the same exact circumstances, but something different about that case. But whatever her opinion was in that case was kept out because they didn't find it admissible under a Daubert hearing. So can we trust her? I've already Googled her. Girlfriend. Again, we have another data person. I can't say data dude because it's a chick. We have another data person on board who happens to own their own companies.
Yeah. Give me is defense going to have their own data experts? Let's have them give their piece.
Yeah. Remember, Cy Ray owns his own company. We got data dude number one in this case that went on and on and on for days about phone extractions on Jen's phone. The Celebrite guy, he has his own stuff going on too on the side, his own programs. Like, what are y'all doing?
Yeah, isn't that sort of a conflict of interest to give use your own application?
Well, is it, or are they trying to build their own? Look how good my stuff is. Well, they're experts. They want to be top in their field. That's their whole goal. They're not here playing around. They want to be experts in their field. They want to own the company that everybody goes to. So you got to promote your business and your excellent data and your great programs that you have to read all this data, right? And so, yeah, she's out here owning her own company. She's a professor I don't take away from her credentials at all. And she's got no reason to get up there and lie. She's believing what her data is telling her. She's believing what her programs are telling her. But I still need another expert to give me their take on the same thing, right? The same topic. Exactly.
I understand what she's saying and how she explained it very clearly, but
she did explain it clearly, didn't she?
But I'm still doubting the PDF itself.
It's not even the PDF. I'm past that. It's the open browser tab stuff. They're trying. So I get why that's important. Don't get me wrong. But what I'm stuck on right now is when this search was conducted and why there's opposing witnesses to say you know what I mean? What's going on here with this phone? Was that search really conducted? Because right now, remember, I'm that juror who doesn't know if Karen Reed's innocent or guilty. I have no opinion right this moment. So I'm going to approach it right now from that standpoint. It's important to me, if I'm a juror, to figure that out. What happened to that search? When was it actually conducted is huge. And let's hope the jury's paying enough attention. You know what I mean? They're the ones that matter.
Before we look at any chalk, I want you to explain the entire basis for that chalk and your ultimate opinions that are reflected in the chalk. So let's start from the beginning.
May I look at my copy of the chart, or no?
Why don't I just ask you?
See if you can answer the questions, and if you can, let us know.
Yes, Your Honor.
When you looked at the phone to analyze it, were you trying to determine when a particular search was made, specifically the search how long to die in cold?
Correct. I was looking for two searches, both how long to die in CIKD and how long to die in cold.
So as a forensic examiner, how do you begin the process to try to identify and determine when that search is actually made?
So the first thing we would want to identify is what application was being used at the time to make the search. So looking at that date time stamped, it was able to, on that date, be able to determine that Safari was the application that was being used as the Google browser. And then you would begin looking at the artifacts for Safari, both those that are parsed by the forensics tools, but then further looking into the data structures that hold that data itself, and then ultimately conducting testing to determine why a certain artifact exists.
So you mentioned the beginning step is the forensic tool or tools. Did you use forensic tools to get information or parse any data regarding this potential search at 227?
Yes, I use multiple forensics tools.
Can you share with us the multiple forensic tools that you used?
Absolutely. I used Celebrate Physical Analyzer. I used Magnet Axiom. I used just the tools I used at first. I used iLeap. There are further tools I used later, but those were the three that I started with.
What tools did you use later?
Later, I used specifically, I've used Sanderson's Forensics Toolkit, the forensics browser in Sanderson's Forensics Toolkit, which helps exploit SQLite databases. And then I further reviewed in a tool called Rabbit Hole.
To begin with, Celebrate, is that a tool that you're familiar with?
Yes.
Is it a commonly used tool in the industry?
Yes, commonly used mobile forensics tool.
Is it reputable?
Highly reputable.
Why did you use Celebrate?
I use Celebrate because on any mobile exam, I'm going to validate what is captured by Celebrate and Magnet Axiom because they have the most robust parsing of what is in my tool arsenal. And then I would also follow up with iLeap closely behind because iLeap has a lot of artifacts that aren't supported by either of those tools. Using a variety of tools is going to give you different coverage, and each tool has a different perspective on how they view and display data.
You said you also use Magnet Axiom?
That is correct.
Is that a leading forensic tool as well?
Yes, that is also a leading forensics tool.
Are you familiar with that company?
I'm very familiar with Magnet Forensics. I was actually their director of forensics for 5 years, then continued to consult for them for an additional 2 years under my company Hexordia, and my company continues to be a reseller of Magnet's products.
You mentioned different tools may present information a different way. Do those tools change the underlying data at all?
That's a great question. So when we're talking about the results that a tool shows, the tools maintain the integrity of that original forensic image, and that's actually something we verify as we continue through our exams to make sure that the underlying data hasn't been changed. There are some tools, I did use some other tools, I apologize, I also used ArtX and Mushy. But the, I'm sorry, ArtX is capital A, lowercase rt, capital E, lowercase x, and then Mushy is M-U-S-H-Y. You're welcome. I'm sorry, can you repeat the question? I got this, the spelling threw me off.
I mentioned, or I asked you about using multiple tools and whether or not the use of different tools changes the actual underlying data.
So the actual underlying data is always maintained, and we do validate that. Some tools allow you to see parsed results and then allow you to dig deeper into looking at the actual files and data structures. Those would be tools like Celebrate, Physical Analyzer, and Magnet Axiom. Some tools show you the parsed results and tell you where they got them, like iLeap. It shows you the parsed results and tells you the file location, and then you would open that up in an external tool. And then some of the tools I used are not tools that parse the results, but are tools that allow me to manually look at the data structures. So they directly allow me to look at the data structures. And all of the tools I use in this instance are tools that do not change the underlying data.
Is it important or critical to go beyond the tools presentations and actually analyze the data yourself?
It is absolutely critical. Actually, in the NIST Scientific Foundation's paper from the National Institute of Science and Technology that states the foundations of digital forensic science, It states that it is the examiner's duty to not only verify and validate tool results, but also to provide meaning to forensics parsed results.
Does software update regularly?
Oh, the software updates all the time. Typically, we get an update about once a month, and to be honest, it's not enough to keep up with how many new apps are developed and how many new phones come out and how many of your applications get updates, new features, for example, maybe in Instagram or Facebook. So the tools update very, very regularly.
When you use the Celebrite tool to analyze the 227 search, did the search How's Long to Die in the Cold have a timestamp on it?
There are actually multiple artifacts for How's Long to Die in Cold. Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces for that How's Long to Die in Cold. Only one of them is associated with the 227 timestamp, but there are other instances of evidence of that was parsed by Celebrite.
Is there any danger for an untrained eye to rely simply on the software when looking at a search like this, How Long to Die in the Cold, and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that tab was backgrounded or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about this specific concern and concept?
Yes, I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University in their digital forensics master's program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use it as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
You mentioned that Celebrite showed the search on the report as How's Long to Die in the Cold with a timestamp of 227. Is it 227:40?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrate of last year, Celebrate made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
Is this ambiguity reflected in other types of software?
Could you rephrase, please?
Sure. For example, when you did a report in Axiom, did it have similar reflection in the report?
Objection, Your Honor.
Ask it differently.
Did you run a report regarding this time frame through Axiom software?
I did process the image through Axiom, yes.
When you did that, was it the same or a different result?
Axiom and Celebrate really show their data very, very differently. So Celebrate takes a perspective of alerting people to possible deletions by annotating either a question mark or a red X next to artifacts that come from different areas. Magnet instead marks if the artifact was parsed or carved. I feel like now I need to explain to you parsed or carved. So parsed means that the data was where it was expected to be found, and the algorithm was able to cleanly see that this is there. Carve means that it had to run that algorithm against the data structure as a whole and found it as a partial result. So it carved it out and went and found it instead of it just sitting there exactly where it was expected to be, and shows you both the results. So it'll show all of the results of, in this instance, the sessions, tab sessions, but the data browser DB, the tab state, it's going to, instead of telling you this has a red X, it'll instead say it was carved. So it's a different presentation of the same data.
And so I want to talk about deletions in a little bit, but I want to get back to the 227 search.
Sure.
So when you produced or you looked at the report for Celebrate and it showed this timestamp as well as the phrase, "How's long to die in the cold," where did you look? How did you make an analysis to determine whether or not that search was actually made at 227 or another time? What was your next steps for us?
So in looking at that timestamp, the first thing I did was actually go and look at what literature exists on the artifact, if anybody had reviewed this artifact before. I also created my own data set and tested how we could get what that timestamp means. So if I make a search in a tab, and then I make another search in a tab, which timestamp is it? If I make a search in a tab and then open a different tab, what changes? I also looked at the documentation in the Artifact Reference Guide for Axiom, which does state, it describes that timestamp as the time in which the tab is backgrounded, and it gives a stipulation that in certain circumstances, the timestamp can be earlier than the search.
Did you specifically look in any databases or for artifacts in the data to help make an analysis of when this search happened?
Of when the search happened as a whole? Absolutely. So there are multiple databases that I looked at that show search information for Safari. So I looked at the plist, mobile Safari plist. I looked at the browser state database. I looked for the history database. I also looked at the Knowledge CDB. The Knowledge CDB is a little bit different. That isn't a database for Safari. It's a database for all of Apple, so it can predict your behavior. So it takes in information that Apple wants to take in, including browser history, and it saves that information so it can make predictive information. I also looked at the caches in the Safari, which is the things that Safari is trying to make quick reference to. This would include suggested terms for commonly searched items.
When a URL or a search through Safari is typed in, or if it connects, does it leave a trace in different parts of the computer or of the phone?
Yeah, so when you actually do any search, you're going to leave traces. Now, it does depend if you are in private browsing or non-private browsing. So non-private browsing is what most of us use regularly. Private browsing might be what you elect to use. Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure like looking at your banking information. You may intentionally use a private browser. For Google users, this would be the equivalent of incognito in Google Chrome, and you may intentionally use that. And so the artifacts for that are more limited than the artifacts for non-private searches. So some of these artifacts only exist for non-private searches, and some exist for private searches.
And in this case, this phone, was it on non-private or private?
So specifically the two searches we're talking about, how long to die in cold and how long to die in CIKLD, excuse my differentiation there. Both of those searches were done in non-private browsing.
So they weren't hidden?
I don't understand the question yet.
Okay. Was there any applications on to mask those searches?
Not to the best of my knowledge. I did not see any.
We began with the 22740 timestamp. The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct. So I believe the next thing we're looking at is the 623 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask you.
Okay.
When you saw that, do you look on the same tab or a database? Where do you find that information?
Fair. Understood. So all of those databases I was just mentioning before, we're looking at all the parsed results from all of those, and I was looking in the entirety of the scope from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in the tabs for Browser State DB, Cloud Tabs artifacts, History DB, Mobile Safari plist, Knowledge C, each one of those, and then I was combining them to timeline out the activity.
At 62351, did you look into how long TIDIE in CIKD?
So that would be the next thing that we see after the Apple suggested term of how long to digest food. That's the next thing we see an entry of that. There's two immediately next to each other. I don't remember the precision on the seconds of which one's first off the top of my head, but one is in Knowledge C and one is in the Mobile Safari plist.
Can they appear in different rooms in the data bank, in different places, the same search?
Searches appear in many different places. They can leave traces, such as that Knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the Knowledge CDB, what Apple's trying to learn about you, as well as in that Mobile Safari plist, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD, CIKLD, CIKD, CIKD.
And finally, at 62447, did you identify any artifacts with that search that appears with the timestamp of 22740? Did you find the same?
Correct. At 624, we have two timestamps in the same two locations for how long to die in cold, the Knowledge C and the Mobile Safari plist.
So based on your analysis in that issue, did you come to an opinion whether or not the phrase "how long to die in cold" was actually searched at 2:27 a.m. on January 29, 2022?
There are no artifacts.
So the answer is yes or no?
Can you repeat the question, please?
And so based on your analysis of the phone and the data using all of those softwares, did you come to an opinion whether or not the phrase "how long to die in cold" was searched at that timestamp tab of 22740?
Yes, I came to an opinion.
And what is your opinion?
Objection, Your Honor.
Rephrase the question as to the opinion.
I'm sorry?
I'll see you at sidewalks, Mr. Lessing.
I knew it. How do I ask the question, Judge, to get the answer I'm needing if y'all are objecting to my question? How can I reword
God,
it?
they got to word it specifically.
Well, it's got to be. The defense is the one objecting, so I'm going to let him roll with his objection. They got to do it for they got a reason behind it. She's about to give her opinion.
They got to give her yes or no. So is it your opinion that this search was done at 27?
Give me your calculated, you just explained all the work behind what you did. So I don't need your opinion. I need your work product tells you it was searched at what time, you give the time and you're done. You don't opine any other. It doesn't matter what she tells me at this point. I'm not going to believe it and go to the bank with it. You know what I mean? She can tell me right now that search was at 6:23:51, and I'm not going to say, "Oh well, there we go, case solved." But
She'll give her opinion. We can write it down. And
exactly,
take it into
because I'm gonna tell you what, the
consideration.
next case that comes along, we might fall for everything Celebrate tells us, hook, line, and sinker. We have to remember that in these cases. I can't hate on them 1 minute and love on them the next. I gotta like, ugh, I still need to know you. I know none of their stuff's accurate down to a T. It was like location of a phone, so only within feet, right?
So she was about to say, because he's like, yes or no. She was about to say there are no artifacts that say it was.
There may not be.
The search was at
And there may,
2:27. So
well, there
maybe,
may
I
not
mean,
be if things were manipulated and deleted on that phone.
true.
That's where the
Yeah.
defense is wanting y'all to go with this. I'm the only one on board so far. That woman's phone was manipulated. Jennifer McCabe's. Who did it? I can't wait for the defense to come up here and talk about that more, because it's coming. Mark my words. That woman's phone was part of the conspiracy plan, and they needed to do some manipulations real quick, and they did them.
Yeah, because if she's on the stand saying I didn't make those I didn't
Yeah, I
delete
didn't do all
those.
that. My phone was just.
Maybe she didn't. Maybe it was
Well,
somebody
yeah,
else.
I mean, I'm not. If we're gonna go all conspiracy, I gotta talk about all the things. Y'all done heard me read her husband's background. I'm not.
Maybe Proctor did it.
Maybe he did, but maybe he didn't. He's just a pawn in their game at this point. He's on that list of all them conspirators. We can't have everybody in town being part of the conspiracy. I can't. It'll fall apart.
The only thing is, like, he went down, so wouldn't he take them all
Would
down
he?
with him? Because he got fired and disgraced. I don't
I
know.
don't know.
Unless there's other things they could do to him, you know what I mean? Ruin him in other ways.
All right, with all that said, if there was nobody to throw under the bus and take down with you, what if everything's true here? He was just a dirty cop with a foul mouth.
Could be. That could
right?
be too.
Why would you go down and take care and just okay, y'all can throw me under the bus. He threw himself under the bus when he crossed the line and began talking mad shit about, the defendant and texting nasty little messages about her. That's all, that made you just look even more sketchy, guy. That's on you, not me. But would he, they didn't get him like, oh, you're arrested on conspiracy. You're arrested and fired because you're a bad dude. But would he just, take that? I don't even know what his punishment was. Did he get to keep his pension? Hell, if everything's good and he got to keep his pension, what's he going to do? Just ride off into the sunset at this point, right?
I doubt it.
Depends on what he was actually terminated. Well, he was terminated, so there's probably all that to consider as well.
Initially, he was suspended, I think, without pay. So I don't know.
Yeah, Rachel, this lady's not telling lies. She's not part of the. She's not part of the conspiracy. Not that little way she's dressed. She's just up there giving you her data geekiness. But still, you run your own programs. To that, you're telling me you did it through Celebrite and Axiom, because I made note. I do know some cell phone stuff. I make note of the important stuff you're telling me.
Oh, Rachel makes a good point. Hank is definitely, the prosecutor is definitely trying to bring out as much dirt as he can until they get to Proctor. They're saving Proctor for the very last.
Well, the prosecution knows that witness is not. He's not good for them. So they're not wanting to. Somebody else pointed out too that. Are they trying to downplay Proctor's role this trial, right? Because they know they're going to catch hell when he comes out, when it comes out to the jury's attention, right? So you gotta pay attention to all that stuff, because it all matters in the big scheme of things. But was Proctor just another? Was he like the little EMT chick? We need another pot. We need it because here's the thing: when I kept trying to figure out why the state police were involved in a man on the lawn in a residential neighborhood to begin with, was baffling to me. Then once I understood why, okay, now we need somebody from the state police on our side to make this work. Was Proctor the perfect person because he already had ties to some of these people? That I don't know. Because you gotta, for a conspiracy to happen, people have to know each other and be willing to do things for each other. And you can't include everybody in on it. Somebody will break at some point. The pressure will become too much, and one of your 50 players is going to break. You keep it small, and especially if you think it's never going to go anywhere. No one's going to look at this, right? This is our little town secret. So if they want me to believe a conspiracy, they better bring me a good story, some receipts. They're sure trying. They're working on it, though. I'm telling you that. Hank is definitely trying to get everything he can in. Oh, yeah. They definitely changed up their witnesses this time around, from what I've heard from last time compared to this time. They're trying to lay the story out a little differently. It got confusing a couple times when they switched back and forth between witnesses on two things. And it's like, wait a minute, let them finish testifying. And will we hear from Julie Nagel today? Because Julie Nagel apparently is the only one to testify that she saw anything in the front lawn. She saw a blob over on the lawn. You know, when they were making fun of Jen for her peanut butter and bread in the car, and Jen was turned around facing the girls and never saw the yard and didn't see John. But Miss Julie saw something over there in the yard, according to her testimony from the first trial. Yeah, Hank was brought in for a reason. Y'all, that's what the prosecutor's job is, right? He's got to get, that's what they do. Oh, we got noise in the courtroom. Y'all hash it out. We good? Y'all got a PowerPoint that things she's done that y'all ain't even presented yet.
You've explained to us the analysis you engaged in and the process you engaged in. In forensic data analysis, is there a methodology that you use, not just looking at the printout of the programs, a methodology you use that is accepted in the industry for experts to analyze this data and come to your opinion?
Absolutely. Beyond looking at what was in the tool results, I further looked at those databases independently and conducted testing of the artifacts.
And in addition to what you did, can you share with us how and why this methodology is accepted in your practice as forensic analyst?
This methodology is accepted by NIST and by organizations like the Scientific Working Group of Digital Evidence. I'm intimately familiar as both a member of the Scientific Working Group on Digital Evidence, who helps work towards the building and development of these consensus-based documents of procedures to be followed in digital forensics analysis, and as a member of the National Institute of Science and Technology, NIST, Organizational Scientific Area Committees, OSAC, Digital Evidence Subcommittee, where we also produce guidelines such as the data set guidelines for generation, the guidelines for data set generation, which is how you do your actual testing and creation of data sets. And I was also a part of the subcommittee that drafted that. So I'm intimately familiar with the accepted policies and procedures because I am also a member of the groups that help author these, as well as review them and look and use them.
Are there articles and guidance in the industry about this particular practice of analysis?
For analysis, just for clarification, you're talking about for analysis of Safari artifacts, of mobile forensics, of browser state DB, just for clarity on the question.
Let's work our way through it. How about through Safari?
For Safari, there are multiple different blogs that talk about Safari, as well as I have analysis of Safari through classes I took, such as SANS 4508, which is their, 518, SANS 4518, which is the Mac and iOS analysis course, which I took.
How about the specific guidance regarding searching the different databases for artifacts?
In terms of methodology for digging into databases,
yes.
Is that correct? There are multiple, I've taken courses throughout my master's program courses on how to analyze digital forensics artifacts, including mobile device forensics, throughout my GIAC certifications. I've taken multiple instructor-led courses on how to do these, as well specifically that cover mobile safari history in mobile forensics at GMU in his master's program as part of the SANS 4518 class. And in terms of data structures, I've taken study on how to analyze databases like SQLite and PLIS are covered in those courses.
There are books on study on this methodology?
There are multiple books on digital forensics, many of which I've read, and including books specifically on analysis of SQLite databases, such as Sanderson's SQLite Forensics, which is probably the most authoritative because not only was it written by Sanderson, who makes a tool, it was tech edited by 3 renowned forensics examiners, as well as Dr. Richard Hipp, who created SQLite itself.
The methodology, the technique you use to look past the reports and actually look at the data to make your determination and arrive at your opinions, is that methodology regularly accepted within the forensic data community?
Absolutely. Again, using the methodology from the consensus-based documents from the community, from the Scientific Working Group Digital Evidence on best practices for analysis, as well as specifically for the SQLite databases I was looking at. I do that deeply verifying and in accordance with the understandings from Sanderson's book.
Now, you share with us that you had an opinion regarding the timestamp and whether that it was applicable to the search term, "How's long to die in cold?"
That is correct.
Now, I want to ask you, to a reasonable degree of forensic data, scientific certainty, what is your opinion about whether the phrase "How's long to die in cold" was made at the time of the timestamp 22740?
It's the last time Mr. Massey on this issue, okay? Yeah, he can really get this on cross. Let her get it out, and then you come back and cross to dispute her findings. Or the judge should have just kept her off the stand, because I'm done. They're aggravating me now. Can't be fooled by this one lady's opinion.
Didn't they just have a sidebar for this stupid issue? What is going on?
2 back-to-back. That's why the judge said last one. What are you doing? Get her on cross. I mean, she's there to give an opinion.
Yeah.
Either way. So let her get it out. Doesn't mean we're going to
said
believe her.
he wanted to cross-examine her, so go ahead, go for it.
Yeah. Don't be afraid. You're making me feel some kind of way right now.
I know.
Right? Don't do that. Don't make me feel some kind of way, darn it.
Right.
We're trying to be on board. Butterfly's gone to pick up lunch. Be safe out there, girl. Getting me something too. I'm starting to get hungry. I don't know what I want. Do I want a sandwich or do I want to? I don't know. I'm eating salads. I get on a salad kick, girl, and like all I want's a salad. Like a really good. I make really good salads at home.
Yeah.
I don't play around with my salads. I throw all kinds of stuff in there. I can make that a whole meal. I don't know what I want this morning or this brunch time, lunchtime, whatever time it's coming to be. They need to let her get on and finish up her testimony, and they do their lunch break and come back and let them have at her.
Right.
What in the world? I wish I could get food delivery out here because I think I'm feeling a Subway sandwich.
I know, I do too. I'm afraid to try.
Nobody gonna deliver to me out here.
There's been a few times when Amazon dropped off at my doorstep, so I'm like, oh.
Oh, Amazon will deliver out here all day long. My son's is Amazon ordering full. Amazon's got no issue with where I live. Just the people who deliver food do. I'm really far away from all the restaurants. My stuff would be cold when they got here, so I'd have to be picky about what I ordered anyway. Yeah, they brought that up, Rachel, that was the whole defense issue, that she was kept out of the Maryland court on a Daubert hearing. But whatever that issue was about is not what she was testifying to here. See, that's the difference on why the judge allowed it. And you can get her on cross concerning her credibility type thing, right? So every time she goes to give her opinion, though, about this damn time search, here they go stopping her. I need to hear it, regardless of what she's got to say. It's not going to make or break the case at this moment. It's part of my consideration in the delivery room. So I have a problem when defense attorneys argue real hard to keep an opposing expert out, right? If I got a problem with it in Koberger's case, why not have a problem with it here? I try to be fair on the law. So I don't know what's going on with these people. Unless they're terrified the jury's going to bank it all on what she's got to say about this stupid search. I want the defense to come out and talk about phone manipulation.
All right, go right ahead, Mr. Brennan.
I'm now going to ask you for your first opinion. So you shared that you have an opinion about whether that timestamp 2:27:40 was, whether or not that was the time the search "How Long to Die in the Cold" occurred. Can you tell us, to a reasonable degree of scientific certainty, your opinion about whether that search, "How Long to Die in the Cold," occurred at 2:27:40 a.m. on January 29th, 2022?
Same objection, Your Honor.
Okay, the objections are overruled.
What I can state to a scientific degree of certainty is that that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
Do you have an opinion, to a degree of scientific certainty, whether there was any other searches similar to "How Long to Die in the Cold" that evening on that tab?
Objection, Your Honor.
I'm going to allow it.
May I first inquire, you meant morning, I
I'm sorry,
assume?
that morning, yes.
Just clarifying, I did not look at evening searches. And can you repeat? I apologize. I disrupted my own train of
Do you
thought.
have an opinion, to a reasonable degree of scientific certainty, whether there were any other searches on that tab before the final search at 6:24:47, "How Long to Die in Cold"?
Same objection, Your Honor.
Overruled.
Just ensuring that I have the question correct.
Please.
You're asking if what else occurred in that tab prior?
Yes.
That I cannot say with a clear degree of certainty.
Did you develop a chalk that I showed
did.
you earlier?
Yes.
Like to approach?
Yes.
Again, I show you. Same document, you recognize it?
Yes.
What is it?
It is the exhibit that I created that was labeled Table 1 in the first report I had delivered.
And does that provide information that will assist us in understanding your opinion?
Yes.
I'd move, subject to redaction, that this be introduced into evidence.
Your Honor, I have no issue with regard to the redaction aspect, but consistent with my prior objections, I would object to that as well.
Okay, I'm going to allow this into evidence. You're right to say it, Mr.
Thank you, Your
President.
Honor. Appreciate it.
Exhibit 82.
Madam Clerk, 82?
Exhibit 82.
Thank you. With the court's permission, I'd like to show Exhibit 82 to the jury.
Okay?
Could we enlarge the first two? And we're going to need to get the right column in if we can, please. Thank you. Ms. High, can you see it from there?
I can. Thank you.
If you can walk us through how this exhibit assists us in understanding your explanation and the basis for your opinion.
This exhibit shows the Safari artifacts and artifacts of Google searches in Safari related to the two searches in question, How Long to Die in CILKD and How's Long to Die in Cold, that occurred on the morning of November 29th, 2022 on the device under examination.
If I look at this chart and I see in the top left it says 2:27:40 a.m. and then under the search term it says How's Long to Die in Cold. How do I understand your opinion that that search didn't happen at 2:27:40?
This document is showing you the data that is the parsed result. The source of that artifact that you see in the last column is a little bit cut off, the browser state db-wall file. That database does store how the data is stored, the search term How's Long to Die in Cold with an associated MAC absolute epoch timestamp that translates to 2:27 a.m. That is what is physically stored. That does not annotate the meaning of that artifact. That was determined through testing following the NIST OSAC data generation guidelines for testing.
In the second row, we see a timestamp on the left-hand column, 6:23:49. And it provides artifact, the cache record. What is the term, and what does that mean under the search term?
iOS Safari cache records. A cache refers to something that a computer program wants quick and easy access to. When we search on our phones, anything, a lot of times, be it in Google or in Safari, depending on what type of phone you own, it'll suggest what it thinks you're going to type in, right? So you can click it. It's trying to be helpful. In this instance, at 6:23:49, we have a cache record that indicates that Apple suggested the phrase, how long does it take to digest food?
And then under that, 6:23:51, it appears it says a recent web search, and the spelling is changed. How long, TIDIEINCIKD.
So this, in reference to these two search terms, this is the first actual search that occurs at 6:23:51 a.m. Upon beginning the typing of that phrase, Apple provided the suggested search, and the person inputting into the phone at that time continued to type out a phrase and finished it as how long, TIDINCIKD, which that is available to us in the Mobile Safari P-list, which tracks recent web searches. And then we'll see 6 seconds later, we get that reference in that Knowledge C database that I mentioned before. That's the next line. So that's the Knowledge C database is Apple's way of keeping knowledge about what the user's doing. It sees and holds your knowledge. It's an easy way to remember it. That's what I teach my students. So that Knowledge CDB tracks a lot of things for predictive purposes. And so 6 seconds later, it's logging that same search. So that search is being tracked in 2 places.
And so one search can be left as artifacts in different locations on the database?
Correct. There can be multiple traces or artifacts of the same user action in different places on a mobile device.
And if we go down to the bottom, the last column, at 6:24:47, we again see How's Long to Die in Cold. And if you look in the first column, it's the same phrase. Is that a coincidence that it appears at the bottom at 6:24:47 and also appears up at 2:27:40?
As mentioned before, through testing of the artifact for Browser State DB, that artifact will hold the most recent search that happened in the tab. So it is logical that How's Long, HOS Long to Die in Cold, was searched at 6/24/18, tracked in that mobile Safari P list, repeated in Knowledge C, Knowledge made its tracking in Knowledge CDB, and then that table for Browser State DB, which again has the time that the tab was opened, or the last time it was backgrounded, and updated just the website that was visited. So the website, that is why we get that 227 time. That's actually, as far as the data storage is, the first thing I have in there, because I want to put it in chronological time order for exhibit purposes, is actually the last thing to happen because it's the update to what's in the tab.
You offered that the How's Long to Die in Cold is the last thing to happen. Do you have an opinion to a reasonable degree of scientific certainty the time when that search was made?
Objection, Your Honor.
To a reasonable degree of certainty, I can say that How's Long to Die in Cold was searched at approximately 6:24 a.m.
Now, moving on from the 227 search, there are two other issues that you were asked to analyze. And we talked about them at the beginning. Let's begin with whether or not you looked at the data and analyzed the data and came to any opinions about whether that phrase, How's Long to Die in Cold, was user deleted on that device.
So there's two really key elements as to if that was user deleted. If the question is, did I come to opinion? Yes.
And can you explain how you came to an opinion that we'll ultimately share with the jury?
The first line in that exhibit, the ending of that, if you remember, it said browser state.db-wall. That's important, so we'll talk about that in a second. But the first thing I want to bring up is kind of how the database works, because I didn't just look at the tool result. I extracted that database and I did a deeper analysis on it using Sanderson's tool, because that information was in that -wall file. So when a SQLite database, which is a specific way of storing, very, very common on mobile phones, actually one of the most common, when that database stores data, it has two versions. The most recent version, and the version in use here, uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant and we're sitting at a table and we're ordering food. Our table is the table. Data is going to come to the table, and that's going to be our food. So when we order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table. The chicken sandwich, the burger, and the pizza, the kitchen puts it in the warming area. It's the write-ahead log. The server grabs it from there. It's where data sits before it goes to the table, just like your food goes to that serving station before your server brings it to your table. Server brings it to the table. That table's got its burger, its chicken, and its pizza. Another table orders waffles and pancakes. They think it's breakfast. The waffles and pancakes are made by the kitchen. They're put on the serving area. The waitress comes over. This pizza has pepperoni. I don't eat pepperoni. Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion. Pepperoni pizza was just removed from the table, right? We're deleting it. We're moving. We said it's not what we wanted. The waitress is removing it. She brings it back to that serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table. That's how a write-ahead log works. Any changes that are happening sit in the write-ahead log until the database is closed, and then when it's reopened, all those changes are made, both additions and deletions. So often when a phone is imaged, when we make a forensic image, the applications are still open, so we have those WAL files. When we look in our Safari browser, the database knows to read it to you in its current state. So it tells you where the waffles and pancakes are going. They're going to that table. So it shows it as if it's in the table. But it's not in the table yet. So if when we parse the data and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger. right? Pizza got sent back, waffles and pancakes haven't come out yet. So when we get the data, we get two files. We get the restaurant, that's the database, and we get the serving area, that's the wall file. Just because it's in the wall file does not mean it's deleted. It means that that record wasn't where it naturally sits yet. It could be that wall file can contain deleteds and food or data that hasn't yet been delivered to the database. So the wall file consists of both. So an assumption that the data was deleted just because it's in the wall file is actually not true. And the peer review paper I mentioned earlier that I had accepted in Forensic Science International actually has a section that explains this exact presence for SQLite databases about how we refer to that as recovered and not deleted. Actually, through that entire document, we don't use the phrase deleted. We refer to things in statement of recovery because we need to determine why it's there. So we can't say that it's deleted just because it came from the wall file. Some tools will automatically indicate to the examiner that they need to dig deeper into that. I did do further analysis by looking at the wall file. That particular item and it's a little bit more complex, actually exists on multiple pages because it moves as the database is being created, but all of them have the same unique identifier. So it's the same entry. It's not more than one search of Ha's long to die in cold. If there was more than one search that had occurred where it became the top element in that database, we would see that. There are, as I mentioned, other carved from the database, from the wall file elements such as the search for the YouTube video, It's Raining Men. Because at some point that was the last viewed item in a tab when that tab was retired right before, also at 2:27 a.m., but a couple of seconds before the Ha's long to die in cold search. So we can see that that table is put to the rear. The newest tab that's open, which is why it's in the wall file, it's the most recent thing because it's like our waffles and pancakes hasn't been delivered to the table yet. So it can sit in the wall file for that reason. It doesn't indicate it's deleted. The second reason is there is no user interaction in the interface to delete a tab. You can open and close a tab, and open and close tabs are tracked in that database, but you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in the interface. So it could not be deleted by a user through the interface for that most basic reason.
So a user, could they delete a tab if they wanted to?
There's no actual option to delete a tab. For your web history, you could clear the cache, for example. Most of us are familiar with clearing the cache in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete it. But you can't delete the tab history. It's just what tabs are there. The device is tracking that.
When you looked at the software, whether it was Axiom or Celebrite, when you look just at the report, not the data itself, do either of those reports have any indication noting that that web, that Safari search is characterized as deleted?
The tools, Celebrite denotes it with a red X, which means that it is recovered. Axiom indicates that it is carved. In the same paper that I referenced earlier that I authored, there's a chart in there that shows the distinction between how different tools, some will use red X's, some will use question marks, some will list carved or parsed, so every tool chooses to do that differently. That does not mean deleted, it means it needs further analysis.
Should an examiner who looks just at the reports of the software assume that if it is marked as recovered in Celebrite or carved in Axiom, should
an examiner should never assume something's deleted without doing a manual examination.
The manual examination, is that a method that's used, that's generally accepted in the forensic data field?
The NIST Science Foundation paper, as well as the data set generation guidelines, both speak to conducting testing to verify and validate, and it states clearly that an examiner is to verify and validate findings and to determine meaning.
So given that you've used multiple tools to look at reports regarding this phrase, how long to die in cold, and have seen indications or characterizations of recovered and carved, and in addition to the fact that you actually analyzed the data, did you arrive at an opinion to a reasonable degree of scientific certainty whether or not the user deleted, any user deleted the phrase, how long to die in cold?
Yes, if it's how's long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an opinion to a reasonable degree of scientific certainty whether any user deleted the phrase, how long to die in cold?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
Finally, I want to ask you about your analysis of the phone records on this phone attributed to Ms. McCabe. Did you go through an analysis of the phone logs and the phone records on the phone?
I analyzed the call logs and the phone logs on the device that I was given, that I was told belonged to Ms. McCabe, yes.
Would a suggestion or a claim that a user deleted irregularly a number of phone calls, would that be accurate or inaccurate in your experience?
It is inaccurate in this instance.
Can you explain to us why and how you came to that conclusion?
Yeah, this is actually really interesting because of what it appears in the forensics tools and additional artifacts that I looked at that are not parsed by the forensics tools. So the call logs, when you look at it, it appears, I don't remember if it's 8:57 or 8:59 a.m. in my mind at the moment, but approximately either 8:57 or 8:59 is the earliest phone call we see on the 29th of January. We see no call logs before, but we do see FaceTime logs before. So if an examiner, again, was making assumptions without testing or reviewing, the first assumption might be, well, things must have been deleted because there's data that exists before, but not current data. So then you have to go, how do phone logs work? And again, create test data and review. What the situation here is that there are 3 types of call logs on this particular phone. There's regular calls, incoming and outgoing. There are FaceTime video chats, incoming and outgoing, and FaceTime audio chats, incoming and outgoing. The storage for that is actually 200 records. So you can only store up to 200 of each. Now, if you were a user of, let's say, WhatsApp or Signal or Telegram, those would each count 2 and they'd get their own logs. So when we look at the database for the number of calls between 8:59 a.m. or 8:57, again, I apologize, I'm not looking at that precise time, on the 29th of January in 2022, there are exactly 200 calls still in that record from then until the imaging of the phone. There are 199 FaceTime video calls and only 27 FaceTime audio calls. So the question is, how do you validate that that's what's happening? So we actually have call logs that we can pick up in other places for recent call logs in the last 7 to 30 days, depending on the exact version of the device and how the biomes are running. We can actually see incoming call logs, the number they go to, and if they're incoming or outgoing in the biomes. So we actually can see the history going back for the entirety of that day on January 29th till midnight. Again, my scope was from midnight until noon. So we can actually see all of the calls. They're just not all in the call history state DB. Now, the call history state DB, from a user perspective, that button on your phone doesn't say call history. It actually says recents. And what it's determining as recents is the most recent 200 of each category. Now, how did I determine this further? There is a running log that exists in a phone. It lasts about 3 days. It's called the unified log. The unified log tracks multiple things that are happening on the phone. In manual analysis of the unified log from this phone, I can clearly see each time a 201st call comes in, the 200th call gets deleted. So it's constantly just the last 200 calls. It may not be typical that we see 200 calls in 3 days, but on this device, we do see 200 regular phone calls in the 3 days between 8:59 a.m. on the 29th and when the phone was imaged.
Do you have an opinion to a reasonable degree of scientific certainty whether there was any user deletions from the phone call log that morning?
Yes.
And what is that opinion?
The opinion is that I can see that it's done by the device itself utilizing unified logs, that the system is deleting the 201st call every time a new call is received or outgoing.
Thank you. I have no further questions.
All right, can I see counsel at sidebar regarding scheduling and a few things?
Scheduling and a few things. Hold on, lady, I gotta write something down.
What do you think of that last opinion there? I don't know.
About
the 201st call is being.
There's some manipulation happening on Jen's phone. They're just trying to dance around it. The prosecution is.
Yeah, I'm not
tell us she didn't see any deletions, no activity of that. And then she's tried to explain away how she, determined the search was done on an open tab, which we established in the beginning of the trial. I clearly understood where y'all went with that, Mr. Prosecution. Y'all opened the window originally at 2:30. It was sent to the background, blah, 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 reopened back into the foreground at 6:30 or whatever the exact time was. Got it wrote down. I know the exact time. Just not looking at my paper right now. So, yeah, I don't know. Still need to hear from the other expert. I understand exactly what she told me, and I understand how she made her conclusion. I don't know that it's wrong, because here's the thing. To me, this Google search doesn't even matter anymore, because the man was, if they want me to buy the conspiracy story, I believe the man was dead when placed in the snow. So why would they need to even worry about how long it takes to die in the snow?
He wasn't declared dead until, I think, 8 a.m.
I know.
But yeah.
He wasn't found till after 6 a.m. But I'm telling you, they didn't partially kill him, in my opinion, and then put him out in the snow hoping he'd die out there.
Mm-hmm.
I think he was dead when he was put in the snow. If I'm buying that conspiracy, he was killed in the home. So if we killed him in the house and we put him out there, is that search conveniently done after 6 a.m. while she's running around screaming, I ran over him, I ran over him, I ran over him? Yeah. Search is irrelevant to me at this point.
All right.
I agree with that.
I'm going to let the jurors have lunch.
Except the next expert, of course, I do want to hear from that person.
Thank you, Your Honor. Thank you, Your Honor.
We'll recess for 45 minutes.
All right,
Bev, I'm trying to snack. You would. Yeah, well, she's always interrupting somebody, isn't she, Rachel? It's time for lunch. We got to let them go have their lunch. Maybe they won't be all hangry. That lady was nerding out on her scientific data stuff. A lot of judges are going to do that. Wait till you see what happens to Ann Taylor with Hitler. I'm looking forward to hearing his cross-examination on this lady, though. And I need to go back and find out what that Daubert hearing was about her. What particularly was kept out of her other court case.
That's a good point. It would be interesting. Mm-hmm. Did they just go to lunch, or is this just another?
No, they're at lunch. Jesse. Hold on. Oh, yeah, they're at lunch. That's why they stopped everything. Hold on, my chat won't come up. There it comes. There we go. Man, I wonder what the defense can get up there and argue about because these phone deletions are important. If it sits in a place where things that are deleted are supposed to go to, and then you come out and said, well, it can just sit there. And then we went into your teacher mode, came on about the restaurant explanations. Did that help y'all? So we got something sitting over here in an area where deleted stuff would sit. But it doesn't mean it was deleted. You got to look deeper. So she did, and then determined it was never deleted. Okay, I still need to hear from the other experts. Tell me why that may not be true, right?
Yeah, it's her opinion. I
Yeah,
need
it's
more
an opinion.
opinions. And I
Yeah, I
need
mean,
experiments. I'm sorry, I need to see it done in practice
she
to make
talked about we
make
need
it
to
make
see it.
sense.
Well, okay, so we know. Hang on. Here's what with that statement. Let me ask you this: do we need every expert that testifies? I totally get it because we had sketchy shit in Delphi with these so-called experts. But are we at a point where we have to get them to record everything they did, including all experiments? Are we prepared to even understand what they're talking about? That's what I'm wondering. So what would you need to see from her for her to make you believe it? I'm legit asking because I really would like to know. What does cell phone people need to show us that makes us believe them,
I
right?
want you to open a Safari browser,
Right.
not make a search, close or not close a browser, but close the phone or whatever. And then hours later, open that same browser, make a search, and then do data forensics to see if this is true, what she's saying. That's all. It's not.
I know it's not hard, but she talked about that though. Didn't you and Dolphin kind of do a little experiment too about stuff like that, opening the browser and but it doesn't show us the time when it's reopened, right?
I don't
You got
think.
to go into the data to look at all that stuff.
Yeah. Mm-hmm.
You have to. But she talked about how all the things that got her to, yeah, it was all talked about there. It just it's so technical, it's not coming across. You know what I mean? That's her up there explaining her stuff. But she talked about that, of how they get there to determine that, about how you open the tab, it just moves it to the back. That's why she was explaining all of that. That tells you how she got there. That doesn't make it accurate. She's not the only expert in the country, you know what I mean? And you're not the only data expert to come in here owning your own company and your own software. You're not the first one, lady. We've got experience in this. We know you people, you know. What do you guys think in chat? Do y'all believe her cell phone data is accurate? Was this search ever conducted at 2:30 versus 6:30? Will we ever find out? Does it even matter anymore? It matters if you want to make Jen look bad. It matters if you want to show that phone was manipulated, you know, at any point before they received it, because they didn't get the phone till what, days later after the incident occurred, after the group text was already formed and everything.
I don't know when they got the phone. Proctor must
Oh,
have
I
got the
got the
phone later
dates.
the day.
It's
But
written
she
down
downloaded
February.
the download was February 2nd.
February 2nd is when they got the phone. They met, what's his name, met and collected the phones. Hold on, I'll tell you what time he met with them.
On the 29th.
It was, oh, that was when the first piece of glass was found. Hold on, where'd my note go on that dude that testified to that? He was the cop that was there that met
Gallagher?
with I think that was his name. He met with Jen and Carrie and took their phones and they signed consent forms. Oh, I think I moved that paper
No,
over
it
here.
wasn't Gallagher. I don't think that was Gallagher. Ooh, I don't
No,
remember.
it was. Hang on, I moved my two. I've already three or four
O'Hara?
pages. Hang on, let me read my note. I've had several pages of notes just this morning alone. I've tried to highlight and make notes in the corner of stuff that I need to just can refer back to quickly, but there's so much here. I've really got to sit back down and go through this stuff. Where'd it go? O'Hara was with the CERT team.
Okay.
Yeah, it was.
Yeah, for us.
Hmm. Like, I think I feel like I'm missing a whole page. Okay.
I don't know. The whole thing just creates doubt in my mind because I don't know. It's just
What so far has created the biggest doubt in your mind? Doubt that what she hit him at all?
what with this particular witness or everything.
Oh, all of them. You doubt all of them. So
Oh,
I don't know which one
yeah.
you're talking about. So, like this lady,
This
what
is
makes
just another thing that adds doubt to me. Like I don't know. I can't say for sure. Maybe she's right. Maybe she's wrong. I don't know.
well,
But
that's
even the doubt, even the
yeah.
question that she may have made that search at 227 just is like I just don't. I don't know.
Well, she just tried to explain why it looks like the search was conducted at 2:30 versus the 6:30. Um, y'all got to hear from the other when the defense, if they bring in an expert, pay close attention and take notes. That's because the lady just went through the whole thing of how she got there, whether or not it's within limit. You know what I mean? What are your limitations on this stuff? So that's why I need to hear from the opposing expert. Like you're gonna have a cell phone guy come in and say, "Well, we can pinpoint the location. They were right here." Excuse me, how many feet within that home were they? That's what the defense attorney's job is, right? You can't place my client in that home. You can place them within 10 feet, but you can't place them in there. And if I'm willing to buy into Celebrate's data in other cases that I follow, am I ready to say, oh, their shit's trash? What I don't agree with is that other guy that testified, Firefly, where he's the one that decided what data Celebrate would look at when they left out the deleted stuff, right? That he
Yeah.
talked about in his testimony. That stuff is fishy, right? And
When did they do that? Because they did remove some stuff, right?
yeah, I got notes on him too. I took like 3 pages on that dude because that dude testified forever. Like, I really gotta, y'all, I got a book going on here.
Oh, I know. He was
I'm not
boring.
even joking. And I do have to sit down tonight and tomorrow and really get a grip on these notes, especially I'm going to go over to Shorty's and run my mouth on Saturday. I got to know what I'm talking about. I don't like coming in hot and blind. Ugh, that's scary. Reasonable doubt meter is climbing and just going to get worse. Yeah.
I know because there's so
Yeah.
many issues. The phone, the
Too many issues.
the broken pieces. Were they really found or were they planted? And then
Yeah.
it comes to his injuries. Were they really by the car or was it a dog bite or is
Or
it
human.
was yeah, there's just so
How
many
come nobody
issues.
saw John's shoe by the curb all night? I got problem with that. Oh, I know why. Because nobody saw Karen hit him. Everybody left the house. Nobody saw the man. They weren't sure not were looking for a shoe, were they? But y'all could have seen that shoe
Well,
the
maybe the
next morning.
snowplow. I mean, I don't remember exactly where the shoe was found, but
I
what
know
could
they
the
testified to it
snowplow have
yesterday. You know exactly
buried it?
where it was found.
But
No,
could the
it
no?
was. They showed the picture of it in court again this morning. It's
Yeah.
laying there right beside the 6-inch berm. It's black with a big old white Nike check
Did
down
they
the
have to
side.
dig it out though?
No, not according to the picture they showed me. You can see it laying there.
Huh.
When the snowplow, which also means with the snowplow came and throwed snow, that he uncover it. It's weird. It just happens to be laying there next to the curb with a few tiny pieces of taillight around it. Right there at the 6-inch curb. So the next morning when y'all arrive on scene, nobody sees it then either. When was that shoe found? When y'all came back to an unsecured scene to do your little grid search? That's when they found the shoe. They just testified to all that in court. Made notes about it. And that's why I was like, wait a minute, I thought this shoe was up by the fence. You know, that's what
Yeah, I
I've been
remember.
hearing for 2
Yeah, I remember
years. Shoe near fence. I couldn't have got there. It couldn't have flung all the way. Okay, I was believing everybody. But I'm finding out that it was really by a curb. Like, I don't even know anymore. That's why we need trials, right? Show me the pictures of your evidence. Where would you, before anybody touched it, where was it found?
That's what I'm
Memorial.
saying, Rachel. Did the plow move the shoe or bury the shoe? And that's why they
Or
didn't see
uncover
it.
it. Or uncover it.
Or uncover it. That's true. I'm sure they plowed more than one time. It was
Well, when you
snowing
ride by with that
previously.
plow, it's kicking. They said they testified to that in court. The plow kicked the snow up, but part of it was still in the road and part of it was over the berm up into the yard. Not a giant mound up in the yard, partly in the road, partly up on the lawn. Y'all need to go back and review that man's testimony.
The plowman probably will testify because he didn't see any
He didn't see
bodies.
anything. Mm-mm.
I think he'll testify. There was that car with that Ford. What's that car that I was there at like 3 a.m.
I'm going, when I say that shoe was found where it was found, y'all, my conspiracy brain is turned on. Somebody put the damn shoe out there. Y'all let me have my moment.
Maybe.
Or, okay. How else would John O'Keefe's shoe get to a curb if he wasn't hit by a car that knocked him out of that shoe?
True.
If I'm to believe that shoe ended up on the street by the curb after he was harmed in that house and carried to the... We gotta make the story make sense, y'all. Or I can't do the conspiracy. We can't get caught. It's got to semi make sense for us to, pass it off.
I don't know. Unless they solidify something. Yeah, there's too many questions. If I was on the jury, I could not convict. You know what I'm saying?
At this point, heck no.
Yeah.
There hasn't even been any evidence established that anything was done on purpose to start with yet.
Right.
They haven't established that with his murder charge.
Oh, but Salty, she said, I hit him, I hit him, I hit him. He likes to say that all the time.
I say
I
a lot of
hit him, I hit him.
I say a lot of things I may not act on. I've learned not to say them on text messages or voice.
Yeah, I know.
Don't do that.
No.
Lock your doors and don't leave shit on a voicemail or a text. Say it in person.
Yep.
And don't delete the calls. I own what I say. If I'm not scared it'll come out later in court, I will text it. I don't care who sees it. I'll tell the judge myself, yep, that's me. I won't lie. I'll tell you why I did it. Then I'll go for my psych eval. Make sure I'm okay. If the plow moved the shoe, the shoe was literally against the curb. So I feel like, if anything, it uncovered the shoe, right? It may have moved it down somewhat, down the street a little bit. If that thing hit it, the plow itself could have moved it down the street, but it would have kept on moving it if it ever touched it. It wouldn't have just stopped and fell off. You know what I mean? I have to use my logical brain and start thinking, how would this have occurred? Instead of just saying, oh, yeah, that sounds good. No. I got to make it work in my head or it's not going to work. Kind of like them tunnels in Idaho. I don't know who's testifying on the defense as an expert. Let me look at something.
Well, Dr. Wolf, Dr. Russell.
No, I meant like, I'm sorry.
For
I meant like
phone?
cell phone extraction.
Oh, I don't know.
Yeah, I know Dr. Wolf's coming in. We got their list. We got the witness, or we have the witness list. We're going to take a look at real quick.
Mm-hmm.
Witness
I think this lady, though, I think she went a little too far. Like when he asked, what's your opinion as far as was this call or text message search, whatever, made at 2:27? She said no. They should have just stopped there. Stop talking.
Yeah, I mean, still, if they're scared that woman's going to convince a jury Karen Reed murdered that man based on that one text, then I question the defense. Because we can't base it on that one text. I can't base she ran him over because she left him a messed up voicemail.
Yeah.
So they need to come. They got a lot of convincing. I'm ready to evaluate all the testimony that comes down. That doesn't mean I'm swayed by it, because I offer an honest opinion on what I'm seeing. You know what I mean?
Yeah.
And I think that's a dangerous thing on these YouTube streets. If you're not part of the crowd, you're out. just because I bring out or choose to look at this at a legal standpoint and evaluate, I try to be fair about all of it. Doesn't mean I'm buying it. You know what I mean? It just doesn't. I'm trying to get down to the defense witness list. That still, I believe, is. Oh, let me do it this way because that's okay. Maybe I passed it because they had interesting people on their list as well. What in the world is going on here? Okay, that was the prosecution. They still got Aiden Kearney on there. We already heard from Levinson and Mason. Okay, that was the girlfriend. We should be okay. They're calling Canton Fire, law enforcement, lab witnesses, experts, defense attorneys. Okay, here we go. Defense list. These are the civilians that they're going to be listing here first. You got your Brian Albert, Caitlin. We went over this the other day. Christopher Albert, Colin Albert, Julie Albert, Kevin Albert, Nicole Albert, Michael Wagner from Foxborough. I don't know who he is or what his deal is. All these other people. Okay, so let me try to get down to their experts on the defense side. They're calling John O'Keefe Sr. Experts will be Chris Van E. I gotta Google these people. I don't know who none of them are.
Richard Green.
Forensic resource guy. Okay. Whoa, what is that? Close. This Chris Van E. Is that how you say that?
I guess.
According to my search, he is impact biomechanics accident reconstruction guy. Ooh, bring it on, Mr. Chris. And then we got Richard Green of St. Pete, Florida, down there near you, girl.
Yep.
Who's this? What's his name? Richard Green? He's not a film director. Well, he could be. I'm getting some actor guys popping up.
Richard Green, yeah, pretty
sexologist.
common name.
There's a one.
Oh no!
Sexologist. Oh, good lord! They're not bringing a sexologist expert in, are they? To explain toxic relationships. I don't see anything on this guy, so I don't know what his deal is. We know who Wolf is, right? ARCA guy.
Yep.
Andrew Rentschler.
Oh yeah, we saw a little bit of him too with Wolf.
Is he one of the crash experts as well?
Well, he was also in that hearing. Remember, he had a short testimony.
Oh, in that hearing they held before the trial.
Yeah.
On the letting them or their admissibility or whatever.
Yeah, that was Dr.
He is an ARCA expert. According to Google, he is an ARGA expert.
Yeah.
Maggie Gaffney. Okay.
Bonita Springs.
Maggie. And Gaffney is with a company called Teal Technologies, digital forensic examiner with 25 years.
Oh, okay.
Out of Florida, girlfriend. She one of us.
This is who we want to hear. We want the defenses.
The Florida lady. The Florida. Yeah. Get rid of them data dudes. We need a data chick. We want the data chick in.
Well, Florida. We did. We just had a data chick. Hide.
Well, she was a salt shaker.
Yeah. She did.
You said that in the comments. Did you see that earlier?
Yes, I did.
I was like, that was so cute. Like a little mushroom top lady. All right. Okay, so Miss Gaffney is a data expert out of Florida. We have Derek Ellington. He is a senior consultant, CFE, ACE, CEDs. He is a digital forensic investigator.
Okay, he's a good another one on here.
All right, now Michael Easter out of Los Angeles. Oh, we got a slick guy coming in. Oops, come back here. Michael Easter. Okay. See if we can find anything on him. He's an actor. No, I don't. That's what it pulled up first thing. Well, this one dude travels throughout the Arctic and the jungles. I don't know if it's him. Don't think it is. I'm not finding anything on this guy.
Michael
No,
Easter?
Michael Easter, I mean, I'm finding things, but they're not his.
Right.
He's not, I'm not thinking he's an actor or this jungle traveler.
Doesn't help that it's Los Angeles, right?
I know, right? You could be like a 50 million of them dudes doing all kinds of weird stuff.
Expert
All right.
witness trial consultant. I found him.
Yay, look, when I can't succeed.
Retired FBI special agent with over 20 years of investigative experience and over a decade. Gotta open it, sorry.
Retired FBI?
Yeah.
Awesome.
And over a decade. Where'd it go? The rest of it disappeared.
Wow.
Well, anyways, he's
he must
over a
work
decade of experience as a national asset with the cellular analyst survey team. Cast.
Oh, we got cast.
There
We got cast. We just got excited. Remember that name, Erickson, when it comes up. We know he's cast coming in. We need to hear about some cast, don't we?
Not Erickson, Michael Easter.
Oh, Easter. I'm looking at Erickson next. That's right.
Yeah.
Okay, I'm pulling up. He's an actor too. What do you see? Oh, research and training. I don't know if that's accounting and information system. I get a pastor. Yeah, I don't see anything on him. Maybe you can find something. Oh, there's a LinkedIn.
Michael Eric. Yeah, that's kind of where I went. LinkedIn.
Yeah, out of Columbia University, that young guy. Looks like Mark Zuckerberg a little bit, but thinner. So I can't find anything on him, guys. There's another Matthew Disorga.
Expert damage specialist in damage EDR infotainment restoration and extraction. EDR
Infotainment. Hold on, I just pulled the same. Did you pull up something on Reddit?
Yes, Geek Out Monday.
Heavy. Okay, it says Matt Disorga appearance speaking on event data recovery heavy vehicle importance in collision reconstruction.
Awesome. Okay, that's good. That'll talk about
Bring on them damn good experts.
I want to know,
right?
Because I was asking about that. Doesn't her car? It's a relatively new car. Like, didn't it have an event?
Girl, it was a Lexus. It was a new Lexus. You know, it had the latest capabilities were on board. And you know, Karen Reed paid for any subscription she may have made.
That's a good one right there.
Are we feeling better?
Because if you hit a 180-pound man, you're gonna trigger an event. Don't you think?
Yes. And if you're gonna back up 60 feet, 80 feet, whatever it was, until you slam into somebody, all that's gonna be recorded on the event data recorder thingy.
Okay.
So now we got
Matthew Disorga. That was him. Okay, cool. I'll try and look at Matthew Erickson again. Or is it is that the one you couldn't find?
Yeah. He's out of Michigan.
Yeah.
I'm looking up Dr. Elizabeth LaPasta now. While you do that. She's a Rhode Island medical examiner. Oh, hell, I need that. I need a good medical examiner.
Oh, yes, definitely.
Rhode Island's just across the line from them. So I want to hear from her and what her opinion might be as to those marks on that man's arm. I'm willing to listen to their reasonable scientific opinions. I don't got no problem with it. I'm smart enough to decipher through the bullshit. At least I like to think I am. If I pay attention to enough of these court hearings and trials and what's actually said, then you become familiar with all of it. Okay, Dr. Maria is an emergency care physician out of Los Angeles, and it says on screen that she's out of Los Angeles. Oh, she testified before Firefly.
Which one?
Dr.
Russell?
Maria Russell, because you can click
Oh,
on.
Dr. Russell. Yeah, she's the one that the prosecution tried to get her to discredit her. They didn't want her to testify.
So the prosecution wanted her to be kept out. So she
She's
must
got
have opined
years
that
and years of experience.
the wounds on John O'Keefe's right arm were caused by animal attack, possibly from a large dog, according to Dr. Maria Russell, a retired emergency room physician and forensic pathologist from California. Russell has done research and published on the subject of animal bites and scratches, authoring or co-authoring several peer-reviewed papers on law enforcement dog and bites. She's got the peer-reviewed stuff, which is you have to have.
Yeah. Yeah. Hey, is Jessica Hyde peer reviewed? Is her opinion peer reviewed? I don't know. Maybe she is.
She says, you found him? What does it say?
Oh, I'm sorry. You can go
No,
over
go
Russell, though. Okay, it said Reed's attorneys hired expert Matthew Erickson to review the police department's video surveillance system. I don't know what his expertise is. I mean, I guess he's
Sallyport.
Oh, okay. Just a.
I'm guessing. Read that again.
It doesn't really say exactly. It's just an article. It talks about how he was hired to review the surveillance system. Yeah.
Review
Yes,
surveillance.
he's a video analyst.
Okay, now think about that. We've heard about how Higgins and their key cards, what they could access at the jail, at the police department, the rooms they could and could not access, the armory and the evidence room they could not access, had full access to Sallyport.
Why was it inverted, though?
I haven't got there yet. I don't know.
Yeah. That's the big question. So I don't know.
Maybe that lady you just talked about or that person you just looked up will have some opinions on that. If that's what they're reviewing, security at the jail, I don't know. What okay, that tells me Sallyport? Did somebody come in there and fudge with something? Karen Reed's lawyer.
Yeah, somebody fudged with it for damn sure. Sorry.
So this lady says, I have a very strong interest in wounds in general. I have a strong interest in dog bites in particular, she explained. Russell estimated she's seen well over 500 patients and perhaps as many as 1,000 patients with animal-related injuries. Reed's lawyers have suggested that O'Keefe's arm wounds were the result of a dog attack, and they pointed specifically to Chloe, a German Shepherd mix who lived at 34 Fairview at the time. Jurors previously heard testimony at the University of California Davis Veterinarian Genetics Lab Forensic Unit found no signs of canine DNA on swabs taken from John O'Keefe's shirt. Well,
they found pork DNA.
Some of that might have got blown away with the snowblower.
Right, exactly.
Okay. Russell testified that she reviewed numerous on his shirt or on his sweatshirt. Okay, I just had a thought. Sorry. Swabs taken from O'Keefe's shirt. Which one? Russell testified that she reviewed numerous documents from Reed's case, including hospital records, autopsy photos, and records, grand jury testimony, and Canton dog bite reports. There's reports that Chloe bit people. After reviewing the various materials, she formed an opinion about O'Keefe's injuries. She says, I believe these injuries were sustained by an animal, possibly a large dog, because of the pattern of the injuries, she testified. Defense attorney Alan Jackson projected an image of O'Keefe's wounded arm for jurors, and Russell highlighted a number of patterns in the injuries, including parallel lines she said were inflicted by either teeth or claw marks, which, without knowing anything about her testimony, concluded the same thing, ma'am. Number of patterns, injuries, and parallel. Okay. Russell also pointed to punctate marks she said could have come from a pointy tooth, like a canine. She replied, or he asked her that. She replied, yes. That was her opinion. Based on a reasonable degree of medical certainty. Now, see, if the defense can use that term, so can prosecutors. Y'all need to let it go. I'm just giving y'all some advice to save your sanity. Based on a reasonable degree of medical certainty that the injuries were from an animal attack. Now, are we going to attack her for using that term, reasonable degree of uncertainty? or certainty, I'm sorry? Or are we just going to let it go? I'm going to let it go.
I think
What
it's just
about him, Rachel?
it's
Rachel.
a legal term. He's gonna have to get used to that. You know what I mean?
Oh yeah, yeah. We all have our shit we get hung up on.
Yeah,
I'm
true.
picking. I'm picking.
I
'Cause
know.
we get it. I'm just saying, y'all got to get used to some of these
I like
terms.
to tease him about it. Yeah, it's
Yeah, I tease him about it. He's probably like, "Y'all shut up. Y'all
fine.
shut up." He's telling us to shut up right now.
He's out
we
there saying, "It's no such thing. There's no such thing."
Joe, do you hear this mess? And he might have turned us off by now.
Probably.
Joe's getting ready for a show tonight over there. We got some body cam footage to look at. Russell testified that she first spoke with the defense on May 17th once Reed's trial had already begun. Really? Russell testified she spoke with the defense on May 17th once the trial had already begun. After reading
Yeah.
about the case, hang on, after reading about the case in a Boston Globe article that month, she reached out to a Los Angeles prosecutor that she knew, who put her in touch with Jackson, a former prosecutor himself. Interesting.
Yeah, so
Now I got
that's what the state
uh,
doesn't like. They didn't like that she
yeah.
contacted them, which I mean, I
Well,
get it.
I get it to an extent.
Mhm.
But if you got an expert outside looking in, they're like, Then again,
She's just saying, "Well, maybe you can use my expertise." She's already made the judgment. It's not like they told her what to say. She's
or
already
do
made
I,
her.
well, she could come in saying what she needs to say to get paid. I
No,
don't
she
know.
did
I
it.
put two
She did
ways.
it pro bono. She
Good for
did it.
her.
Yep.
Good for her then. Russell
Mhm.
said she had never asked to produce, she said she was never asked to produce a report on her findings regarding O'Keefe's injuries. Why not? We got an issue with people not taking reports, so I can't give you a free pass, ma'am. I don't care who you work for. She also testified that she reviewed some of the pertinent case files for the first time just 2 days ago due to technical difficulties. Oh my God. Houston. Yellow flags are flying. I wish I hadn't read this.
I
Now
know.
I gotta balance myself. Hold on. Lally asked Russell if she was familiar with a 2008 National Academy of Science report concerning forensic odontology, teeth, or other science of teeth. According to Lally, the report indicated the forensic method is not a reliable science as far as bite marks are concerned. Russell said her understanding is that the method has been deemed unreliable for matching a particular bite to a specific person or animal. However, she noted, I did not read the report. All right, people. I'm trying not to feel some kind of way. I'm not sure what to feel at this moment. Y'all help me. Y'all encourage me. Love body cam. Yeah, so Joe did a FOIA. Joe did a little thing. Joe, I'm going to spill a little bit of it. You're not up here to tell about it, so I'll tell about it. Joe is going to do a live later. I think he said he's going to do it later tonight. He requested some body cam footage. William Labredo was the attorney placed on the Richard Allen case when Judge Gull removed his defense team for no good reason. The Supreme Court put them right back on the case because they were removed for no good reason. Supreme Court put them right back on their old job. I just had to throw that out there because that wasn't me saying it. That was Supreme Court did it. Anyway, William Labredo took over temporarily as the attorney. He began to go through the documents and look and make his own determination. And when the old attorneys were put back on the case, William decided to go out and do an interview over on Court TV with Barbara McDonald. William Labredo came out and said that Richard Allen is not the guy. He was handpicked by Judge Gull, mind you, to take over that case. One of her friends, one of her colleagues that she knew well, trusted him. He came out and said, Richard Allen didn't do this. I believe his exact words were, one was killed and the other was sacrificed. He got beat up in Indiana recently, and we don't know why. So we had to go find out. So hopefully tonight we'll find out. I think everybody's speculation at first, because a lot of things were happening behind the scenes in Delphi 2 weeks ago when that occurred. This made me very curious as to what was going down over there in Indiana yet again. So anyway, Joe's got that body footage, and I have not got a chance to review it yet with him, and I really am looking forward to actually seeing it. I don't think it's Delphi related at all, but I want to see it. Got that inquiring true crime brain. Can't help myself. She testified that she has seen thousands of people with injuries to their skin from blunt and from sharp and from all different mechanisms. Those injuries did not look like blunt force injuries. Well, ma'am, it didn't look that way to us, but how did you get there? On redirect exam, Jackson asked Russell why she believed the photos from Chloe's records didn't resemble O'Keefe's wounds. There's a variety of wounds or patterns that one can see from an animal attack, Russell explained. It depends on the thickness of the skin, the movement between the victim and the animal, true, and also the power of the animal Yeah, I know all that. Just tell me what those marks are on the man's arm. Confirmed his family. Wait a minute, I missed something. Who's law?
No, you went into the
I went into something else. I know.
driver.
Oh, that's the snowplow dude.
Yeah, Lucky.
Oh my God, Lucky? Is that his name?
That's his nickname.
Okay, Brian Lofgren. Okay, this is Lucky. That's the snowplow guy?
Yeah.
Well, all he did was say he didn't see nothing, right? We'll leave him alone. Snowplow guy, you're a needed necessity out there.
We'll get to him eventually.
He put his clothes in the trunk. Wait, they're going to break out the leaf blower and collect this glass and carefully put it into a bag. Or did they? And they put blood into some cups and stuffed in a bag. Then they just throw John's clothes in the trunk.
Really? Why? Did they take the clothes off? Did they cut them off and leave them there? Is that what? Why are his clothes not with him?
They would have been in the ambulance, wouldn't they?
I would think so.
They would have been cut and taken off. They would have been removed. Now, they may have removed the sweatshirt on scene, but from what they described it, it was just cut but not removed at that point.
Yeah.
So that he should have been clothed when he was
saying. What
placed in the
clothes are they
ambulance.
talking about?
Yeah, it was a comment in chat that Rachel said.
Oh.
That Proctor put his clothes in the trunk. That I don't know. Y'all know more than I do. But so I'm trying to make that make. Yeah, I'm not disputing what the lady's saying, but what I just read brings me caution. I don't think she's going to lie. I really think people misunderstand when I say these things sometimes. I don't call her a liar. I would never do that. But I got a problem if you just reviewed stuff 2 days ago and you say it just doesn't look like that type of bite, right? I can do the same thing all day long and twice on Sunday. So I need a little bit more. I need some scientific stuff, lady. I hope she's got it. But she did a pretty good job of convincing the masses last time, right? With what she testified to. Y'all didn't feel some kind of way about her, or?
I didn't.
Yeah. Yeah, I went to get dried a week later. I don't know. I can't. There's too many. This is going to be like Koberger's case in a minute with 50,000 rabbit holes and 50,000 things went wrong. And I'm like, oh, God, no. I got to narrow it down to a few and keep them there. If a case has 1,000 things wrong with it, I will drop that thing like a hot potato and go on to the next one and let everybody sort it out. Because a lot happening, I get it. But
see, I listened to the first trial, but I was listening while I was working, so I wasn't here writing notes. So anything I remember, I'm just recalling from memory, and
And when you're working,
I don't know
you're bound to miss little things. You're going to end up missing things here and there. You can't help that.
Yeah.
It is what it is. Like, I didn't review a lot of that, any of the old testimony. I'm starting to review some of it now, right? Mm-hmm. Just to, did the other night when I went and watched Julie Nagel's. And that's when I realized she's the only person from the last trial to say she saw anything on the front lawn. And she testified she saw a blob.
Did she? I didn't see. I don't
Yes,
remember
she
that
did.
either. Okay,
Yes,
you'd
she
think I'd
did.
remember that.
Yeah. They
But
said it was a bombshell because nobody had heard her say that. She had never told the prosecutors. The defense never didn't even know it. It wasn't in any of the discovery, the depositions, or anything like that. She said it once she
Wow.
took the witness stand. I've got the testimony. Let me pull up the
And
court.
what time? When they were leaving
Hang
the
on.
house, like 1:32?
I
Okay.
don't know. I'm going to pull up her testimony. Let me get the live feed brought up on the side though, because I got to keep an eye on that. I got a couple of things going on. Okay, let me get to it. Let me pull her up. I want to show you guys the rest of that Mickey Steins video because I want to get y'all's impression on what's happening inside that damn room. Let me see. Where did I put her testimony at? Because I just watched it. Let me look at the playlist from, was it yesterday? Here, let me do it this way. Let me get my history and look at. In fact, I thought I wrote a timestamp down so I could review with you guys. Oh yeah, this is that channel I found on. Okay. Look, it's right there where I left it. Okay. I think this is the exact part, guys. I'll get it. Let me check. Because this is like a long testimony. Let me see.
Correct?
If that was the time frame, yes.
And you are good friends with Sarah Levinson, correct?
Yes.
Certainly over the last 2+ years, the two of you have discussed what happened on January 28th and 29th, correct?
Yeah.
And you know that Michael Proctor only interviewed you after the defense in this case filed a motion to get Sarah Levinson's name from the DA's office.
Objection.
Correct?
The objection sustained. Next question.
So you've known Brian Jr. since your sophomore or junior year, correct?
Yes.
And you actually graduated Canton High School in 2016, correct?
Correct.
But you've known him since 2014 or 15?
Yes.
9 or 10 years?
Yep.
He's a good friend.
Yes.
He's a close friend of yours, correct?
Yes.
And on January 28th of 2022, you were one of a select group of his friends who went to his house to celebrate his birthday the following night, right?
Yes.
And you don't go to somebody's house whom you graduated high school with 10 years previously to celebrate their birthday if they're just an acquaintance, correct?
Objection.
I don't know.
I'll let the answers.
When you got there, other than Sarah Levinson and yourself, everyone at the house was a member of the Albert family, correct?
Can you rephrase the question, please?
Sure. You and Sarah Levinson are not actually Alberts, correct?
Correct, yes.
But everybody else at the house was when you got there.
No.
You named Brian Albert Jr., correct?
Mm-hmm. Yes.
Julie Albert?
I did not know.
Nicole Albert?
I did, yes.
Caitlin Albert?
Yes.
Brian Albert Sr. might have been there?
Yes.
And you knew the Alberts well enough to know the names that we just discussed, correct?
Yes.
And in addition to that, the McCabe's were related to the Alberts, correct?
Yes.
And you knew Jennifer and Matt McCabe before that night, right?
I'm sorry, can you?
Yes. Before January 28th of 2022, you knew Jennifer and Matt McCabe.
Yes.
You had been to their home before.
Whose home?
The McCabe's home.
I don't recall.
You'd driven their daughters around, correct?
I have, yes.
And you had actually pet sat for the McCabe's golden doodle, correct?
Correct, yes.
Their home.
Mm-hmm. Yes.
And so the answer to my previous question is certainly you've been to their home, correct?
Yes.
And their golden doodle was named Bailey, correct?
Yes.
In fact...
Why is she a liar right out of the gate? First trial. And why is she acting so evasive? We heard you was a pain in the butt.
You knew Jennifer McCabe well enough that you called her by a nickname, correct?
Yes.
What was the nickname that you referred to Jennifer McCabe by?
JJ.
And you knew that JJ was Nicole Albert's sister, correct?
Yes.
Now, on the night of January 28th into the 29th, you saw Brian Albert Sr. After he came back to 34 Fairview, correct?
Yes.
You were on the first floor of that residence the whole night, were you not?
Yes.
And you have a specific memory of Brian Albert Sr. walking Chloe through the first floor of that house, correct?
Yes.
When Brian Albert Sr. was walking Chloe through the first floor of that house, he maintained control of Chloe's collar, did he not?
He did, yes.
You like dogs, right?
I do.
But you didn't pat Chloe, correct?
I have, yes.
That night.
No.
You've never pet sat for Chloe, correct?
No.
But you did hang out regularly at the Albert home for years because of your friendship with Brian Jr., correct?
Yes.
Which meant that you have had contact with Chloe over the years, correct?
Yes.
You would agree with me that Chloe's a very different dog than Bailey, the McCabe's Golden Retriever, correct?
Objection.
Sustain.
Bailey is a friendly dog, is he not?
Objection.
Sustain.
Chloe is not friendly, correct?
Objection.
I'll let you have that. Can you answer that?
Can you repeat the question?
Yes, Chloe is not a friendly dog.
I mean, I would say so, yeah.
It was clear to you that she is not good with people, correct?
I'm not aware.
Oops. I hit the wrong button. Sorry.
She saw Chloe
On
that
January
night.
28th and 29th,
That's what she's saying. But Albert, the homeowner, Brian Albert, was controlling the dog around by its collar, and she never sat for this dog. This dog was not a friendly dog. It's so obvious. Everyone's trying to downplay it.
Yeah, why are they downplaying it? Crazy.
Yeah, because the dog didn't bite that man. So we're going to downplay this dog. But I downplay you because you got
while you were in
lying
the kitchen dining room
about Jen's
area,
house.
you'll agree with me that there was music playing for most of the night, correct?
For a decent amount, yes.
And that area of the house has surround sound speakers?
Yes.
Everybody was in a good mood?
Correct, yes.
Talking?
Yes.
Drinking?
Yep.
Singing?
I don't remember.
Dancing?
Yeah.
And all the action was in the kitchen dining room area, correct?
Yes.
And that was where your attention was mainly focused, was it not?
It was, yes.
Because that's where everybody was.
Yes.
You were not monitoring the basement door, were you?
No.
And you never went down to the basement, correct?
No, I did not.
Prior to January 28th of 2022, you knew who Colin Albert was, correct?
Yes.
You knew that he was your friend Brian Jr.'s first cousin, right?
Correct.
When you were at 34 Fairview, you did see Colin there, correct?
I did, yes.
You believe that he got there shortly after Nicole Albert, Caitlin Albert, and Julie Albert left the residence, correct?
At some point, yeah.
And you say at some point, that's because you're not sure of the exact time when he got there, correct?
Correct.
You're also not sure of the exact time when he left, correct?
I would say 11:30, 11:45, around there.
He wasn't somebody who was important to you that night, was he?
Not really, no.
You weren't paying attention to monitor when he came or when he left, were you?
No. I said no.
You never physically watched him walk out the door, correct?
I don't remember.
You can't even say which door he walked out, correct?
I don't know.
You never saw him get picked up.
I did not know.
You never saw any car arrive for him.
I don't know.
And you never saw how he got home.
No.
Now, on January 29th of 2022, after midnight,
I'm going to skip ahead because
your brother Ryan Nagel and you lived in the same home, correct?
she established Colin was there for a little while.
At about 12:15 to 12:20.
So there's discrepancy about when Colin came, right? Which is the nephew of the homeowner. Because some people
they were trying to point to him like he punched him because he had scratches on his knuckles.
Social media or the defense say that?
I mean, defense was like asking questions about him, so I'm thinking they were.
Well, yeah. But I mean, what got social media to say he did it? That's what I was wondering. I do know that was out there. I just don't know the whole gist behind it. Because I know they're going to try to establish that kid left that place at some time. 48, where's it at? They're going to talk about when she goes outside, because she's going to go outside and tell brother Ryan Nagel, never mind, I've changed my mind. I'm going to stay in the house. Jennifer McCabe is giving me a ride home. And then that's when they go to leave. Okay, 4806. Let me get down here to it. So then she goes out and tells her brother she's not leaving after all. And then she goes back in. Then eventually she leaves with Jen. Okay, I think. Did it work?
I said no.
Okay.
You never physically watched him walk out the door, correct?
I don't remember.
You can't even say which door he walked out, correct?
I don't know.
You never saw him get picked up?
I did not know.
You never saw any car arrive for him?
I don't know.
And you never saw how he got home?
No.
Now, on January 29th of 2022, after midnight, your brother Ryan Nagel and you lived in the same home, correct?
At the time, yes.
At about 12:15 to 12:20, you texted your brother Ryan for a ride home, correct?
If that's what the timestamp says, yes.
Do you have a screenshot of that text message?
Somewhere, yes.
Did you provide that to any investigator or assistant district attorney?
I don't remember.
Do you recall whether any assistant district attorney or investigator asked you for a copy of that text message?
I don't know.
Is that text message still on your phone?
I don't know.
Did you delete that text message?
I don't know. So let's move this along, Mr. Unity.
When you texted Ryan that night, you were contacting him because...
All right, they're coming back to court. We'll get, before we leave the day, I'll finish that out. She's going to testify here in just a second how she sees this blob on the lawn. But she's literally the only person to see that. When did she tell investigators? Right?
Given her attitude, I'm not sure I believe her.
I'm not. Here's the thing. I never said I believed her. I'm saying what she claims she saw. But when did she tell an investigator she saw that?
Mm-hmm.
Okay, let me get the screen up real quick.
Part 2 should be good.
Their presentation.
I don't remember the
May
day
of
off the top of my head.
2023,
May
perhaps?
of 2023, obviously. Then I have the second one. This was the one that was used in the pretrial motion.
December 2024?
December 20, yes, that's correct. Very nice. Then I have the third one. This is the final one regarding the phone that was identified as Ms. McCabe's.
Yes.
And then I have the fourth one, which is the phone of Mr. O'Keefe. And then I do have the opinion from State versus Huera, but if we don't need that, that's fine.
Okay, very well. I appreciate you telling me that. In March, and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland in a case called State v. Herrera as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And in that particular case, you had attempted to offer various opinions to the court, correct?
I object.
You have to move along from this case, from what you're talking about. You have to move along from that Maryland case.
So with regard, do you recall another case from the state of Massachusetts, Arrington case, in which you submitted a pro se amicus? Do you recall that case?
I do.
And is it correct that in that case you submitted arguments on behalf of the prosecution in that case?
I submitted an amicus brief, which is not on behalf of anybody. It's as a friend of the court.
Right, but the Friends of the Court, you took a position in that, quote, Friends of the Court brief, correct?
Took a position on the evidence.
Right, and the position you took on the evidence was that the frequent location history data is reliable and should be used. Is that correct?
The statement is that frequent. I do not have that amicus in front of me. It has been a year and a half since I've read it. But that amicus does discuss frequent location history records, and I want to be clear, it speaks to both bias on both sides and negative and positive of submitting it. It was an unbiased writing, and it was not specifically in support of the prosecution.
So you are testifying in this case on behalf of the prosecution, correct?
In this case, I was hired by the prosecution.
Right.
That's correct.
And the prosecution is paying you for your services in this case, is that correct?
Yes.
And with regard to this case, you have been paid and have been on this case since May of 2023, correct?
That is correct.
With regard to the various reports that you have submitted in this case, you have mentioned one which is a report with regard to the iPhone of John O'Keefe. Is that correct?
That is correct.
And you have, in that report, you have made a statement, have you not, that from 12:20:50 a.m. on January 29th of 2022 and after, there is no indication of interaction with the device. Is that correct?
There is no indication of user interaction with the device. There is all received until about 6:04 a.m. when there is again Apple Health data that picks up.
I'll ask it again. And you can feel free to turn to page 1529 in that report.
Page 15?
Page 15, 1529.
The report is.
Would you like the page
pages.
of the report or the page NDA number at the bottom? I can do either way.
I'm sorry. I thought you were saying page 15 in the report.
No. It's NDAO 1529 or page 7, whatever way.
Page 7. Okay, Roger.
Okay, so page 7, you see there's a heading interactive phone activity, correct?
Yes.
And at the top it says, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20.
Yeah, you have to
Slow down. Okay, sorry about that. I'm just trying to move it along, but I will be slower. I'll repeat, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20:50 a.m. ET. You see that statement?
Yes.
And that if you skip down, I'm going to skip a couple sentences to the paragraph under the chart, and this is the key part.
Okay.
It says, from that point, and I'm understanding that point to be the 12:20:50 a.m., correct? Mm-hmm. You need to say yes or no, I'm sorry.
Yes.
There is no indication of interaction with the device. Did I read that correctly?
That is correct.
So I am going to, and you believe that statement is correct?
Until 6 something a.m.
No, I'm sorry. I'm just asking if that statement is correct. Not if you have other information, but is that statement correct? I object.
Can you answer that? Can you answer that?
Dead at that.
Did I read that correctly?
Him to interrupt.
You read it correctly,
Thank
yes.
you. If we could, Your Honor, have a document that is put up already in evidence and publish Exhibit 39.
Okay.
And it will be, thank you. And if we could go to slide 82, please. And Ms. Hyde, if I could draw your attention to the entry that is, it says 3209 under app lock, but we know that the 00 is a 12. So it's 12:32:09 a.m. on January 29, 2022. And I'm going to read what it says in red, and this is a timeline of Mr. Whiffen. You know Mr. Whiffen?
I do know Mr. Whiffen.
And so he put in red, not us, he said device locked with lock button for the last time. Do you see that?
I do.
And you know that to lock a phone, you actually have to hit the side button with regard to an iPhone to make it lock. Do you know that?
Yes, sir.
Okay. And that is an interaction with a phone, is it not?
I concur.
So that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest to Mr. Whiffen's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen has produced, and that do you have any basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate to be accurate as a digital forensic analyzer on the topic of the last of an indication of interaction with the device? Don't you think it would have been appropriate to look at that 12:32:09 in any of the tools you said you used on direct?
I did not correlate that artifact in my timeline.
I understand you didn't, and my question is, you make a statement. Well, let me back up. Do you understand that in this case, as in many cases, that matters of seconds in activity can be determinative of a case? Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right for any data forensic examiner when they're issuing reports about activity, particularly of a decedent. Is that important?
Absolutely.
So isn't it correct that the statement that you make on page 7 of your report, that from that point, 12/20/50, there is no indication of interaction with the device, is incorrect?
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a lock button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
Is there anything that had prevented you from reviewing that in that data before you wrote this report?
Not that I can think of. I would have to go and re-review that.
My question is...
I don't know if that artifact, I have not reviewed that artifact, so I cannot speak to an artifact I have not reviewed, and I did not, that is not my report, that's Mr. Whiffen's report, so I cannot speak to that without going back and reviewing that evidence.
Isn't the interaction with the device, a lock button, readily available to you in the data that you have and had in your possession when you wrote this report?
Yes.
Thank you.
Two conflicting reports of when that phone was last touched. Great job. What we needed. Conflicting reports.
If you could please turn to, in the same report, page 1528, which is your page number 6. And I just want you, please, to go to the, just put a placeholder in that, and if you can now just go to the conclusion, which is your page 50, 5-0. Let me know when you're there.
I'm there.
So in the conclusion, you state that starting at 12:01 a.m. on January 29, 2022, the mobile phone was in use with activity of Waze navigating to 34 Fairview Drive, Canton, MA, active interaction with the screen, steps, audio playing text messages and calls until 12:31 a.m. EST on January 29, 2002. Did I read that correctly?
Yes.
That statement is also incorrect, isn't it?
On what basis?
Do you believe that statement is correct or incorrect?
I believe that the statement is correct regarding those artifacts that are mentioned in that statement, yes.
Okay, if you could please, if you could turn to page 1535 of the same report.
Can you give me my page number, please?
I will. I'm
okay,
just,
thank you.
You're welcome. If you could turn to your page 13.
13, Roger. Yes, I'm there.
And do you see an entry that says 12:31:56, which is the same time in the conclusion, but I'm going to develop it.
I believe I know where you're going.
Hold on. I'm sorry. I need to ask the questions.
Yes.
I appreciate you looking to help, but if I could, I'd appreciate it.
Absolutely.
Thank you. So it's got health steps, and it has steps 36, duration 20.9 or 20.398 seconds. Did I read that correctly?
That is absolutely correct.
So if you look at this data point in your report on page 13, the steps began at 12:31:56, but they ended 20.39 seconds later at 12:32:16. Is that correct?
That is correct.
So therefore, your statement in your conclusion, if you could go back to 50, and this is in your conclusion, your statement there is that the steps, the mobile phone is used with activity, including steps, until 12:31 a.m. EST. That should read until 12:32:16, correct?
It depends on your interpretation of interaction. As a user is walking, they're not actively interacting with their device. It's their movement that is. It's not direct interaction with the screen. But I would agree to your view that that could be interpreted as needing an additional 20 seconds.
Isn't the more correct way to state the conclusion that the active interaction when it comes to steps is not calibrating using the screen, but the phone is calculating steps taken? Isn't that correct?
That is correct, but that's not interactivity with the device.
I understand,
yes.
But the sentence reads, includes steps, and the more accurate way to have stated that would have been to put 12:32:16 instead of 12:31 a.m., correct?
I'm sorry, you just said 12:30. I did this to the minute, not to the second. Could you rephrase what you were stating?
Well, I'll state it again.
I appreciate that.
You're welcome. So isn't the more correct way to state this important data point in your conclusion, instead of saying active interaction with the screen and steps, etc., until 12:31 a.m. EST, the 12:31 should be 12:32, because the steps that you have on your page 13, by what you concede, is the duration of 20 would have brought it to 12:32:16, correct?
I would state that depends. I believe either is a correct way to state that. Based on interactivity, based on your interpretation, your definition is more correct.
Okay, thank you. And it's not my interpretation. I'm reading from your report, correct?
Your interpretation that 12:32 is a more correct representation of interaction is based on your theory that interaction concludes when the steps end. And I'm saying both would be acceptable.
Okay, so let's follow up on this.
Sure.
Isn't it correct that it isn't my theory when the steps ended?
Oh, it's not,
if I could just finish,
Please,
because if
absolutely,
we
sorry.
talk over each other, the stenographer's not going to get both of us. Thank
Agreed.
you. So it's not my theory, it's just the simple math from an entry you've made on page 13 that the steps began at 12:31:56. They ended 20.398 seconds after that, which just doing the simple math is 12:32:16. Did I do the math correctly?
That is correct.
Okay,
I'm not
thank you.
debating that.
Thank you very much. So now what I'd like to do is to go to page 1528 of your report.
Do you have my page number for that? I'm sorry.
Yes, and I appreciate that you go page number, so I center in on the lower one, then I'll go immediately to the one. So it's your page 6, Ms. Hyde.
Thank you.
You're welcome. Just let me know when you're there.
I'm there.
If you could please go to Apple Health Data Steps.
Mm-hmm.
And we've been talking about steps because they're important enough that you put them in a report, correct?
That is correct.
So let's go to an important data point, therefore, in your report, in the chart, which is the second entry, which is, as you've stated, 12:21:10 a.m. Do you see that?
I do.
And you note under the data that John O'Keefe's phone registered 80 steps at 12:21:10. Did I read that correctly?
You did read that correctly.
And those 80 steps constituted 191.253 seconds, as you state, correct?
That is what is stored in that database, correct?
And is my math correct, so that the jury understands this perhaps a little better?
Sure.
That 191.253 seconds equals 3.2 minutes?
Approximately, yes.
Approximately.
I'm doing the math in my head, so that's why I said approximately.
Right. Understood. So, am I reading this entry correct, that you're stating what the data shows, that 80 steps were taken by the phone of whomever had the phone of Mr. O'Keefe? There were 80 steps taken at 12:21:10 a.m. on January 29, 2022, for a length of time of 3.2 minutes.
That is what the phone registered.
That's what the phone registered. Very well. Now what I'd like to do is to turn to the phone of Jennifer McCabe.
Okay.
And that is, for your reports, you don't date your reports, so I can't give you a date, but it says...
It's report 3, I believe, is what
exactly.
You're looking at.
It's 3. And there is... Bear with me, I'm accommodating your page reference, and I'll have it soon for you. It is your page 7. And let me know when you are there.
I am there.
Are you aware of an issue regarding the time of an interactive phone activity on Jennifer McCabe's phone at 5:07 a.m.? Are you aware of that issue, and particularly a communication to a person named Coco? Are you aware of that?
I would need to check in my report. May I turn to the page for
Absolutely.
that time?
And
I do see an outgoing call to someone labeled Coco at 5:07:21 a.m.
And you can tell that because in your report on page 11, you list a 5:07:21 a.m. call to a Coco as outgoing, correct?
Correct.
Have you discussed that call with any member of the Commonwealth?
No.
And again, this call is at 5:07 a.m. on January 29th of 2022, correct?
That is correct.
There is no duration listed for that call. And if you just follow my questions, if you can, yes or no, is that correct? There's no duration yet listed.
Correct.
So what I want to do is to also note that that omission is not the only omission of durations from this report, or I'll state it differently, let me withdraw that. There is no population of the duration column for any call from 12:14:30 a.m. on January 29, 2022, all the way through this 5:07:21 call, and you don't start listing durations until 8:59:34 a.m. Is that correct?
Yes, and explainable. The artifact.
I understand
yes.
Mr.
Okay.
Brennan can
Sure.
handle those on his redirect.
Absolutely.
So there's not a population of duration of calls after numerous early calls and phone, as you call it, interactive phone activity. Nothing populated in this report until 8:59:34. That's correct?
Yes.
All right. Now what I'd like to do is to turn to the 22740 artifact that was the subject of much discussion on direct. And I am going to refer to that as an artifact. Is that a parlance that is familiar to you?
Yes.
And if I refer to that as a timestamp also, is that a parlance that's familiar to you?
Absolutely.
So I can refer to 22740 as a timestamp, and you would find that parlance acceptable?
Yes.
Thank you. So I'm going to do that. Just to keep it simple, I would refer to it as a timestamp. Now, you've been on this case working for the Commonwealth since May of 2023, correct?
May 4th, 2023. That is correct.
So you've been on this case for 2 years, correct?
Not actively the entire time.
But you started on this case in May 2023. You issued a report in
Correct.
May of 2023, correct?
Correct.
You issued a report in December of 2024, correct?
Correct, after being rehired in November.
Right, and you issued more reports in 2025, correct?
That is correct.
So all of that activity has been on this case, correct?
All on this case. That
And
is
that's
correct.
been all on behalf of the prosecution, correct?
That is correct.
None of that work has been done on behalf of the defense, correct?
That is correct.
So let us now go to the timestamp of 22740. Your opinions on what is the meaning of that timestamp have varied from May of 2023 until today. Is that correct?
No, that is incorrect.
Let's cover that issue.
Sure.
Let's turn to your May 2023 report. Isn't it correct that the report and your findings were pursuant to a request from Detective Lieutenant Brian Tully?
Correct.
And how many interactions have you had with Lieutenant Detective Brian Tully on this case approximately?
I really don't know. I'd have to go look back at email and call logs.
Is it more than 5?
Yes.
Is it more than 10?
Yes.
Is it more than 20?
I don't know.
So somewhere between 10 and 20, would that be fair?
Again, I'd have to review my call logs. I'm not
But it
going to
was
test.
more than 10.
More than 10, I'm sure.
So the issue was your use of various forensic tools that revealed a timestamp, 2:27:40 a.m. timestamp on January 29, 2022. Is that correct? Is that a fair characterization of an issue you looked at?
Correct.
So if you could go to page 5 of that report. And I would ask that you go to the last paragraph that starts with "in the instance of the Google search," and let me know when you're there.
I'm there.
So it reads, "In the instance of the Google search, house long to die in cold, that was recovered from the write-ahead log associated with the X browser state DB SQLite database with the timestamp of 2:27:40 a.m. was marked by Celebrite as having this timestamp and being deleted." Did I read that correctly?
Fair. Yes.
So you use the words that Google search, "house long to die in cold," was associated with the timestamp of 2:27:40 a.m. Isn't that what your words are in this report?
In that database, they are associated. That is correct.
Right. And in terms of page 3, if you could go back, of your report, under relevant findings.
Mm-hmm.
It starts with, "There were 2 searches of interest that took place on the iOS device," and we're talking about Jennifer McCabe's device, correct?
The device that was identified to me as Jennifer McCabe's, yes.
That's identified to you as Jennifer McCabe. And it's what you talked about on direct examination as her device, right?
Yes.
It's not a mystery as to whose it is. It's not like you don't know, right?
In direct, I also use the phrase "identified to me as Jennifer McCabe's."
Right, but your conclusion is the device you've been working on and analyzing for 2 years is the device of Jennifer McCabe.
That is how it was identified to me.
Do you have a different conclusion as to whose device it is?
I always am very, very careful that I did not assess the ownership. That was information that was given to me, not information that I personally assessed.
So are you uncertain as to whether the device you've been working on for 2 years is the phone of Jennifer McCabe?
The device that I have been working on for 2 years is the device that was identified to me by the Massachusetts State Police, Detective Tolley, as belonging to Jennifer McCabe when I began working and received that device, as stated in the evidence analyzed section on this same page.
So let's go, and we're talking about, again, to get back to the center of gravity, we're talking about a timestamp of 2:27:40 a.m., correct?
That is correct.
And when you issued your first report in May of 2023, the timestamp you were looking at was 2:27:40 a.m., January 29, correct?
I was looking at multiple timestamps associated with the same 2 searches.
Right. So what I'd like to do, you said multiple timestamps. What times are in the multiple category?
What I was tasked to do was to look at the times, the search, the Google search history, I'm sorry, not Google search history, the Safari history, which includes Google searches, associated with those 2 search terms within that 12-hour period. That was the particular task, not the task of looking at the 227, just for clarity.
Right, and I appreciate that, but my question wasn't that. My question was, I thought I heard you on direct examination, which is why I repeated the question, what I thought I heard on direct, but I'll ask you the question.
Sure.
You looked at and talked about on direct 2 potential times for a Safari search, which includes Google, one of which was 2:27:40 and the other one was 6:23 a.m. Is that correct?
I analyzed the meaning of those 2 timestamps.
Right, so we're just talking about 2 times, 2:27:40 and then 6:23. Is that correct?
So you are only talking then about the one that we're also talking about 6:24 a.m.
Okay, so we
Eastern time for clarity, because some of these records are in UTC, some are in local.
Fair enough. So you've got 2:27:40, you've got 6:23, and you got 6:24 that you were looking at, correct?
There are other timestamps that exist in the realm of what I was looking at, but those ones, correct, are the ones that are relevant in this report.
Exactly, and that's what we're talking about.
Okay,
we're just talking about this report.
Yes.
And so if you look under relevant findings, at the very bottom paragraph, you say, second sentence, a Google search for how long to die cold at approximately 11:23 a.m. and then how long TIDIE in cold took place at 11:24.
That is in UTC. I apologize for not having the time stamp format there, but that is the UTC time. The UTC time equivalent in Eastern Local Time would be 6:23 and 6:24.
So to be clear, in your report, you wrote 11:23 a.m. and 11:24, and you didn't put UTC next
Correct.
to it, did
They
you?
should. You are correct. That should say UTC. That is a typo.
And there's a significant difference between 11:23 and 2:27:40, correct?
11:23 is UTC, so its equivalent in Eastern Time would be 6:23. The artifact of 2:27 is already in local time, so that is in Eastern Time. So what we would be comparing is 2:27 and 6:23 and 6:24 to be appropriate. They're taking into account the data storage and which ones are in UTC and which ones are in local time.
I understand your explanation now.
Perfect.
But in this report, there is no UTC time down. You have two additional times in addition to the two times, two different numbers added to the two, correct?
The UTC was a typo. It should say UTC next to those, and the chart shows all of those artifacts in EST and is clearly labeled that they're all in EST.
So you would agree that it's better stated to state it a different way than you have in your report?
I would say that both are equivalent. I should have had UTC there. But yes, it's easier for the audience to speak in EST. I would say forensics examiners typically communicate in UTC, but we translate for our reports. And I should have either communicated that in EST or included UTC. I will definitely contend that.
So, in terms of your May 2023 report, your first report in this matter.
Yes.
You, on page 5, in the sentence underneath the block paragraph, state, in the instance of the Google search, house long to die in cold that was recovered from the right-ahead log associated with.
That's correct.
The X browser stage with a timestamp of 2027:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
You read that correctly.
Now let's move ahead to page 7 of your report. Up at the top above conclusion. Importantly, at this time, you state, testing shows great inconsistency with timestamps parsed from this file. It is, however, definitive that the page existed in a tab.
Correct.
While a definitive reason as to why the timestamp is listing the time of 2:27:40 is unknown, the time is inconsistent with the timestamps associated with the same search. Did I read that correctly?
You did read it correctly.
So as of May 2023, you said the definitive reason as to why the timestamp is listed as 2:27:40 is unknown, correct? I'm just asking, is that what you wrote? Unknown.
I believe that the wording here is, sorry, I know I do use the word unknown. It says, while a definitive reason as to why the timestamp listing is the time of 02/27:40 is unknown. Sorry.
So you use the word unknown, your word in your report?
Yes.
Okay, so now what I'd like to do is to go on to the first proceeding in this matter. Do you remember giving testimony in a proceeding about a year ago under oath?
Yes, I do.
I am now going to go to that testimony, and If at any point you would like to have a copy of that, if Your Honor would like, I will do it, but I'm going to start and then we'll see how it goes. So, bear with me a moment. Do you recall in that testimony stating that you processed the image in several forensic tools? I used Celebrite Physical Analyzer, and then you list many other tools. Do you remember giving that testimony?
We have a page.
I'm sorry, Mr. Brennan, I thought I'd given it 1-12. My apologies if I didn't. It's June 14, 2024, page 1-12.
Thank you.
You're welcome. So, do you recall giving testimony about the various tools you used for this timestamp?
I do.
And do you recall stating that those tools were commonly used digital forensic tools that are very standard? Do you recall that?
I'd have to see the wording that I used at that exact time.
Would it be helpful to refresh your recollection if I showed you that?
It would be great. I would greatly appreciate that because I do not recall the precise wording, but I know that I spoke to the tools I used.
May I approach, Your Honor?
Yes, Mr. Alessi, you offered a transcript. Do you have the whole
I
transcript?
have the whole transcript if that helps.
It might speed things along.
Agreed.
Okay.
We have one. I'll provide it. Ms. Hyde, I'm going to give you a transcript.
Thank you. I appreciate it.
So, may I approach, Your Honor?
Yes.
Thank you. Mr. Brennan? Transcript. 112. Thank you. You are. That's, let me turn it over to, it's going to be 112.
Okay.
Got it? Okay. You're welcome.
Thank you so much. And you said we're on 112?
Yes, please.
113, I see it. I see it's highlighted on the copy, so I figured that's the
what I
one.
wanted to do, the reason I said 112 is that's where I started with my
sorry.
previous question. So I'm not going to repeat the question, but just to orient you, so you have a fair context for the questioning.
Fair.
So I started at the bottom, 112. Now I'm moving to 113, and I'm starting with line 7. Do you see that?
I do.
And it says, yes, they are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. Did I read that correctly?
That is correct.
And then if you go down to line 22, you testified in that proceeding, so it's important to use multiple tools so you can see the results from different data sets, and be able to compare those results and enhance those with manual analysis. Did I read that correctly?
You did, that's correct.
And then going up to page 114, line 5.
Slow down a little bit, Mr. Alessi.
I will, Your Honor, thank you. Yeah, that's very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretation from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent to that. Did I read that correctly?
That is correct.
And then lastly, for this section at page 114, 17, the Sanderson tool is meant to look at specific type of data structures called the SQLite database. XQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Did I read that correctly?
Yes, you did.
Thank you. Now if we can go to page 124 of the very same testimony. And feel free to go back a page just so you can see to page 123 that the topic is the 2/27/40 timestamp associated with house long to die in cold.
Can I have a moment just to review and get context?
Absolutely.
Thank you so much.
Page 123, 13, but if you need to go back further, feel free.
Okay, I'm good. Thank you.
You're welcome. So what I want to do is start with page 1-23, and this is your testimony. On line 16, I have them in the timestamp order that is associated with the artifact. You use that word associated again, correct? Did I read that correctly?
Yes.
And that's associated with the Google search, "House Long to Die in the Cold" in a 2:27:40 a.m. timestamp, correct?
That is correct.
Now if you turn the page of the testimony, you state back then that on page 124, line 1, the browser state DB is an artifact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that the tab moved. It could be lots of things. Did I read that correctly?
You did.
Not one thing, you said it could be lots of things, correct?
That is correct.
And then you go on in line 10, and you talk more, and then you go down to the bottom. You go down to line 20, and you testified, we cannot tell by this particular artifact what time that search occurred. Did
Absolutely.
I read that correctly?
It's specifically pertaining to that particular artifact that in browser state DB. That does not tell us what time a search occurred. That is correct.
Right. So you stated, and it was your statement then, we cannot tell by this particular artifact what time that search occurred, correct?
That particular artifact.
Okay, so now let's keep going. If you go to page 129 of this transcript,
I'm there.
at the top,
Sure.
line 1, 227 isn't necessarily one time when the tab was closed. That's in my report. I say it's undetermined. Remember we were just reading your undetermined
Absolutely.
in your May 23 report?
Correct.
Because there's a lot of things that can cause that timestamp to be there, including tab being moved, tab being minimized. The next sentence. I don't know exactly what caused the tab to get that particular entry, but it's not, that timestamp is not indicative of the time of the search or any URL that's visited. But the first part of it is, I don't know exactly what caused the tab to get that particular entry. Did I read that correctly?
You read 100% correctly.
Thank you. Now if we could turn to page 130 of your testimony.
I need to object.
Right, I'll see you both.
Oh my gosh. Can we move on? Salty, away from your phone.
Sorry, I was all the way in the kitchen, but I was listening.
Okay, I figured you were somewhere.
It's time to move on because I get it. I already know her opinion. Her opinion didn't change from that. I don't know until the software update happened and she examined the phone again. I gathered that from the earlier testimony. But as a juror, I've removed this whole Google search off the table, so we can move on. I need to get to the crash experts because I don't think any of y'all are going to be able to prove to me when this search was conducted. Not any of y'all. So therefore, I'm bored with it now.
I'm bored with it too, yeah.
I already got explained how she concluded the search happened and when, and I get it. I'm no rocket scientist, but my mama didn't raise no fool. I understand big words and terminology. Been looking at cell phone data for years is nothing new to me. Some of these terms, just I already know them. I get it. Y'all don't know when that fucking search happened. We'll never know. Therefore, it's mute.
Yeah, you could probably question 100 different experts, and half of them are going to go one way, half of them are going to go the other. So it's like, yeah, we're not going anywhere with this.
Yeah, and they distinctly talked about the Celebrite update twice now by Whiffen and her. They went. Look, we know for a fact in Delphi they continued to do extractions on Libby's phone throughout the 5-year investigation. Why? Because software is constantly updated. And what you couldn't pull from a phone 2-3 months ago, you can probably pull today. So I get it. I'm beyond this whole subject now. I don't care about this Google search at all. It doesn't matter. I get that it matters because, part of the conspiracy at 2:30, we'll throw him in the snow and hope he dies. I don't buy that either because I don't think they laid a half-alive man in the snow and hoped he'd die. Because we still got to come up with how he got there. Don't we got enough problems? So I feel like if they placed John O'Keefe in the snow, they being the homeowners, then he was killed inside the home. By a human, not a dog. So I don't care when the search was conducted because I don't think their intent was to have the snow kill him or finish him off. You know what I mean? Maybe Karen did ask her to Google it when she was running around screaming, could I have hit him? Oh my God, Google how long it takes to die in the snow. Because if I hit him, it would have been last night at midnight, 12:30ish. Like, see? So weird.
I think he could potentially have been assaulted and he was not dead but dying and they wanted the snow to finish him off. I do think that could have happened. It's a possibility.
But if you're a cop, do you want that kind of trouble on your lawn? And you hope it finishes him off? You don't need a live witness. I'm smarter than the cops, man.
Thank you for your patience, Ms. Hyde.
Absolutely, sir.
What I'd like to do is to go back to your testimony in the first proceeding, and we can go back to page 1-30.
I am there.
Thank you. So I am going to go back just because there's been some time and give some context. So we're talking about the 2:27:40 a.m. timestamp, correct, at this page location?
We've been talking about that for several pages. Yes, that's correct.
You're absolutely correct. We've been talking about it for several pages. And bear with me, I think this may be either the second to last or the last. So there you testified with regard, this was when you're referring to an artifact. You've agreed that timestamp is a fair synonym. You say on line 5, that means it wasn't in the regular database, it was in the write-ahead log. And to Celebrite's credit, that tool actually parsed the write-ahead log and displayed it where the other tools did not. So did I read that correctly, number one?
You read it correctly. So
am I correct that here what you're stating is Celebrite was actually showing the 2:27:40 a.m. timestamp at that time during your testimony in the first
on that date, that is correct,
okay,
yes.
so I just wanted to establish that, and
Absolutely.
You were giving Celebrite credit for actually showing that timestamp at that time of 2:27:40 at the time of your testimony back in June of 2024, correct?
That is correct.
Okay, so now let's go to page 1-36.
136, you said?
136, yes.
Thank you.
And on line 12, you note that so Celebrite and Magnet Axiom, and then you elaborate, both Celebrite Physical Analyzer, which is a specific tool, right, of
Correct.
Celebrite, and magnet axiom, another specific tool, correct?
Correct.
Both have file system viewers that then have SQLite database viewers. And you, skipping down to line 17, you talk about they don't allow for deep analysis of the write-ahead logs, which is why in my analysis I use the specialized Sanderson forensic browser for SQLite, correct? I read that
is correct.
So is it fair to say that what you did up to this point in June of 2024, with regard to the 2:27:40 a.m. timestamp on January 29, 2022, you applied a variety of tools to analyze the issue of when did the Google search occur, that you use the words associated with a Safari Google search, house long to die in the cold?
There's a little bit of wording I would correct there, if that's okay.
Right, but so let me see if I can ask the question
That'd be great.
a different, more simple way.
Thank you.
You're welcome. So you used a variety of tools to analyze that house long to die in the cold search, correct?
Plus manual analysis and testing, yes.
Plus manual analysis and testing. Alrighty, now let's leave the testimony.
Okay.
And let's go to your next report. And your next report is December 2024. Do I have the chronology correct, Ms. Hyde?
That is correct.
So in December of 2024, just approximately 6 months ago, you issued another report, correct?
That is correct.
And you got the request for that report also from the Norfolk District Attorneys, correct?
That is correct.
And you state in regard, well, that report regarded the analysis of the same timestamp, correct?
Correct.
To 2:27:40 timestamp. And in that report, under relevant findings, you state, and this is December of 2024, so it's from your May 2023 report, it's approximately a year and a year and a half. Is that approximately from your May 23rd report? Approximately a year and a half?
Yes.
So a year and a half after what we just reviewed in your May 23rd report, and then just months after the testimony of June, right? So about 6 months after your
6 months later.
June testimony that we just went through, you went and looked at this issue again, correct?
That is correct.
And isn't it correct that when you were asked to look at the same timestamp in December of 2024, that Celebrite removed the timestamp from their tools?
Celebrite did remove that timestamp from the tool. That is correct.
Okay. And that timestamp was the subject of extensive reports and testimony that you participated in the first proceeding, correct?
That is correct.
And even though that timestamp, 2:27:40 a.m., that showed up in Celebrite tools, Magnet Forensic Axiom showed up, that was removed by Celebrite, correct?
Celebrite no longer reports it. The evidence is still in the data. I want to be clear, just that it doesn't change the data. They just removed it from their automated parsing and reporting.
Right, so they removed it from their automated parsing and reporting, correct?
Yes, they did. That is correct.
However, your former company, Magnet Forensic Axiom, still shows it. Yeah.
Magnet Axiom Forensics currently shows it as a carved artifact and still shows that and gives a description in their artifact reference guide as to what they believe causes that artifact.
I'm going to ask the question.
Yes, it does.
Magnet Accident Forensics, where you used to be the director of forensics,
That is correct.
still shows that timestamp,
Yes,
right?
yes,
But Celebrite doesn't in the automated
that is correct.
tools.
That is correct in their automated parsing.
And you would agree that Magnet Forensics is a very reputable company, correct?
Correct.
Let's go back to your December 2024 report. Do you recall just moments ago when we went through your testimony in June of 2024 in the first proceeding where you stated various times how it was, I'll use the term best practices, to use multiple tools to analyze the timestamp?
Correct.
And you used many tools back then to analyze that timestamp. And you testified to those many tools on your direct examination, correct?
Correct, yes.
However, in December of 2024, when you returned to analyze the 2/27/40 timestamp, how many tools did you use to analyze that timestamp? Can you give me just a number? How many tools?
At least 4.
Well, in your report, let's go to your report, what your report says. So in your report, you state that under relevant findings, do you not, that review of data from Celebrite shows that the artifact of a Google search from a Safari suspended state tab with the search term "house long to die in cold," and I'm going to skip over, in addition to my own previous report, no longer shows a last visited timestamp.
I think that is not clear. The skipping there makes it sound like my report no longer shows that, and that's not what's
That's a fair statement. That's a fair statement. Let me rephrase it this way.
Thank you.
You're welcome. In this report, you speak about Celebrite release reports, correct?
Are you referring to the Celebrate release notes that come out?
The release notes at the bottom,
Perfect.
right? You referred to that?
That's correct.
And that release note states that Celebrite has removed the timestamp value from records, and I'm assuming that's a reference to Celebrite.
Celebrite no longer parses that result. That is the statement in this report. Correct.
Right. And so I'm going to go to page 4 of your report.
For sure. I'm there.
And I'm going to go down, all the way down to the conclusion. In that report, is there reference to any company other than Celebrite in this entire report?
In this report, no.
Okay, thank you. Now let's go to your prior testimony in the first proceeding, where you said that it was important to use multiple tools.
Absolutely.
Do you still stand by your position that you've given today and that you gave in June, that it's important to use multiple tools?
Absolutely.
Now let's go back to the issue of the extraction of Jen McCabe's phone. And what I want to do is to cover a concept and see if I've got this correctly. Are you familiar with the phrase Apple source codes?
I'm sorry, can you please repeat?
Absolutely, no worries, sir. Are you familiar with the phrase Apple source codes?
Apple's source code? Absolutely, yes.
And isn't it a fact that Apple keeps its source codes proprietary, meaning very few people have access to it?
That's correct. It is closed source is the term we would use.
Closed source.
That would be the term of art, correct?
And they keep it so close that they call it closed source.
And it's not just Apple, lots of tools are closed source. That just means that the code isn't available like it would be for the tool I mentioned earlier, iLeap. That's an open source tool. Anyone can look at the code. For Apple, we cannot go look at the code that makes your phone run. That's correct.
And isn't it the case, and I referred to that as the MB postulate, it's a shorthanded, but I don't need to have you refer to it that way.
I'm sorry, could you repeat that phrase? I was unfamiliar with it.
I'm going to skip it.
Okay,
I'll
thank
just
you.
go on. Basically, the concept that Apple has source codes that are closed sources. So I just refer to them as Apple's closed sources. Wouldn't the best information about when a search occurred, what it's associated with, wouldn't the best information be in the Apple source code to answer that question?
It is acceptable in digital forensic science and in accordance with the NIST Science Foundation papers to conduct testing to determine how the functionality of something works. You do not need access to the source code to be able to speak to an artifact.
My question isn't that. My question is, isn't the best place the best place to go is to the Apple source codes themselves, or are you saying these physical analyzer tools are just as good, and the information they pull is just as good as an Apple source code?
Those are very, very, those are incongruent statements. Apple's source code is not a healthy way to do an examination because it would be so onerous, and we do not know the level of documentation, we don't know the language. That is not necessarily the most effective way to determine what data is. Forensics tools parse results of how data is. They don't interpret them. The examiner interprets them and provides meaning. And I would like to state that those three things should not be conflated. They are very individual concepts.
I think you misunderstood my question.
I probably did it because that's what I was seeing.
My question is this. Isn't the best source for information about data in an iPhone contained within Apple source codes?
Not necessarily. Because that doesn't operational performance is a better source in a practical sense to being able to determine what something is, as opposed to zillions, and no, I don't know the number because it's closed source, lines of code that may or may not have different levels of documentation. Apple themselves wouldn't be able to, any individual there who has access wouldn't know every feature of how every element works. Testing through the methodologies described in NIST is the accepted methodology in our science, not reviewing the source code.
I'm going to try it a different way. I understand what you're saying is, if I got it correct, you correct me. Are you saying that these physical tools make it easier to interpret and view the data?
I did not speak about the tools at all in the statement I just made.
Okay.
I spoke about manual testing and checking the functionality and what results. Parse tools, again, these are three separate concepts. The concept of code and actually reviewing code to make a determination is different from parse tool results, is different from doing testing and validation. Those are separate concepts. They should not be commingled as if they equate to each other.
So have you ever learned of, have you ever spoken with Mr. Whiffen? Ian Whiffen?
I have spoken with Mr. Whiffen historically, but not since the term of this trial.
Okay. Have you ever spoken to Mr. Whiffen about whether the Apple source codes are the best source of information about topics like timestamps? Have you ever spoken? That's just a question.
I have not had that conversation with Mr. Whiffen, no.
Okay, all right. I want to move on to, and do you regard Mr. Whiffen as a reputable?
Mr. Whiffen is a reputable forensics examiner, and I've actually reviewed his work in other instances and peer-reviewed his papers.
So you have regard for his reputation?
I have regard for his reputation.
I'm sorry, we have to wait for each other to talk.
Oh, yes, I'm sorry.
It's all right, no worries. So you have regard for the opinions of Mr. Whiffen generally, correct?
Absolutely, yes.
And you believe he has a solid reputation, correct?
Absolutely, that is correct.
Now let's turn to the History DB database. You are familiar with History DB history DB, are you familiar with that phrase?
I am familiar with that phrase.
Okay. Do any of the house-long searches appear in the history DB?
In this instance, no, we do not have artifacts in the history DB of either of those two searches.
So I want to just repeat that in a different way. So the history DB, is that considered a valid and valuable source of information in an iPhone?
That is a valuable artifact for Safari history. That is correct.
But the house-long searches we've been discussing do not appear in that history DB, do they?
That is correct.
You spoke about PYF, PDF on your direct testimony. Do you recall that?
I do. It's the Python framework for PDF. It is a GitHub tool, one can download from GitHub to utilize to create PDFs using Python code. So a developer and a tool would integrate that to create a PDF.
And the PYF, PDF can have the variables set, correct?
Yes, the Python script allows the developer to set things such as their name that they created the document, yes.
I want to go to the extraction of Jen McCabe's phone that you talked about on direct examination. Is the hash value signed or unsigned?
A hash value isn't signed. I believe your question you're asking me is if the Adobe document that contained, the PDF that contained the hash values, are you asking me if that's signed? Because a hash value is something that matches, a hash value isn't signed.
Let me ask it this way. Is there any hash value associated with Jen McCabe's phone that is unsigned?
That is not a valid question. I apologize. We don't refer to hash values as being signed or unsigned. We would refer to the PDF that contains that value as being signed or unsigned.
Have you ever read a report of Mr. Ian Whiffen in this case?
I have, but I have to be clear, I have not read all of Ian's reports. I've only read some, so I don't know if... I read some of his earlier reports.
Do you recall reading a report of Mr. Whiffen where he references a hash value being unsigned associated with the iPhone of Jennifer McCabe?
Can I see said report so I can validate if I did or did not? I'm not sure based on just that, because I wouldn't use the term hash value being signed. I did see a report in which Mr. Whiffen spoke to the PDF not being signed.
I just want to try to shortcut this and work off your last statement. You're now saying you do recall seeing a report of Mr. Whiffen where he said a PDF was unsigned?
I need to see, I do remember him referencing the PDF. I would need to see the report. Especially since the characterization of hash value being unsigned is not a term of art that I am familiar with in our field.
Let me ask if you agree or disagree with this statement. This value can be used to compare with the original hash calculated at the time of extraction in order to validate the extraction data. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%. Do you agree or disagree?
His statement there says the PDF is unsigned, not that the hash value is unsigned.
Right, but it's nonetheless unsigned, correct?
The PDF is not signed.
He's
that
trying
is
to
a
give the
correct
jury
statement.
reasonable
Gray
doubt.
key PDFs that purport that value are not an Adobe signed document.
Do you know the history of the extraction of Jen McCabe's phone? It's yes or no.
Can you provide more clarity? What do you mean? Do you mean from the time the image was made? Do you mean from the time the device was received? Because I don't know the information pertaining to the receipt of the device into evidence, and then when I only have the documentation of the image forward. So I want to be clear about what period we're talking about.
It's an excellent point, and I am going to follow up with some questions.
Okay.
In an extraction, doesn't the extraction from a phone start with the raw data, raw image? You tell me, when someone brings a phone in, what's the first step that gets taken in order to do a full file extraction? What's the first step?
It depends. There's got to be steps with regard to network isolation. I need to know if the device is AFU or BFU at that point. So I don't have that information from this case, if that is the question. I get from the image forward.
So what I'd like to do, and this may be my last section of questioning, I'd like you to describe the ideal situation as to getting the most reliable data from an iPhone from the start. What's the most reliable way to do it?
I would say the most reliable way is following the recently released SWIG-DE Scientific Working Group on Digital Evidence document on best practices of evidence handling, preservation, and imaging. I may have that title slightly out of order, but it is the document released this January.
And tell me what that is.
Sure. In that, the first thing, from which point are we starting? Are we starting like extracting the data using a tool, or are we talking on scene, taking the device into evidence?
The latter.
Okay. So the first thing you're going to do is you're going to ensure that you are isolating the device. This is also going to depend on condition from the network. So typically this would be done with a Faraday enclosure in a best practice. However, there are alternative ways of isolating from the network, such as disabling all of the communication protocols, such as Wi-Fi, airplane mode, etc. The next step, once you've isolated, but prior to, you also want to make sure you're continuing battery stat. So if a device is on, you want to keep it powered on. If it's off, you want to keep it powered off. That's a general statement. So the best way to do that is to attach a battery charger. Just like when your battery runs low, you plug in a charger in the back of these battery packs. We do that with that before we put it in the Faraday bag. A Faraday bag is an enclosure that blocks signals from coming to the device. This is so a remote wipe command couldn't be sent, or so that more data isn't received to the phone, because phones are live and constantly obtaining data. So we're going to have it with a battery pack in the Faraday, presuming it was on. Again, I don't know the status of this device. The next steps are going to depend on what state that device is, and what make and model that device is, and what the current support for that device is. There are multiple types of extraction methods of phones. In the modern day on iOS, a full file system image, what we had on the devices in question in this case, is considered the gold standard because it has the most robust information. So at this point, the next question is what's the best image type? And that's going to depend on if we have a passcode or if we don't have a passcode.
If I could,
please.
And I'm going to allow you to continue.
Yeah, please.
I want to break it down for the jury. So what I now want to do, you've stopped at a certain point, but you've talked about securing, what I would call securing the phone, right? And then making sure that there's no data swipes. You talked about airplane mode, Faraday bag, Faraday box, right? Do you know whether any of those protocols were followed for either the iPhone of Jen McCabe or John O'Keefe?
As I mentioned, I was not there for those processes. I don't have documentation of it. As mentioned, what started where my receipt of the device is from the image.
Exactly. So you don't know.
I can't testify to processes I did not or was not available or aware of.
Fair enough. But do you have a little bit of hint as to whether the phone of Mr. John O'Keefe was properly secured in airplane mode, a Faraday bag, or a Faraday box, based upon your own report of the iPhone of John McCabe. Can you determine that from page 5 of your report?
Obviously, there is data signals that are still being made and created. I believe that is what you're referring to. So the assumption is that I don't know at which point a Faraday bag is employed, but I also want to be clear, I don't know when, I don't have information outside of the digital forensics realm about this case, so I don't know precisely when the phone was taken into custody by law enforcement.
Fair enough. So assume that Mr. O'Keefe was deceased around the latest 9 a.m. on January 29th, 2022. Isn't there activity on that phone, health data activity, up to around noon of January 29th?
Health data activity would continue to be reported regardless of if the device was isolated from the network or not. Health data has to do with the movement of the device, so if the device was being moved even within a Faraday bag, that data would still be populated.
How about location data?
Location data is unlikely to be reported in a device that is Faraday enclosed, but I do not know what location data you're referring to, so I cannot speak in absolutes without having a better reference to the artifacts in question. If you're saying it's in my report, I'll look at it, but again, I never knew when the phone was seized, so it was not part of my initial analysis. Do I have permission to look at that time now? Yes. Thank you, Your Honor. So, bear with me, it's a big report, as you know.
It is a big report.
And it was at the bottom of my stack.
Pardon me?
All right, it was at the bottom of my stack. I had to lift up the other ones to find it. All right, so.
Your Honor, may I assist and point her to a page?
Sure. That'd be
Thank
great.
you. If you could turn to that report on your page 47 and continue on to page 50.
I do see incoming data that is consistent with the device not being Faradayed, such as the receipt of SMS messages, notifications from Ring, etc.
So, the iPhone of Mr. O'Keefe was not secured in the manner you described before we got to this, as would be the best practice with regard to getting the most accurate data from a phone. That is, once it comes in, that it's to either be put in airplane mode, Faraday bag, or a Faraday box. That's correct. By your own report, you see activity.
I do see activity. It was not Faradayed. Faraday prevents wiping of the device and additional data. So actually, in this instance, it doesn't appear that the device was at risk of wipe because it was not wiped. And we actually have more data because we get to see the data that continue to come into the device. I'm not saying that's in accordance with best practice. I'm saying that that's what I see based off of what you just had me review in the data.
It sounds like you're trying to justify.
Oh, I'm not trying to
right or
justify.
wrong, you tell me. It sounds like you're trying to justify the fact it wasn't secured. Am I correct?
No, you're incorrect. I'm just stating we have, you asked if we had more data or less data. We actually have more data with it not being Faradayed, but no, best practice would be to Faraday. I 100% agree.
My question wasn't, is there more or less data? My question was simply, doesn't your own report show activity up until noon on January 29, 2022?
Correct. And for clarity, my scope was till noon, so I don't know if there was activity beyond that.
Right, but as far as your scope goes, I want to be clear.
Yeah.
There is activity on this phone.
Absolutely.
Which shows that it was not put in airplane mode, it was not put in a Faraday bag, and it was not put in a Faraday box, and that failure is not best practice.
Correct. It is not in accordance with the best practices. I agree. I would have Faradayed it.
Thank you. So,
if I,
that's okay. I have no further questions. Thank you for answering my questions, Ms. Hyde.
Thank you for your questions. Have a great day.
Best practices were not observed.
Thank you.
Oh my goodness, are they done?
The sad part is I got all of that entire testimony. I understood every freaking piece of it, but they didn't land none of it. Sorry. I'm not, that Google search is off the table for me at this point. I'll never want to discuss it again. God dang. Fuck. Faraday bags. I'm joking about not discussing it again. By the way, I was being a smart
Of course.
He looks a little disturbed, right? Where do I go now?
You were asked when you began working on analyzing phones in this case, and you said it was in May. Was that of May of 2023?
May of 2023. May 4th, 2023 is the email I have of a note. Thank you. Yes.
I got it highlighted, lady. Y'all move on.
It's easy to remember because May the 4th be with you.
When you first were asked
she did not
to begin work on this case in May of 2023, what was the catalyst for you to begin working on this?
I was contacted by Mr. Tully and then contracted, a SOW was signed, and I began work on the initial request to look at those two search terms on January 29th. Does that answer your question?
Sure.
Okay.
Was there a certain claim that was lodged that you would have focused on?
I was to focus on the two search terms from January 29th, 2022.
And were you informed why? Was there any context to that?
Probably, I don't recall the exact conversation that I had with the DA's office and Lieutenant Tully at that time, but I'm assuming that I was given that context. I have in my notes that I was to look at those two searches on that date and do an analysis about those.
Were you asked to reach any particular result?
No, I was asked to provide my report, not to reach a particular result.
Were you asked to reach a conclusion that the 227 timestamp was inaccurate?
No.
When you engaged in your analysis, was it independent of the District Attorney's Office?
My analysis was independent of the District Attorney's Office. I actually, in the first case, had very little communication with the District Attorney's Office during the period of my analysis.
Was there any input from any outside source on what your result or ultimate opinions would be?
No.
Would you ever allow anybody to affect your input?
No.
Throughout the course of your efforts with this phone, have there been changes to software?
Absolutely. As mentioned on direct, software updates are near monthly.
I want to ask you about changes to the Celebrite software. You were asked about certain reports you wrote. Were the reports that you wrote relative to different requests for analysis?
Yes.
The report regarding report number 3, regarding changes to Celebrite software, was that report limited to the timestamp change, or was it to include other efforts?
The scope of that report, may I review what I have documented as the scope? I believe we're talking about report 2, that's the one about the Celebrate change?
Yes.
And I have the request was to understand changes made in the newer version of Celebrate Physical Analyzer to artifacts pertaining to the timeline of a particular Google search on January 29, 2022, namely How's Long to Die in Cold.
When you looked at the Celebrate software and report, was the timestamp characterization changed or removed?
Yes, it was removed. That timestamp in the version starting in May of 2024, Celebrate actually removed that, and they put a release note stating that it was due to the ambiguity and potential for misconstruing the meaning of that data.
Was there any other releases informing other reasons why that was changed other than the potential that somebody could misconstrue, misinterpret, or distort the information?
Can I read Celebrate's own statement?
Please.
Celebrate's statement in...
To yourself.
To myself? Okay, roger that. Thank you. I appreciate that. Can you repeat the question?
With us, was there any reason other than the concern about misinterpreting or distorting?
They said that the...
So what's your understanding?
My understanding is that it is not a reliable timestamp, and that is why Celebrate removed it.
You were asked about Axiom. Axiom, is it the same or different?
Magnet Axiom and Celebrate Physical Analyzer are two different tools that both do forensic analysis of mobile phones.
You were asked whether Axiom still has a timestamp that was similar to Celebrate before the change.
Axiom shows what I spoke to on direct, where they have it as a parsed versus carved result. And so that particular result shows in the suspended StateDB artifact as carved.
Do companies like Axiom and Celebrate give releases, updates, information about how to interpret their reports?
So Axiom actually has a document that's released with it called the Artifact Reference Guide, and that actually gives a brief description of the fields and of artifacts. All tools, when they release new artifacts, they put out in a release note. Not all artifacts are clearly documented that are parsed. However, all of the vendors regularly put out webinars and blog posts that explain their new artifacts, but not necessarily all.
Is there any releases or cautions from Axiom on the same issue about misinterpreting a timestamp?
Axiom, in their artifact reference guide for this artifact, does speak to the possibility of misinterpretation and states that the timestamp can be earlier than the search had occurred, based on what different reasons could cause that timestamp.
Let me ask you about a Faraday bag. You said that best practices is to isolate an item in a Faraday bag.
That's correct.
Do you have any information, or did you know the travel of Mr. O'Keefe's phone that night, or where it went after?
I'm sorry, can you clarify the time period?
On January 29, 2022, from, say, 6:04 in the morning until later that afternoon.
I did not have access to that information.
When you analyze data from certain devices, are they always placed in a Faraday bag immediately after an incident?
There's a lot of times when this is situation dependent. An example of when you would not put something in a Faraday bag is when you have a deceased victim and you're going to be using their biometrics to possibly unlock the device. Because a Faraday bag is enclosed and then can't be opened, if your intent, if you don't have the password, is to use a deceased person's fingerprint to unlock the phone, we don't want to put the person's finger in the Faraday bag, so usually those phones would not be Faradayed, but they would typically have airplane mode enabled or SIM card removed. But no, SIM card removed doesn't actually work on iOS, so I won't get into that.
Understanding or having the opinion that this item was not placed in a Faraday bag at 6:04 in the morning, does that in any way affect your opinions about the data that you analyzed on this phone and the conclusions that you reached regarding Mr. O'Keefe's phone?
It does not have any impact on the conclusions other than the fact that it wasn't Faradayed and more data came in. So we have additional data.
You were asked a very specific question about History DB, and it was simply whether or not How's Long to Die in Cold, whether it appeared in History DB. That isolated question, does that provide any context for you and your analysis and conclusions about How Long to Die in Cold and that it occurred at 6:23 and 6:24 the next morning?
The absence of the History DB artifact doesn't mean that that search didn't occur at that time. We have multiple corroborating artifacts, which is usually what we look for, 2 artifacts that demonstrate is like very good. You don't necessarily need that, but in this instance, we have both from the Mobile Safari plist, which tracks the history, as well as the Knowledge C DB. So we do have 2 artifacts showing that those searches were done at that time. Of course, 6 seconds apart for the difference between the Knowledge C and the Mobile Safari plist.
On direct examination, you were not asked questions about Mr. O'Keefe's phone.
That is correct.
You were on cross-examination, so let me follow up. You have a report that you authored regarding Mr. O'Keefe's phone?
That is correct.
And you had an opportunity to look at the healthcare data for January 29, 2022.
That is correct.
Page 6 of your report.
Thank you.
You noted that there were steps that began at 12:11:09 a.m. Is that accurate?
That is accurate.
And the way healthcare data works, do you have an understanding whether steps means a person actually took a number of steps, or does it mean something else?
Steps doesn't necessarily mean that you took a number of steps. It's based on the motion of the device. So it could be steps, it could be you're carrying it, it could be that you're in some other kind of motion, you could be on a bicycle, you could, any number of things. And the number of steps is based on the presumed gait, based on the input into the Apple Health app in terms of gender and height. So it determines a gait and then prescribes a number of steps, but it is possible for other things to cause steps to occur.
You were asked specifically if you saw that there were reported movement or health steps at 12:21:10 a.m. and specifically pointed out to you notation or characterization of 80 steps. Is that accurate?
That is what's stored in the database. I try to clarify, as I did for you, sir, that that's what's stored in the database. I'm not saying that 80 steps were taken.
And by the way, in addition to the healthcare analysis, you did some analysis on the movement of a car, didn't you?
For Ms.
Your Honor. I'm going to deny that question.
Can these health steps occur if
Good
somebody's
call.
holding a phone while traveling in a car?
As mentioned in my report, it's caused by motion. It could be various motions that could cause it. You could be using an elliptical, you could be in a vehicle, you could be on a bicycle. It's not necessarily steps taken.
Based on your analysis of Mr. O'Keefe's phone and the report that was pointed out to you in cross-examination, and do you have information or opinion where Mr. O'Keefe's phone was located around 12:21:10 while those steps registered?
Objection, Your Honor. So,
That's beyond the scope of the class.
It was pointed out to you at 12:21:10 there was a registered 80 steps. Is that accurate?
That is correct.
Okay. And then you were also asked about the last healthcare data, the last movements of this phone. And it was pointed out that that began at 12:31:56 for 20 seconds.
That's correct. Per the data in the database.
And is that the last movement of Mr. O'Keefe's phone that evening before 6:04 that you saw when you analyzed the entire data in the phone?
May I have one moment to review? Yes. That appears to be the last before the 6 a.m. hour.
So that 20 seconds, if it began at 12:31:56, what was the last movement in seconds in time at that time of Mr. O'Keefe's phone?
I'm sorry, can you repeat?
Yes, if that was a 20-second interval at 12:31:56, what was the last second that evening that Mr. O'Keefe's phone moved?
12:32:16.
And then when you analyzed the phone and were asked about these times, is there any movement between that last movement and 6:04:01?
Between the 12:32?
Yes, 12:32:16 and 6:04:01. Any movement of that phone whatsoever?
I do not have anything supporting that in my report.
Do you know what was going on with Mr. O'Keefe's phone at 6:04:01 a.m. on the morning of January 29, 2022?
I do not know precisely what was happening with his phone at that time in terms of movement. If that's, or are you asking me? I'm sorry. Can you clarify what you mean by the question?
The next movement after 12:32
is the 6:04.
6:04:01
Correct.
a.m.
Correct.
Do you have any information about where or why there was movement of the phone at that time?
I don't. That wouldn't be inside my digital evidence, I don't believe.
And the last question is, the next movement at 6:15:14, do you know if that phone was being moved by somebody or somebody else than Mr.
The
O'Keefe?
phone was in motion. I do not know if it could be by a person, it could be on a rail car. I don't think it was on a rail car for clarity, but I don't know what is causing that motion at that time.
Thank you very much.
Any follow-up, Mr.
Yes, please, Your Honor. We have a moment.
I'm willing to bet Firefly. She's something.
There you go.
Thank you.
Koberger's family, that's what. Jesus Christ. I'll tell you in a minute.
Ms. Hyde, you were asked questions by Mr. Brennan just moments ago about Celebrite and release notes. Do you recall those questions?
Yes.
And did Celebrite, beyond stating that their opinion was the 2:20:40 a.m. timestamp was not reliable, did they give any reason at all for why they concluded it was not reliable in that? I'm sorry, we'll wait for the...
Thank you, I appreciate it.
Yeah. And I'll repeat the question for you.
Thank you.
If she got a wedding ring on, dude, do you just ask her on a freaking date and y'all get it over with? 'Cause I'm tired of watching y'all flirt with one another with your niceties. It's quite boring.
She has a wedding ring.
Oh, well, they're being all nice to each other. Etsy's wedding. I love that. Yeah, Firefly, they get to sit in the courtroom prior to their testimony being heard. Because what they're testifying to was nothing.
May I, Your Honor? Thank you. In that release note, does Celebrite state any reason for why they wrote not a reliable timestamp?
There are other
I'm sorry, my
but
question
not
is, did they
Celebrite?
state in the release note whether there's a reason for why they concluded?
May I look at the release note again? Thank you, ma'am. Thank you, Your Honor.
And please try not to talk.
I will,
Sorry, Your Honor.
Thank you.
2.
Not asking you to read it, just asking whether or not they give any reason for the conclusion not a reliable timestamp.
One moment, I'd like to review what they wrote. Thank
Absolutely.
you.
You're welcome.
Yes, they do. They state that further research since is the reason that they're doing it, that there's further research.
Did they state what that research is?
They don't, but
All right, but they don't state what the further research is.
that is correct. They
All right,
state
now
that
what I'd like
it's
to do is
unreliable.
Move on to Axiom. You were asked questions by Attorney Brennan, and you referred to Axiom as using a different parlance with the timestamp of carved, correct?
Celebrite uses this deleted demarcation or recovered demarcation. Axiom does not do that at all. They speak to how they recovered the artifact, be it that it was parsed. When I say parsed, I mean the item was where it was expected to be in the algorithm, found it, located it, and said it's here, versus carved, which is when they have to go into an unexpected area, such as slack space, which would be the areas that are not yet used or were previously used to extract the data from that.
So Axiom actually recovers the timestamp, but Celebrite does not. Is that correct? Is that correct?
Yes,
Okay.
currently, previously, when we did the first case.
Right, but currently,
It's the opposite.
Celebrite doesn't, but Axiom does. Axiom recovers 2:27:40 a.m., correct? Timestamp?
That is the timestamp that they show for that artifact.
Exactly. So now I'd like to go back to the next topic, our discussion about Mr. O'Keefe's phone and secured or not. You talked about one example of maybe needing to use a biometric to unlock a phone, and that might be a reason, as I understand it, as to why someone might not put it in a Faraday bag or box. Do I have that correct?
Correct.
Okay, do you know whether the passcode was immediately provided on the phone of Mr. O'Keefe?
I do not have that information.
Assume that the passcode was immediately provided for the phone of Mr. O'Keefe. Can you think of any other reason why that phone wouldn't be put in airplane mode, Faraday bag, or Faraday box?
Best practice would be to put it in a Faraday bag.
Okay.
Sorry.
And that phone was obviously not put in airplane mode, Faraday box, or Faraday bag after 6:04 a.m. on January 29, 2022, correct?
Correct.
Now let's go to...
Well, I don't know if at some point past 12 o'clock. My report only goes to noon, so just for clarity, I don't know
Fair enough.
anything past noon.
Fair enough, but from 6:04 a.m. until approximately noon on January 29, 2022, at least that time, that phone is not in airplane mode in a Faraday bag or a Faraday box, correct?
It would appear such. Because I didn't analyze past that, I don't know if it had been potentially Faradayed and then it broke Faraday and got data, but I don't suspect that based on this. It appears that that data was live. But I just have to speak to the fact that I just don't know because I didn't go past noon.
Right, but you're going past noon.
Right.
I'm not.
Okay,
My
yeah.
question,
6 a.m. to noon, it does not appear to be Faraday.
So, to be clear, from 6:04 a.m. on January 29, 2022, until at least noon of January 29, 2022, the iPhone of Mr. O'Keefe is not in airplane mode, it's not in a Faraday bag, and it's not a Faraday box, correct?
Unless it was in a broken Faraday bag, like they put it and it was failing. But yeah, it does not appear to have been placed in Faraday bag.
All right.
I'm just being honest. You should test your Faraday bags. They go bad. I use Dr. Katz's testing methodology, but 100% it appears to have been receiving signal for that entire period and not in a Faraday bag, which would be best practice unless biometrics were needed.
So let's now go to hopefully what are the last two categories of questions. With regard to the iPhone of Jen McCabe, do you have any knowledge as to whether over 200 calls were auto-deleted on her phone? You analyzed it.
We can see that calls were auto-deleted. You're asking me if the number of, I just want to make sure I understand the question, if the number of calls that were auto-deleted, if that exceeded 200?
My question is, do you know whether there was auto-deletions on Jen McCabe's phone? Do you know that?
I'm uncomfortable with the term auto-deletions because I don't know what that is inferring.
Okay. Did you analyze her phone at all for deletions?
I analyzed her phone to see if there had been deletions of call logs, and what I found was that there were records that were removed by the system and not recoverable from that database, but were recoverable from biomes.
Understood. Now what I'd like to do is to address your answer in response to Mr. Brennan's questions, where you said that the issue with regard to Mr. O'Keefe's, or just generally your proposition, that there was no impact on your conclusion because more data had been obtained. Did I get that correct?
I believe my statement was there was no impact on my conclusion with the fact that it had not been in a Faraday.
Right. So isn't it, though, the case that when a phone's not in a Faraday and is therefore active, data can be overwritten?
Yes.
So if data can be overwritten when it's not in a Faraday, you can lose that data, correct?
Is there data that we're concerned? Yes, theoretically.
Right.
Yes.
You talked about, in response to Attorney Brennan, the 12/31/56 steps, and you said the last, according to you, last movement 12/32/16. Do you recall those questions?
I recall the questions.
Yeah. To boil it down, isn't correct that that phone was moving at that time?
May I check the timestamp again?
Absolutely.
I apologize. There's
no.
a lot of timestamps going back and forth.
Please do.
12/31/56? Is that
Yeah,
the?
that's the start. Yep.
Oh yes, this one there definitely is. Yes.
So, doesn't matter what kind of movement, but that phone was moving starting at 12/31/56 and still moving until 12/32/16 a.m. on January 29, 2022, correct?
Yes.
Thank you. Appreciate again you answering my questions.
Thank you.
All right, Ms. Hyde, you're all set.
Thank you, Your Honor.
Thank you.
May I see counsel about scheduling?
Yes, you may,
Feel
lady,
free to
because I'm
stand up
trying to
and speak.
decipher something I was reading, and y'all was getting on my nerves with talking in my ear. Hold on a second. I got to read something. Never mind, because I can't make it make sense till I do a deep dive. It's a 17-page document. Damn it, man.
What's that,
Hey there,
Koberger
Karen
thing?
Reed, trial
Oh,
watchers.
go
You know,
away,
a lot of the
Jesse. We
trials
don't
I know,
we
but
remind of that the world is unfortunately very unpredictable.
Let me silence porn star.
silence him. That's it.
Yeah,
Put
just put him on silent just in case. Yeah, this one I'm reading through.
We gag him.
Now, I just dropped the link, guys, over in the community tab to the document that's allowing Koberger's family to remain in the courtroom even before they testify. Normally, they wouldn't be allowed, but what they're testifying to is not going to be like, we know he committed murder. You can go read the document. We'll review it when we have time. But the second one that came down is an order on the state's motion for examination of the it's an extension for a deadline when the state wants to conduct their own testing. And I believe this is what the hearing was about the other day. Yeah, they heard all arguments on this via video conference on May 5th. But I haven't got to the bottom of this one. It's just a 17-pager. But I think the judge has agreed to give them more time. The prosecution.
Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Oh, what?
Oh, shoot.
What? Girl?
Wow.
So, folks, I talked to the lawyers briefly about scheduling the sidebar, and I'm told we're actually ahead of schedule. So with that, rather than beginning a witness who's probably going to take a while,
We're going to stop today.
enjoy the rest of this beautiful afternoon. So we're on schedule, ahead of schedule.
We're ahead of schedule still.
Tomorrow, and I will see the lawyers and sidebar as the jurors want about to talk a little bit about scheduling. Oh, same cautions, please. Do not discuss this case with anyone. Don't do any independent.
We know.
Wait a minute. They really had to end it with that video. Come on.
They're ending it because the next witness is going to take a long time, she just said.
Yeah, but they had to play that video first. I mean,
I know. That was
they
ridiculous.
go home with that video in their head. You know what I mean?
Smart move there. But why did you even let them play it?
I mean,
why did she even let them play it if she knew she was about to call it a day?
That's what I'm saying.
Either one of us is going down, me or John. What the fuck? I don't blame you, Karen. At this
I
point.
don't either. I
Right?
mean, think about it. If she's innocent, yeah. Karen,
And you're trying to frame me,
hey,
honey. One of us is going down in a minute. If you're legit trying to frame me for something I, honest to God, did not do, you may have an ass whooping coming at the end of this. That's all I'm saying.
There's lawyers out
I'm
there
not
that
as
are
nice
like,
as everybody else.
if Karen gets acquitted, they're like, the FBI is watching. They're probably going to come after those people. So
Will
who
they,
knows
though?
if that's true? I don't
Will
know.
they?
I
Can
have
they
no
prove
idea.
can they prove a conspiracy occurred?
Well, they can. I mean, she's lied on the stand, right? I don't know.
Committing
If that's
perjury.
enough.
Lie, but when I'm in by proof, text messages, proof. Did they tell them
I
the guy
know.
never went in the house? Things like that.
They
right?
have their
You know
own
what I mean?
investigation they're conducting, so who knows what they've got.
But I mean, in general, for a conspiracy to be proven, and Lori Vallows, we knew if they didn't break out the text messages soon and show the jurors how Lori conspired, Lori was going to get away with that. Okay, just like Casey Anthony got away with that because the prosecution failed miserably at their job. So they got to do something. You can't walk in with cute stories. I'm not 3. I'm not 16. I'm not 21. I'm not 32 watching Real Housewives with a glass of wine in my hand. I'm a grown woman watching a full-fledged court trial for the second time. I'm done with the theatrics. You know what I mean? If I'm just being serious for a moment though. But seriously, if you're Karen Reed, you should be done with all theatrics, all the BS. What is happening here? I just they need to bring on the real experts. So Rachel was saying that, and I dropped an article as well, and I saw you were pulling up the info at the same time that the judge kept Easter out of the trial, and he was only going to attest to shitty investigation at the crime scene. But when with that article I read, Bev was like, well, you can pretty much do that on cross. Yeah, it's going to be easy to show leaf blower red Solo cup guy. I don't need an FBI guy to come in and tell me that was shitty practices, right? So I'm okay if she kept Easter out. No big deal. He's not the forensic data guy who was going to come in and talk about all these phone stuff. I don't think anybody will ever know for sure what time that search was conducted. And she can't miss thing. You don't get to tell me you don't think those deletions occurred. It was sitting in the deletion pile. Had to get there. Oh, well, it was just there, but not really there. No, ma'am. That sketchiness. Turtle Boy is probably I don't want to communicate with the DA or anybody who is.
Turtle Boy has some good info though. I watched some last night.
I don't watch
I didn't
him.
take notes, but there was some good.
Okay, well, let me ask you this. If this wasn't Karen Reed case, would you have a problem with prosecutors or anybody speaking to a social media podcaster?
Yeah.
Okay. I'll rest my case. So therefore, I just choose, because I'm trying to get to the bottom of this case based on what I see in court. I've made a conscious decision to avoid all Turtle Boy coverage through this entire first trial. I never looked at any of it. I saw stuff that was on Twitter, of course. I'm no fool. I'm not saying he's wrong in any aspect. God, please, if I say anything against some people, it's taken that way. I'm not accusing that man of telling you any lies. I'm not. He's probably bringing you the absolute.
I was just listening to him because there was nothing on last night. I was so bored, and I was like,
"Oh, I don't blame you for listening to him, girl. I mean, if it was somebody I listened to in the beginning, maybe I would now. But once that case started getting out of hand,
yeah,
I had no desire to go look at that part of it because I really wanted to wait till trial and make up my own mind. I didn't want to be influenced. I'm still trying to get there without.
I don't think he's like totally innocent. Like he totally like harassed the McCabe's and the Alberts. Like
yeah, he did. I saw that stuff on Twitter, and that's why I can't side with somebody who's doing the same thing you accuse somebody else of doing.
Right.
I can't. I'm not that. I can't get down with that. I'm so beyond bullshit. I'm probably the least dramatic chick you know. I'm the one in the movie that will slap the girl screaming next to me because she's about to get us all killed. And honey, just settle down and shut that mouth a minute. I got something to get out of here, and I can't do it with your hysterical run around screaming ass. Ain't nothing worse than a hysterical woman in a hysterical moment. And I'm a woman, and I ain't scared to say it. I can't deal with hysterical women running around screaming like little banshees. Calm down, honey. We got to think of a way to fix this. We can scream and cry later over a cup of coffee when we realize, damn, that was some heavy shit we just did. That's how me and my sister roll. We're going to take care of business. We'll break down later. That's how you get it done.
True. Yeah, I agree. I'm like that too. I don't like the people that freak out too, but
yeah, so when the hoopla and the screaming and the thing about social media and these criminal cases, the loudest people in the room things start, and I'm probably going to listen to the quietest person in the room at that point. Because I need to evaluate things fairly if I look at them. Now, I've looked at other things about this case outside of what Turtle Boy's done, like looking at the photos of John's arm on my own and looking at that going, you can't convince me that was no damn car hit that man. I didn't need any expert to come out there and tell me that. I didn't need social media to come point that out to me. It was just something I noticed right away.
You know what? To be
Then I
fair,
began to read the comments about it. So go ahead.
I was just gonna say, to be fair to Turtle Boy, like I said, I
Mhm.
think I've seen where he's been harassing the Alberts but to be fair, like I don't know if they've been harassing him. I don't know.
Oh, it
Maybe
went
they
both
have.
ways.
It went both ways. So
They got mad at look, if you got
they're both like tit for tat
I'm gonna
here.
tell
Like,
you
you
what,
know
if
what?
some rant here's the thing, if something I'm not gonna tell you we haven't had shit happen in my family. Okay, I've got a story to tell. I'm just not gonna do it today. Shit has happened in my family one time a long, 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 long time ago, and it got really fucking ugly. If a YouTuber or a random social media person shows up outside of my door after a family whatever, anything happens in my
Takes him.
life,
Yeah.
I'm not gonna fixing to be their best friend. Wait a minute. First of all, y'all might be sketchy. What's going on here? You know what I
That's what
mean?
I mean. Like he's on Karen's
Don't come
side, so they
harass.
hate him just for that. Like
Or
that's enough.
did he harass them a little bit and they harassed
I don't
back?
know where it
'Cause I
started,
think
to be
I feel
honest.
like I saw footage last year outside the courthouse, people going at it and stuff like that, and they were going as hard at him too.
That's
You
what
know
I
what I
mean. I
mean?
don't know where it
Yeah,
started, and
I don't
to be
either.
honest, I won't believe either side because they're both full of it, and just like the same thing with the 227. Both, every side can tell me what their point of view, and we still don't know because it's just so
Exactly.
confusing. We're never gonna know. I'm like you. At this point, we're never going to know. So let's
And
just
yeah.
drop
And
it. It's like,
the Google search didn't kill John O'Keefe.
no.
I understand the importance behind it because if it happened at 2:30, they put him in the snow and hoped he'd die in the snow
But
and hoped they'd come up with a logical explanation in the morning as to why that man was out there.
But enough's enough. The jury gets the message, what you're trying to say. So
Exactly.
enough,
As
enough,
long as you
enough.
can get it out there, get the story out there, and plant that reasonable doubt,
Hmm.
then you're done. You've made your point,
Move
right?
on to other sketchy stuff because there's plenty of it.
Plenty, right, girl? We're screaming. There's plenty of other
And you can
stuff.
just write down, look at all these different sketchy things.
But
Like,
you know
what?
what? Here's one thing that neither side can explain right now. Nobody can explain all of these random deletions that appeared to have occurred on Jen McCabe's phone.
Yeah, don't. What is that trying to say? He's like, can you say that there were auto deletions on there? She's like, well, I don't feel comfortable saying that. And then she pretty much, in so many words, said they were auto deleted. It's like, okay.
Yeah, her data.
If she didn't manually delete them, but they got deleted,
It's
basically, what
sitting
you're
over
saying.
there in the deletion pile, but really wasn't deleted yet. The phone is just mass deleting stuff. She got a messed up
Why?
iPhone, lady.
My
Lady,
phone's never done that. Has your phone ever done that?
no.
Come on. I've never heard of that happening.
Jen, your $1 million husband needs to buy you a new phone, lady,
Like I
because your
said,
phone is jacked up.
and the other day I was looking at my Safari open browsers, and I had like 157 browsers still open,
Oh my
or
God. Your
windows
phone
open.
or on your phone
Yeah,
or on your
yeah.
I
So they
I
just
don't
stay there they'll stay there indefinitely unless you close them.
yeah, I close tabs. I
Yeah,
don't
my son's always telling me, close your tabs, close your tabs. Like he'll pick up my phone at any given time and he'll be like, Mom,
yeah,
why you got
I
so many
don't
things open? I'm like, I don't know. I try and do it, but
it's a habit to me. I just gotta hit one
I
little
do
tiny button on
now.
the
I'm
left-hand
better.
corner and it
But
closes
like
all
I
the
said,
tabs.
the Safari browser I don't do. Like I just cleared
I
mine
don't
today.
even
I
use
had
that.
30.
I don't use that damn Safari. I don't
Well,
know nothing about it.
it's probably Google on your phone.
Yeah, my
Google.
phone is Google. So, Safari's the equivalent to
So
Google,
look,
but it's an iPhone
yeah,
thing.
yeah.
Okay, that's why I don't know nothing about no Safari.
Yeah, it's
Problem.
just a browser. So
Thank
when you
you.
go to Google,
Okay.
see how many searches, you might have a bunch of
Mhm.
windows open too. Who knows?
Not on my phone. I don't. I close them.
Oh, okay.
No, I have
Not
a
that it
habit of
matters.
closing. Yeah, I close my tabs. There's one
I
little
try
button right
to.
there. I click it. It's done. Because I got so much on my phone, I don't need a bunch of open tabs. I got 17,000 screenshots
But
to deal
according
with.
to these people, they can still do data forensics and find all those open, like when you did all those browser openings, right? That's what they're
Yeah.
trying to say.
Oh, what they're saying happened is she opened a freaking browser, and at the 2:30 when she was searching for the
Some
sports and all the
basketball thing.
basketball and all the
Yeah.
things, then it moved the tab to the back and it just chilled out back there until she
Mhm.
brought it back to the forefront and searched how long to die in cold on the same tab. The phone just automatically knew to go
Yeah.
pull up that tab 3 tabs ago. Come on,
I
y'all ain't
mean,
talking to
it's
idiots.
just the last browser that's open. So, like, if I open Safari, well, I
No.
just closed all mine, but there's going to be, you
Oh,
could
I
use
know,
the
but
open browser and
I
just
thought she had
start.
another. Okay, but I thought she had another search after the search about the basketball. Maybe that was the
She had
last
2
search.
searches at like
There was 2,
2:27.
right. Were those on separate tabs or the same
Basketball and
tab?
2 sports related things. They
Yeah, I
were
know.
the
I
same
got all
tab,
that
I think.
yeah, I know, I got all that wrote down right here on her phone extraction stuff, but what I'm wondering is
But what's weird is on that thing that she showed was the suggestion for how long does it take to digest food. Why did that pop up if she didn't type in how long
because
did
she
I?
already tried to exactly. So they've done lost me on their cell phone
That's what
shit.
I'm saying. So
Done with
did
it.
she possibly type that? How long did I cold and just didn't hit the send and enter it, or
Yeah, well, there's no
sounds like it
telling.
was already in there.
It had to be unless, your phone's reading your damn mind. They don't know when this lady searched nothing. They don't know. Oh, I can't
Unless the
open it this way.
suggestion comes up before you actually.
All right. Well, sometimes we know our phone. All right. Sometimes our phones are listening. We know we open it, we see an ad. But is it listening to me talk to you right now to the point when I open my
Yeah.
phone and go into a browser to search, it's going to pop in a headline and search it for me without me typing? No.
No.
So apparently there was a search done prior to that, or the phone wouldn't have suggested all that. And I got all her actual. I got to go back through her stuff, but they're not getting anywhere with their phone stuff. It's mute at this point because they don't know nothing. And like I said, that the damn Google search didn't do nothing. And then again, I have to go back to why would these idiots lay a dying man in the snow on their yard and hope they'd come up with a good solution by
I don't
daylight?
know why, because none of them wanted to go down for it. They're like, oops, I didn't mean to punch him so hard that I knocked him out.
I get that, but if I'm a cop, I'm not putting him in my yard.
Well, that's true. Yeah.
That's where I'm at with that. This is a cop's house. His brother's a freaking cop. I'm not putting a dead
Well, I mean,
man
that's
or a dying man in my yard and going to bed and waking up the next day and going, I'll figure it out tomorrow.
That's the problem with the
Make that make
conspiracy,
sense.
'cause
Exactly.
it kind of
Exactly.
doesn't make sense, but none of
Exactly.
it makes sense, though.
None of it does it? Like, I don't know if we'll ever get to the bottom of it. Oops, this is the wrong one. Let me.
And not only that, but the problem with the conspiracy theory is even though they're all family and probably a tight family, those 4, the 2 couples,
Mhm.
like, if all it takes is one person to spill the beans and you're all going down,
Okay, just like like I've said that about that's why you're only going to have as least many players involved as possible. That's why I wrote down the ones that were involved, because every person you see testify is not a part of the conspiracy.
No.
They were just out there doing their jobs.
Right.
But I can tell you the ones that were.
Right.
Right now we got a paramedic firefighter and a cop, or 2 or 3. But every single person that comes up to testify is not a liar. They're not wrong. They're not part of a conspiracy cover-up. Now, with what you said, the more people involved, the more you run the risk of somebody snitching. Somebody getting nervous when the cops are asking too many questions. Just like I said over there in Idaho 4, if I got a frat house full of punk-ass kids murdering their friends, up to 50 people, somebody's going to break at some point and tell mommy everything they did. What is she going to do? Is she going to hide them out the rest of their lives, or is she going to turn their little ass in? There wasn't no frat fight over there. Xana and Ethan hung out at the frat house apparently all damn night long until 2 o'clock in the morning. So it couldn't have been no major fight going down over there at the frat house.
Yeah.
None of us were there.
I think that's blown way out of proportion.
I haven't spoke to one single person that was there in person.
Mhm.
Internet rumors have told me a fight went down at the frat house. Not one frat brother has told me that. Not one person from that frat house has come out and said there was a scuffle there that night. Social media told us that. How do they know? Oh, would it be one of them accounts that just said bye yesterday?
The frat
Another
lawyer,
one
the
bites the
frat
dust.
house lawyered up real quick though, so that's why nobody's spilling anything there.
Showalter?
What? He's not in the frat, was he?
Which frat boy lawyered up when accusations
No, I
began
mean
to fly?
the whole fraternity where
When
they were at.
accusations started to fly.
I thought it was like immediately they got
No. Why would they
lawyered up.
immediately? No. Where'd y'all hear that? They immediately lawyered up like after the murders? The whole entire frat house?
Yeah.
Oh, wow. No. That would include Ethan's brother. You wouldn't hear frat member there too?
Yes.
Yeah, I don't. If somebody can bring me a receipt that happened, okay. But if I got lots of accusations at social media coming at me, I might lawyer up too. Defense attorney Bob Mata tells me to lawyer the hell up all the time. I'm taking my defense attorney's advice. So when something happens and I lawyer up tomorrow, y'all don't say, look, she's guilty, she lawyered up. I've been advised by every YouTube defense attorney on these streets to lawyer up and do it quickly. And don't say a word, girl. Message received, law tubers. Okay. 3-page notice here. This is the order on defendants' families in the courtroom. Let me make this a little bit bigger for my blind self. Whoa, not that big. I need fresh coffee. I made some a few minutes ago. It's time for a cup. In its order on motion in limine, family members in the courtroom, was filed April 16th. The court ordered the state to submit for an ex parte in-camera review a list of defendants' immediate family members it intends to call at trial, the purpose for calling each of them, whether they can be called early in the case, and why exclusion from the courtroom prior to providing testimony is necessary. The state timely complied with this directive. Having considered the state's response, the court, exercising its discretion, finds good cause to excuse defendants' immediate family, i.e. parents and siblings, from the anticipated exclusion order that will be entered. Now, the state of Idaho had no disagreement with this whatsoever. I'll let the YouTube streets tell you they did. The United States Supreme Court has recognized the right to a public trial afforded by the Sixth Amendment, entitles a criminal defendant at the very least to have his friends, relatives, and counsel present, no matter with what offense he may be charged. Courts recognize that having a defendant's family members present at trial advances the value served by the right to a public trial, i.e. ensuring fair proceedings, reminding the prosecutor and judge of their grave responsibilities, discouraging perjury, and encouraging witnesses to come forward. Yes, sir. The right to an open trial may give way, in certain cases, to others' rights and interests. Here, the court must balance defendant's rights to his family members present at trial against the state's interest in excluding testifying witnesses from trial under IRE 615. The purpose of the exclusion of witnesses under IRE 615 is to reduce the possibility of witness shaping his testimony to confirm. Now, what the prosecution didn't want them to do was sit in there, listen to other testimony before they testified. And usually in Idaho, if you look back at Lori Vallow with Kay and Larry, they have the same problem. And the judge in Idaho allowed them to go ahead and come in and testify at the beginning of the trial out of order, so they could stay in there the whole time. That's how it got worked out there. But the state has conceded to agree to this. Basically, under the circumstances here, the court does not find that excluding the testifying members of the Kohberger family will serve this purpose. Namely, the scope of the family members' proposed testimony is very narrow and is not necessarily tied to the testimony of other witnesses. So that tells you right there, they're going to be very limited. They're going to be testifying to things about, I don't know, when he arrived home, when dad got out there, things like that. Nothing like evidentiary, right? Like that. That's what I'm feeling here. That's the vibe I'm getting. Maybe about some searches. I don't know. It's weird. They're not going to get in depth into their testimony. Let me put it that way. Maybe that's a better way to put it. Kohberger family will serve this purpose. Namely, the scope of the family members' proposed testimony is very narrow and is not necessarily tied to the testimony of other witnesses. Further, the family members were previously interviewed regarding the matters on which they will be questioned at trial. So they've already been interviewed about what they'll be asked about. These prior recordings serve to protect against any attempt by the family members to mold their testimony based on how others testify before them. And that's always a risk they have to weigh, because if they were allowed to sit in, they could shape, mold, and change their testimony to fit what's happening already in court. But we don't got to worry about that here. Thus, exclusion. Now, if you're Brooks Houck and you got your family trying to record the grand jury testimony while they're giving it and get caught, that's different.
Yeah, because it's going to be about his actions when it's unique to the Coburgers. It's not like
Exactly. Great way to put
anything's going to
that.
influence them. Yeah.
That's perfect, because they're not going to be testifying to stuff others are testifying to, only stuff that they can.
Yeah, like his behavior once he got
Mhm.
back from Christmas break or whatever, and
Right? Exactly.
what
Things of that.
activity he was doing and how
Yeah.
suspicious he was acting or whatever.
Right. Exactly. You see? We get it, don't we? You said that perfectly, though, because that's exactly what it is. Thus, exclusion pending their testimony will not necessarily prevent them from conforming their testimony. Finally, the state has indicated it would prefer that the family members remain in the courtroom and be called when the state sees fit, rather than calling them out of order witnesses. So there you go. In sum, given the defendant's right to a public trial in general, the important presence of the members. Okay, so the judge is allowing that to happen. And I dropped one of these was it this document I dropped already? Yeah, I'll drop the other one in just a minute. I'm trying to remember to start doing that for you guys, to drop those docs. All right, I'm going to pull up this one, and we'll read through it before I leave, but let me go grab a cup of coffee real quick, guys. Yeah, right, Rachel, we don't think so either. We don't think so either. Rachel says they was all drinking. Common sense went out the window. She ain't lying, is she? Well, they sobered up. They probably thought about it, Rachel, like, oh, shit, what are we going to do? That guy's out on the lawn. All right. Firefly, if you're with me, I'll be right back, guys. Let me go grab this cup of coffee real quick, and we'll get to reading this before we head out for the day.
Okay, sounds good. I'll be here.
Okay. Had to let the doggy outside as well. I understand the drink. My whole family, my mom and dad, I never saw my dad with anything alcohol in his hand until I was 16 years old. Saw him with a beer. I was like, Daddy, are you kidding me? My mom never drank until her and my dad got divorced. But my mother's mother, God rest your soul, Granny, because I loved her more than life, full-blown alcoholic. It wasn't pretty when she passed. I hated that for my mom. But my granny was a wonderful lady, but alcohol is an enemy. And that's why I don't drink today. Watched my granny.
Oh, I was saying my dad was an alcoholic, and when I was about 11 or 12, I think that's when it all came to a head, and he got dry, and he's been dry until he died.
Oh, good for him, Firefly.
Yep.
That's good. My grandfather was not like a drunk like he just drank all his life, right? I remember when he stopped drinking and he just put it down one day, put down his beer. He old Milwaukee with like salt in the top, like Papa, old school beer. But yeah, just put it down one day and never drank again until he got Alzheimer's. Okay, my grandpa quit smoking and drinking, like I'm telling y'all, 25, 30 years before he ever got Alzheimer's. He walks into my room one night and he looks dead at me. He's like, "You got a cigarette?" And I was like, "Yes, sir." They're laying right beside me. I'm not lying to my pawpaw. He's like, "Give me one. I'm out." I'm like, I already knew. I don't argue. I don't argue with him. I've been to the Alzheimer's library. I got all my books. I know how to handle this man. I'm like, "Yes, sir, I do." He lit a cigarette and he stood there and he smoked it like he was in his 20s. He put it out and never touched another one after that night. My mom comes in my room one night. She's like, "It was evening. Your papa wants a beer." I was like, "What?" She's like, "You got to go to the store and get him some beer." I was like, "Mom, are you serious?" She's like, "Go get him a damn beer." I was like, "Okay." So I go down to the corner store. I gave him a 6-pack. I go back home. He drank one beer and never asked for another one.
Aw. That's
Isn't that
weird.
odd?
When I worked at a nursing home, we had this one gentleman who was 100 at the time, and every evening he got one beer.
Right?
I'm like, oh, that's I mean, it's moderation. Like, it's not gonna
There's
hurt you.
nothing wrong with that.
He's lived to
Yeah.
100, so
Now
geez.
look, when I tell y'all my grandma was a full-blown alcoholic, I'm telling y'all this lady partied.
Mm.
They went to the juke joints. She was in the bars. She was an amazing mother. Her house was spotless. She was an amazing grandmother. But she went out to the bars, and Granny looked good at all times. My grandma was that lady, right? I'm gonna look good, dressed to the nines, the whole 9 yards, smell good. It's all there. She could hold her liquor. Oh my God, it was so horrible. But back then that was like a thing. Well, let me say this: Southern Baptist preachers back in the day were usually alcoholics, and most of their children were as well. My granny's father was a Southern Baptist preacher, and every one of them that I ever knew was an alcoholic. What's that tell you about Southern religion and the Bible Belt?
It seems like a
Okay.
lot of people overdo it, you know?
Oh
Look at
gosh, yeah.
look at all of Canton. It looks like all
I
those adults.
know.
Like
Why do people overdo it with alcohol though? I gotta stop after a while. My brain starts getting fuzzy and I'm in
like the young
control.
adults, the one Brian Albert Jr. had a birthday, he was like 22 or
They were all
something.
drinking.
They stayed at home though. At least they stayed at home. The older adults were all out
Right? I
partying and
noticed that
drunk,
too.
driving in
I
the
noticed that,
snow.
Firefly, that the youngins were all at the house drinking, and then the parents were
Yeah.
the ones all driving around.
Yeah, there's a big snowstorm coming, so let's all get drunk and get on the road and then drive home in hazardous conditions. Makes sense to me. Right?
Yeah. Yeah. Let's do it, man. Let's party it up like we're
Yeah.
still in college. Oh, I forgot I graduated college about 10 years ago. I was supposed to grow
Or
up.
not.
Oh,
20 years
damn
ago
it.
for these people, 25 years ago.
That's how it starts. Okay, a lot of us get drunk in high school. I did. But when a lot of these people get to college, they're finally free and can experiment. And they start drinking. 4 years later, they're used to drinking on the regular basis. You graduate college and you're drinking now we're adults, we're young, we graduated college, we got our career, let's go meet up for happy hour at the end of the day. Guess what? By the time you're in your mid to late 30s and you got a baby or two and you realize you can't wait to get that drink at the end of the day because it's that habit you've been doing since college.
I mean, I'm
Anything,
like you. I drank in
anything
high
can be that,
school,
right?
but I'm like,
Anything
I
can be
never
that.
really got much fun out of it. So
Right?
yeah, I never drank that much. So I'm like,
My husband told me, my ex, one time, he's like, maybe we shouldn't smoke weed. We should just drink beer. I was like, you can. That's a totally different buzz, dude. I'm not down with it.
yeah.
But he didn't drink either. I don't mind drinking a cold beer in the summer. Don't get me wrong. On the riverbank, being responsible and all that good stuff. Me and my sister get us a little mixed drink on. Our granny might come out of us every now and again, but you got to be responsible, right? So Joe's over here. Hang on, Butterfly.
Yeah. What's he talking about?
Um, Okay, so what Joe's talking about is like we mentioned earlier in the stream. He's got the body cam video from William Labredo, who was beaten up in Indianapolis, Indiana, a couple weeks ago. Labredo was the attorney appointed by Judge Gold to take over when she threw off Rick Allen's original attorneys in Delphi.
Oh, okay.
And then after the Supreme Court put them back on the job, and he left the job, he comes out and speaks publicly to Barbara McDonald on Court TV, and I got a whole video on it. The guy says Rick Allen was innocent. After he evaluated the case, his conclusion was Rick Allen was innocent, and what happened that day to those little girls, they killed a little girl and they sacrificed the other one. And now he's been beaten up in Indianapolis in the midst of some drama going down in Delphi. So out of curiosity, Joe and I had a little talk, and Joe got the goods. Yay, Joe. What time you going live tonight, Joe? What time we doing this, man?
And those people are scary when it comes to that. I would be quiet. I wouldn't say a damn thing about those people because I'd be
There's
afraid.
something. Look, if you've noticed, I'm not covering Delphi, and I've stated it publicly.
Yeah.
So this right here, I don't believe is related to Delphi. If it is, I want to know, because I need to know for my own research purposes. I'm just not speaking publicly on a lot of things in Delphi right now, but this is interesting to me. So I know Joe's done reviewed it because he had to work on the video. So I'm going to get my first reactions tonight over there at Joe Schmo's channel. Thank you there. 9 p.m. Eastern, 8 p.m. Central. Awesome, Joe. All right, so if you guys want to come check out some body cam when this guy was beaten up and hear him talk about it, y'all come on over there and check it out. Good body cam is always fun. I'm sorry you got injured, Mr. Labredo, but
yeah.
I didn't do it. It's just my hobby to evaluate it. Huh. Before the court, y'all, in this, sorry, I've got to laugh at myself for a moment. I'm too far into true crime sometimes. And I get bored so quickly with one case when it goes blah. I got to go dive into something else till I get unbored again. All right. Before the court is the state's motion to conduct an examination of defendant pursuant to IC 18207-4C. Now, this is going to tell us that May 5th closed hearing that was just held was about this. And as I briefly skimmed through it, there was something I disagreed with from the state if I was a defense attorney. There's that. Defendant does not dispute that his penalty phase expert disclosures opining to his mental conditions trigger the state's right under the statute to conduct its own mental health examination. See? Him spawning examinations automatically triggered the state's right to do the same. State's right. Okay, that's the law, people. Not y'all. Not our crew here. Y'all understand what I meant. We're going to scream it out loud for those in the back. What is in dispute, however, is the scope of the examination, and I tend to agree. Whether defense counsel may be present or whether the state has to show good cause to extend the rebuttal disclosure deadline. Oral arguments on the motion were held by video conference on May 5th of 2025, after which the court ruled from the bench. So he ruled that day. This order memorializing that ruling. The standards, okay, well, he's going to go into the standards of law. Consistently with legal, I'm not going to read all of it because I skimmed through it and it was just pretty standard bullshit. Okay, procedural background, on January 23rd of 2025, defendant timely disclosed guilt phase expert opinions by 2 mental health professionals who examined the defendant and subsequently diagnosed him with various mental health and behavioral conditions, including autism spectrum disorder, obsessive compulsive disorder, and attention deficit hyperactivity disorder. Oh, God. So Brian Koberger's been diagnosed with what every American I come across right now tells me they're diagnosed with. It's an epidemic. We have an epidemic in the United States because I'm telling y'all, since I've been on these YouTube streets for 3 years, I have had more adults.
I forgot to add anxiety disorder to that. Is it on
Oh
there?
my God, we can't forget the anxiety disorder.
They didn't put that in there. I'm
He
sure he
don't got
has
no
anxiety.
anxiety. He's calm as a cucumber.
That's part of the OCD, I guess, maybe.
No, I don't have
You think
OCD,
he's
but I have it.
calm?
I am diagnosed with an anxiety disorder, but I'm not diagnosed with a compulsive disorder. Those are two different things. He's got ADHD, autism spectrum disorder, and he's obsessive compulsive disorder. You know, that's why he wears them gloves all the time.
Mm-hmm.
He cleans like he does. Clean freak. So am I. Getting my DNA out of my own house, that's going to be hard for you to do.
But I'm just saying, I'm surprised he doesn't have anxiety disorder too. No. It's weird.
He doesn't strike me. He's never talked about having too much anxiety, even in his TAPA talks. When I say that, I'm going by the TAPA talks, if they're real, which there's no reason. XR, I got a little sticky note right here. I've had
I
it for
think
a
they're real for
long
sure.
time. They're very fucking real, right?
Yeah, it's got
XR,
his birth date. It's the right era. Yeah, it's definitely.
the account is XR.those with visual snow, and it's Brian Koberger. And he talks about a lot of things in there, including his autoimmune, his visual snow, his dietary needs, his candida, all the things caused by autoimmune disease. And how do I know? Because I have autoimmune disease, like Karen Reed. I don't have the same one she has. We have a different one. He ain't got no anxiety, girl. His dude's cool as a cucumber. He's a Scorpio. Following those disclosures, you tell him the sky is blue. He's going to tell you it's purple, and you better believe him. That's how them Scorpios roll. I know them well. I got too many in my life. That's how they roll with Geminis anyway. Following those disclosures, the state provisionally I'm sorry. I got sidetracked on something. Retained a psychologist. Okay. Following those disclosures, the state provisionally retained a psychologist to conduct an examination of the defendant, and provided a report from the for rebuttal purposes. On March 31st, defendant timely disclosed penalty phase expert opinions by 5 mental health professionals. So on March 31st, the defendant did that. He timely disclosed penalty phase experts, from 5 different mental health. How many does it take? I bet they all can attest to a different type of behavior, including the 2 previously disclosed regarding his various mental behavioral health conditions. Did they leave out the one about his coordination? On April 2nd of 2025, the state initiated communications with the defense counsel about conducting the examination of a defendant pursuant to the law. I'm just going to call it the law. I'm going to rewrite their document. Defense counsel responded that same day, requesting the name of the experts, the nature of the testing, and whether there was any objection to the defense counsel being present. I have no problem with that, defense attorney. I need the name of your expert, the nature of your testing. I do need that as a defense attorney, and I would like to be present. I get that. The following day, state provided the information requested, including the proposed testing. Among the tests listed was an assessment of personality structure. What the hell, state of Idaho? You gonna do a what? What is that personality structure going to tell me that the state provides? If I'm the defense attorney, I'm fighting that. Can anybody have any idea of? I've never heard of that. Personality structure. The state also objected to defense counsel being present. What's it going to hurt?
Why were they objecting to that?
Oh, it's standard. I get it. But what's it going to hurt, right? It's going to save you headache later when they come back and say, well, we weren't present for the exam. We just heard that brought up in the Karen Reed case with the medical examiners stuff. So, yeah. these legal documents, man, they don't. There's a lot of them lately. A lot of the wording that comes out of them, I would see similar things in Ann's filings that I was seeing in Delphi. The next thing I know, I kept warning everybody, Koberger's going to lose the DP if they fucking, don't turn over their prosecution to ask Lori. And Taylor done went and cited her ass 4 times up in Brian Koberger documents.
I am surprised. Sorry, I'm reading ahead, and I'm surprised
ahead.
they didn't diagnose him with any other personality disorders, like antisocial
what?
personality disorder or something.
Well, all that's going to encompass some of that. Some of his autistic behaviors will encompass that, I believe. They can't give this guy too many things because they can't. First of all, Anne doesn't, wants the jury to be aware of his things, so they won't think he's odd, and then nobody else can bring it up after that. Only her during that one time. So go plant that seed in those jurors' heads. There's something wrong with your
I
guy.
can't wait till Dr. Vanna is on because I want to see what she thinks he could. I mean, okay, yeah, you can't, unless you are in person with somebody, you can't technically diagnose them. But I still want to know because she's, I'm sure, read the talks and it knows as much as we do. I wonder what
Oh
she
yeah.
thinks,
I still don't what is his personality structure? What would it tell you, and what could you present to that? Defense attorney's going to have a field day with that one.
She could probably explain that for us.
Well, I know. No, I want the judge to show me his ruling in the end. That's what I'm waiting.
Yeah, that's true.
Because what's his personality structure? Does that lend himself to be a killer? His personality is A, B, C, D, E, F, or G. You know what I'm saying? That's where my brain went. Personality structure.
Oh, okay. I Googled it and just
what does it say?
Says, oh, sorry.
No, go ahead. What's it say?
And it says the Big 5 personality test. And I don't know if this is what it means, but it's like there's 5 common dimensions: openness, consciousness, extroversion, agreeableness, and neuroticism. That's who's that guy? Dr. Grande. I don't know if you've ever watched him.
Todd.
He talks about that all the time.
Does
whenever he reviews somebody, he always gives the caveat, I cannot diagnose anybody without seeing them in person and all that. But he's like, he bases his decisions on all of those 5.
I haven't watched him in a long time.
I haven't either, but he's really fascinating.
Well, we'll have to look and get some interesting things he's dropped and maybe review them on a members only or something.
So remember that: openness, conscientiousness, extroversion, agreeableness, and neuroticism.
Extroversion, neuroticism. Good Lord.
I know.
They wanted to delve in. I wanted to take a journey into his mind. I did a year ago, and it was dark and scary, and I came out. Hadn't went back, but I'm interested in that personality structure. But as a defense attorney, now remember, we're all defense attorney team, defense attorney, and Karen Reed. If I'm a defense attorney in this case, I'm fighting that. I told y'all I can go to prosecutor. What y'all need? What y'all do? You need me prosecution today, or do you need defense? Which one we gonna do? I'm here for all of it. All right, I'm here for the law. I'm such a law junkie, an evidence freak. I love me some good evidence. Bring on them tire impressions. Let's get down. I want to know if those ones in front of King Road match any tire on that Elantra. And I'm not a fool. I understand he could have changed his tire between here and yonder. I get it. But if you did change your tire between Idaho and Pennsylvania, was it at a tire shop? Did you purchase said new tire with debit card so I can track it? Yeah, a lot of questions there.
But there's no tire change. Sorry, I get sidetracked on his Carfax, though, right?
Far as we know, the Carfax doesn't show that there was something about a tire change. I don't even know anymore with the Carfax report. I don't know really. We have the VIN number and all that. We've looked it all up, but I can't remember right now. If Dolphin was here, she could tell us. I think there was something about a tire change on there. But
maybe.
Okay, but that would tell you there's record of it then.
When he got to Pennsylvania in December, I think maybe he had a car change. He went to get some service done.
Okay, that's cool.
But anyways, I looked up another test, which is the Dark Triad personality test.
What?
It measures Dark Triad.
I'm
sure you've heard of that.
No.
It measures 3 traits of Machiavellism. I can't say it. Machiavellism. I can't say it. Narcissism and psychopathy. I'm like, oh, Dark Triad. That's like
what's it called again?
The Dark Triad.
Goodness, y'all, we got the dark triad has entered the freaking building.
Machiavellianism. There you go.
Have to look out what that means, Firefly. Okay, so they want to do a personality structure. The state also objected to the defense being present for the testing. Are they afraid that Koberger won't be as relaxed and natural for his testing if the defense is present? I don't know. Yeah, whatever. In response, defense counsel did not object to the evaluation. They shouldn't, but did object to any testing outside the scope of defendants' experts had conducted. And I agree. The state should be performing the same type of testing that the defense claims they did, right? Don't do extra testing. Unless you're telling me there's something wrong with this man, then we got a mental situation happening. And there goes your death penalty. So be careful, state of Idaho, with your personality structure. That's all I'm saying. Don't open the door to get the DP taken off. Don't be the fool. Jesus. Gotta go. What's their email? We'll tell them. She also asked the state to reconsider its position as to having counsel present during the exam. On April 7th, the state responded, indicating it would not remove personality testing from the proposed examination and would not agree to counsel being present during the exam, except through a video feed or otherwise having counsel shielded from defendant's view. Wow. Y'all think Ann's got that kind of pull over Koberger or vice versa? What's happening here?
I don't know.
She can watch via video to observe, or she can hide behind a shield so he can't see her. You know, those little partitioner things they put up in the room. So you know what I'm talking about. You're a nurse. They got them. Pull the curtain, right? Sit back there, Ann. We're going to pull the curtain, ma'am. Pull the curtain, y'all. Okay, I would agree to that. I would be like, okay, I'll come, just pull the curtain. She can still hear everything going on. That's weird. They're just so technical, aren't they? But they have to be, I guess. On April 11th, state's health expert informed counsel. This part I found odd. On April 11th, 2025, the state's mental health expert informed counsel he was not able to continue on the case. Did he get sick, family emergency, other obligations? I don't know. Approximately 1 week later, the state retained a replacement, doctor's name redacted until the state formally discloses the expert. Okay. They informed the defendant of the change had occurred. The state indicated it still needed to discuss the specifics of the examination with the new doctor, including his position on having counsel present. On April 22nd, the state alerted the defense via email that their new doctor believed personality testing was warranted and objected to counsel's presence. The state also sought a stipulation to extend the rebuttal disclosure deadline for purposes of disclosing the doctor's opinion. Defense counsel responded the same day, objecting to the deadline extension. To the extension to personality testing and to her exclusion from the room. On the 25th, the state filed the current motion. Good God. A lot of back and forth over this one item. Analysis. In its motion, the state seeks an order extending the deadline for its penalty phase rebuttal disclosures for 21 days following the completion of the state's expert exam. So the state wants their examination. What did he end up saying? Limited extension was granted or will be granted for rebuttal. Deadline is warranted. So he extends their deadline. Personality testing will not be allowed. Oh, Judge Hippler.
Wow.
I knew it. Let's see why. The state seeks leave to allow its expert to conduct personality tests on defendant during the examination to confirm, rebut, or otherwise contextualize the neuropsychological conditions diagnosed by defendant's experts, particularly the ASD. State argues there is no basis to limit its doctor's professional judgment as to the appropriate areas of exam and further. Defendant has opened the door by offering testimony about his lack of personality disorder. Offering testimony about his lack of. So he says he has a lack of personality disorder. The state contends it will not seek to utilize the results of the examination as rebuttal evidence in the penalty phase and will disclose all the results of the exam to the defendant. Defendant objects, arguing personality test exceeds the scope of proper rebuttal. And I'm not going to continue to read all that mess. Okay, so attaching to the mental condition he chooses to... Wait, what? The subject to which waiver applies is an issue of mental condition. In other words, the statute does not provide waiver of a defendant's entire mental condition. It only waives privileges attaching to the mental. Okay, I got you. Go down, because this is a long damn document. The state responded it is not proposing the personality test simply as a fishing expedition. Rather, he believes the test will aid in rebuttal for several reasons, as he explains. In my professional opinion, including broader testing of personality and psychopathology is important for several reasons. First, these tests contain the most sensitive symptom validity measures that help determine if the exam is reporting information in a consistent and reliable manner without significant over-reporting, exaggeration. Y'all scared coworker come in there and trick y'all. or under-reporting defensiveness. In her evaluation of defendant, it does not appear Dr. Rachel Orr administered any tests that formally evaluate symptom validity to this level. These validity measures help ensure that the results of other report measures that do not contain validity scales. Y'all aren't going to get there by you doing that. Personality structure test is not going to help you balance that.
No.
You get what they're saying?
Mm-hmm.
Second, not only is it important to rule in diagnosis, okay, let's get on down to the judge's decision. Y'all's arguments are about as dumb as that damn Google search. The Sixth Amendment does not require counsels present at the exam. Judge Hippler. I'm going to nerd out on you and your law knowledge. Your law knowledge. Finally, the state seeks to exclude defense counsel from its examination, asserting defendant has no Sixth Amendment right to the presence of counsel at the examination. It further argues exclusion of counsel is consistent with standard psychological practices in the American bar, standards on mental health, which advise the counsel should only be present if requested by the evaluator. So these okay, I get what's going on here. Redacted the defense. Okay, let me go down. What's his decision? What does you decide, Judge?
Yeah. Let's wrap it up here.
Sidebar from other reading. Order. Based on foregoing, state's motion for exam of defendant pursuant to Idaho Code for extension to complete rebuttal phase is granted in part and denied in part.
Okay. Compromise.
Compromise. Personality structure. I just need to be careful with that one. Because if prosecution were to bring that in and show he had a personality disorder during the penalty phase, that could remove the death penalty.
Yeah, and this is for penalty phase, right? Not the guilt phase.
Right. And they also think, though, that Coburger could be faking symptoms. And by performing these other tests, they can balance that to get an idea if that's true. Like
that is possible.
That's what they're talking about here. And that is why they don't want the defendant's counsel present to affect him during his testing. Do you know what I mean? So I do get that. Put her behind a curtain. She can still hear everything going on. You have to verbally communicate with the defendant to talk to him and ask him questions and conduct your test. So she can hear everything going on, or she can watch via video. I've got no issue with that either. But because you need to memorialize the process, right? I get it. So I don't have a problem with her watching it. I do kind of got a problem with this structural personality thing, though. That's weird. It's weird, y'all. All right, guys. Well, it's 3:30. We're gonna go over to Joe's later on this evening for that watching of the body cam video of the William Labredo situation over there and see if we can figure out what the heck happened over in Indianapolis to that man. Did he get in a bar fight, Joe? Was it a scuffle on the street? Did he get robbed? Was it Delphi related? I gotta know. So, yeah. Okay, guys. Well, I guess we're gonna meet back here in the morning
Okay.
for day 12. A dozen days.
It's already day 12. Wow.
Yeah, a
Yeah, I guess
dozen
it is.
days. And we have done moved through, and I'm going to say it like this because I made a boo boo somewhere. We have moved through, well, I got to add these two, 22 to 24 witnesses.
Wow.
I'll refine my list later. Yeah. And
What's
one
the
of those,
total? Like 80 something?
I don't even know the total. I didn't count them, girl. I was scared.
I know.
One of these has already been called back. Well, two. Jen McCabe's been called back again already. So she's done
True,
twice.
and Garino.
And Garino,
Twice.
right? Yep. He was the other guy that came back twice already. So,
Yep.
it'd
And
be
you know what? Higgins is going to be several days. I guarantee he's going to be 2 solid days, if not 3.
What all information is Higgins going to, all we've heard so far is,
I don't know. He was long last time. So, well, I
was
could
it,
be wrong.
because I haven't watched it. I didn't watch his yet on purpose. Because I've been looking at some of the other past testimonies recently just to kind of just gauge stuff here and there. I ran across his past testimony. I was like, nope, don't do it yet. Don't do it yet.
Yeah, because we got to go over what was he doing in the bar? What was he talking about with those guys? Why was he looking at John and laughing?
Why'd you tear up
What
your
did he say
phone?
to? What was your messages to Jen? And were you mad? Were you jealous? Were you
With his
what'd you
relationship
do with your
with
phone?
Karen.
Where were you that night? Where'd you park your?
Well, they were laying the foundation that he had a jealousy thing with John O'Keefe because of Karen Reed. And so at the bar that night, Higgins was getting upset because he was texting Karen Reed and she was ignoring him. Remember, we talked about that already.
Yeah.
So if
He's like, what about me, Karen?
they're alleging in this conspiracy, the Bryans consorted to lure John over there.
Yeah.
Right? Because I got to buy your theory. If you're selling it, I'm gonna talk about what you're telling me. It's not a secret. Shh. The conspiracy is not a secret. The cat's out of the bag. So I need to know what's your thoughts on Karen Reed, dude? You was the jealous guy that she was using to make John jealous. That's what was happening there, Higgins, and you know it. I'm gonna call it as I see it. You were being used to make John jealous. And you knew it, and it made you mad the night they came in the bar, and you text her and she ignored you.
Yep.
Was that a problem for you, Higgins? Y'all, I'm a good rabbit hole conspiracy theorist when I want to be.
She was ghosting him, and he said, no, it didn't bother me. Didn't bother me at all. Oh, sure, buddy. Yeah.
Nope, didn't bother me at all. No. Okay. All right, dude, whatever. It's going to be interesting. At what date did he so he removed a SIM card and destroyed a phone. So what date did that occur? Why did that occur? What prompted you to get a new phone? There's a lot of questions there. Was his phone ever taken for phone extractions? Did anybody ever interview him? Because he was at the scene that night. Something allegedly went down out there on the lawn. What time did you leave, sir? That's important. Did you see an SUV out front? Because that Jen McCabe lady says that she swears she saw your Jeep behind Karen Reed's SUV. Nagel doesn't see it, but Jen does. So I need to really pinpoint now, Mr. Higgins, what time did you leave that house? Oh, you don't got a phone no more? Damn it. Damn it, man. He got cloud coverage. Can we get that cloud data going? Did he use his Waze that night? Damn it.
Yeah, it should be good.
Yeah, girl. Okay. So can you join us again tomorrow? What's up with that?
Sure.
Sure. Okay. Yeah, my kid, we're not doing anything special today for his birthday. We were going to do it this weekend. Well, actually, Friday. I won't see them again when they leave Friday morning. They'll all be gone. I'll see them again on Saturday sometime. Um, I don't know where him and his girlfriend are going. They're going somewhere. Grandbaby's going to his nana's, so I might do a show Friday evening. I'm contemplating. Maybe we'll do because I'm going to be at Miss Shorty's on Saturday night, and we're going to look. I got you tiny and me big. I don't. That's weird. I just noticed that.
Oh, I didn't even notice.
I was like, oh look, that's not cool. I got Firefly all tiny. Y'all let me know next time I tiny her up like that. Not cool. Yeah, so anyway, I'll be at Shorty's on Saturday night. I do not know the time yet. What time she's going to do that show yet. I'll figure that out. And y'all just go keep an eye on Miss Shorty's channel. Get our notifications on. Go turn on Joe's. Turn on mine, please, for those of you that don't. And hit the thumbs up if you don't mind. We appreciate it. And thank you all for coming in and being a part of the conversation and this little community watching this trial together. Because there's literally thousands of people watching this trial. Thousands. And they're all watching on different platforms, the major network platforms and, the bigger YouTube channels and such. But so I really appreciate you guys choosing to come here to do it because I absolutely know you have a choice. And I never forget that. So I appreciate you guys who are here every day with us and sharing your thoughts on the case. Firefly, you've been invaluable. I've enjoyed having you up with me and our back and forth about the debating on the evidence and different things. It's good to do that because you know more. I'm coming in blind, and we're like da da da. So you guys, we do this. This is what we do. This is how we work stuff out in our heads. And again, we
I don't know if I know more, but whatever. I know.
No, I mean about the players' names and things.
Yeah,
Not recognize somebody. You can offer up what
little
you
more
think
familiar.
about.
Yeah.
I always appreciate your input, and Rachel's always got good insight into the case as well. So I always enjoy having her enjoy having her in the comments to clarify when we don't know something. So I appreciate all of you guys for being here. We'll have to put together a members only live soon. As soon as this Karen Reed calms down a little bit, maybe on a Saturday night or something, we can get together and do something and work on a cool show. I'm also working on another show for Sunday as well. All right, guys, I'm going to let you go. I'm going to do a couple things around here and get squared away so I can go there and hang out with Joe tonight. And I'll set the show up tonight. Be back in the morning around 7:40-ish. We'll get going.
All right, sounds good.
All right, guys. Everybody have a great evening. I'll see you
Thank you all
later.
for watching this here video. Please like and subscribe and follow. Much love from little Yas to each of you.